My lord, connected matter is
Before
on
all of
19th.
you tell, I will tell you. Yesterday, I think the association president or the secretary has complained that auto listing is not coming. And there's instructions from the Honorable Chief Justice, no fresh memo will be taken. So don't give any fresh memo. Because you have complained that auto listing is not coming, all right? Give all the pending matters.
Connected,
lord,
connected
for
matter
the
is on
fourth
19th.
time, my lord.
Give all the pending matters.
I
Connected
am
matter is on
moving-
ಏನು
19th.
ಮಾಡಕ್ಕಾಗಲ್ಲ
Fourth
madam.
time,
Fresh
my
matter
lord.
ಕೊಡ್ಲೇಬೇಡಿ. ಕೊಡಿ. ಕೊಡ್ಲೇಬೇಡಿ.
Connected matter, my lords, is on
Give
19th.
all pending matters.
19th, the connected matters are on
ಎಲ್ಲ
19th.
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಒಂದು ಫ್ರೆಶ್ ಮೆಮೊನು ಕೊಡ್ಬೇಡಿ.
ಅವತ್ತಿನ ದಿನ ಇದನ್ನ ಎರಡನ್ನು
ಒಂದೂ
ಕನೆಕ್ಟ್
ಕೊಡ್ಬೇಡಿ.
ಫ್ರೆಶ್ ಅಲ್ಲ ಸ್ವಾಮಿ ಇದು.
ಅವತ್
ಇದು ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಏನೆ.
ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಕೊಡಿ.
ಇದರಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿತ್ತು, ಬಟ್ ಇನ್ ಆರ್ಡರ್ ಶೀಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ರಿಫ್ಲೆಕ್ಟೆಡ್.
ಫ್ರೆಶ್ ಒಂದು ಕೊಡಬೇಡಿ.
My lord,
Please give all the pending matters.
my lord, fourth
See,
time I am moving,
You
my
had
lord,
to,
from
you
1
10
month.
times ಮಾಡಿ ತೊಂದರೆನೇ ಇಲ್ಲ. I was accommodating something. You have complained. So do it. Yes.
My lords, one respectful submission. My lords, one is
Date.
that
All fresh
on
matters. You won't, I won't take any fresh matter memo. It will come by auto listing by itself. Yes.
Settlement, my lord.
My taking memos is disturbing the auto listing, so I will not take. Yes. Give all the pending matters and settlement idre kodi.
Lord, settlement, end of the list, my lord.
Settlement whenever you want, give it.
My lord, mediation, my lord, matter may be referred to mediation.
Give it. No.
in this, my lords, ಇದು ಕನೆಕ್ಟ್
But
ಆಗ್ಬೇಕಾಗಿತ್ತು
even
ಮ್ಯಾಟರ್
after
ಇನ್ ದ
10
ಆರ್ಡರ್
days
ಶೀಟ್ ಇಟ್ ಇಸ್
also
ನಾಟ್
it's
ರಿಫ್ಲೆಕ್ಟೆಡ್.
fine, my
ಕೊಡ್ತೀರಾ
lord.
ಇಲ್ವಾ?
My lords,
ಅದು ಯಾವತ್ತಿದೆ ಅವತ್ತು ಬರುತ್ತೆ.
19th.
10 ದಿನ ಆದ್ರೂ
Yes,
ಪರವಾಗಿಲ್ಲ,
19th
ಒಂದ್
ಪರವಾಗಿಲ್ಲ
date
ಮೇಡಮ್, ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಫ್ರೆಶ್ ಮೇವು ಒಂದು
ತಗೊಳ್ಳಿ
ಕೊಡ್ಬೇಡಿ.
19th.
ಕೊಡ್ಲೇಬೇಡಿ. ಎಲ್ಲ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಅಲ್ಲಿ ಅದ್ರ ಪಾಡ್ಗೆ ಅದ್ ಬರುತ್ತೆ.
madam,
ಮಂಡೆಗೆ 250 300 ಹಾಕ್ಸಿದೀನಿ ಅಷ್ಟೇ. ಅದು ಇರೋ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಬರುತ್ತೆ. ಅದ್ ಬಿಟ್ರೆ ಇನ್ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಯು ಪ್ಲೀಸ್ ಆಸ್ಕ್ ಯುವರ್ whoever has complained.
Pending matter next week, at least.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ಅದು ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೀನಿಯಾರಿಟಿ ಓನ್ಲಿ.
Yes.
Pending my matter, my lords, I'm for the
Vacating
petitioner.
stay?
My lords,
Is it vacating stay?
no, my lords. Charge sheet has been filed under 376, my lords. 307 has not been invoked. Before my lords for further investigation, my lords. It may be heard, my
Further
lords.
investigation. Pending matter.
Pending matter, my
IT
lords.
come.
My lords, for vacating stay.
Vacating stay and pending matters, please give. ಕೊಡಿ ಸರ್. ಏನ್ ಪರವಾಗಿಲ್ಲ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರುತ್ತೆ ಕೊಡಿ. ಅದಿದ್ರೆ ಬರುತ್ತೆ ಕೊಡಿ.
For report, my
Give,
lords.
give all the pending matters. Give all the pending matters, sir. No 230. 230 ನೂ ಇಲ್ಲ, ನಾಳೆಗೂ ಇಲ್ಲ. ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
For the settlement, my lord.
Settlement, please give, sir.
Because pending
For
matter
settlement, madam.
pertaining to
Kindly have
director of
tomorrow, madam.
IMB.
Huh?
Director of IMB.
So what?
Pending matter.
So what? There is an interim order?
Yes, my lord.
One more, give it.
Thoughts of withdrawal.
It will come, give
ನಾಳೆ
it.
ಬರುತ್ತಲ್ಲ?
Lord, one matrimonial dispute, my lord. One of
madam,
the
ಬರಿಬೇಕಾ
petitioner, my lord,
pending ಅಂತ?
student,
Pending ಕೊಡಿ.
Lord, one of the petitioners is a student. She's not able to get her passport, my lord. Matrimonial dispute.
File an application for passport, I will take. I will take it.
My lords,
I am helpless.
it's a fresh
Can't
matter, my
help,
lords.
give it, Yes.
Notice is issued by executive magistrate against my dead father also, my lords.
So what? Give it, sir. Fresh matter, I am not taking at all. No memo.
Maybe consider it's
No
been,
memo.
it's been continuously
No
coming,
memo,
my
sir.
lords.
Seriously, no memo. Because you have complained,
No, my
saying
lords.
that auto listing is not coming because he's taking too many memos. I can't.
No, my lords. So far as urgency is
ನಮ್ಗ್
concerned, my lords, you
ನಮಗ್
have
ಗೊತ್ತಿಲ್ಲ,
kindly
sir.
consider, my
That
lords.
is the instruction that I have, that. no
Not
fresh-
about my move, about generally.
ಅಯ್ಯೋ, ನೀವು
about
1, 2, 3
urgency.
ಅಲ್ಲ. in
About
general.
urgencies,
No, sir.
kindly consider,
Nothing,
my lords.
Nothing, sir.
As a blanket,
Nothing.
will really hurt the bar,
You
my
ask,
lords.
you ask the
Please,
office
please, my
of the
lords.
association.
We will
Why
look
did
at.
they complain?
So far as urgency is concerned, my lords, you have been kind
ಗೊತ್ತಿಲ್ಲ.
enough to really
No,
consider,
sir.
because that's going to really
No,
adverse.
sir.
Please,
I
my
will
lords.
not, sir. Fresh memo ಒಂದು ಕೊಡ್ಬೇಡಿ.
My lords,
No, I am helpless, I
urgency,
told you.
please,
No, sir.
please, my lords, we will,
No, sir. No.
because it's, you have been always accommodating and
Correct,
then,
sir. ಅದಕ್ಕೆ why did
so
you
far
come?
as, so
Why
far
did
as
you
the
come? Why
seniority
did
is
you
concerned, my
complain,
lords,
sir?
there is an
One minute,
issue.
sir. Why did
Yes.
you complain?
So far as seniority is concerned, my lords, there is a challenge that it has not been managed properly.
That-
We'll also just cooperate with the,
That also I will rectify.
yes, my lords.
I will rectify. I need cooperation from all of you. I will
Yes,
rectify
yes, my
everything.
lords, yes, my lords,
But
we are obliged, yes, my lords.
Beyond this, I cannot work, sir. Beyond what I am doing, I really
My lords,
cannot
we
work.
bow our heads
So,
and then we know what,
yeah, if you
what
have-
this court is doing for us. We are helping, we are being helped, yes, my lords.
If you have to complain, you should think and complain.
Yes, my lord. We'll,
Right? Now that you have done it, no fresh memos here afterwards, only auto listing.
my lords,
No, sir.
kindly,
Yes.
your,
No, sir.
Your
Hey,
kind
what-
consideration is
then I will-
required
then-
because
no, no,
fresh
no,
matters,
one minute, sir.
urgency, my lords.
Then I
On
will.
based on urgency, just like what you are doing earlier.
Oh, sir, that
if
can't be done.
based on the submission, you can
Only
just,
auto listing.
my lords,
No,
please, my lords, because sometimes 230 matters, arrests and all these things.
ಏನ್ ಮಾಡಕ?
My lords,
ನಾನೇನ್ ಮಾಡಕ?
still, my lords.
ನಾನೇನ್ ಮಾಡಕ?
One
You
is
ask-
auto listing will come,
No
only the
problem.
system so far
Sir.
as the seniority is concerned, my lords may kindly consider that, my lords. Please, my lords. No, I have to really check, my lords, because I'm not, I will just. ಹೌದು ಸ್ವಾಮಿ, ಹೌದು ಸ್ವಾಮಿ, ಖಂಡಿತ ಸ್ವಾಮಿ, ಎರಡು ಡೌಟ್ ಇಲ್ಲ, ಪ್ಲೀಸ್, ನೋ ಕೋರ್ಟ್ ಯುವರ್ ಮೈ ಲಾರ್ಡ್ಸ್. My lords, the entire bar is happy so far as the, my lords, we are extremely, I'll definitely see, please, my lords, as in, please, my lords, so far as the urgency is concerned, my lords, kindly, we'll just look into, my lords. Seniority, yes, there is a procedure which is required because twice, thrice memos are being, yes, my lords. Yes, my lords. No, my lords, please, we kindly pardon us. I'll just look into, my lords. So far as urgency is concerned, total ban, kindly request you. Yes, my lords, I will look into, my lords, much more. Yes, my lords.
My lord,
One
one
matter,
small
my lord.
submission, my lord.
Respondent
One
police are
small
threatening
submission.
to cancel the bail, my lord. Though I am, auto listing ಏನಾಗಿದೆ, after hearing my lord directed the petitioner to cooperate with the respondent. Despite now the respondent police is seeking me to produce the original signed copy, but therefore my lord is threatening to therefore. Tomorrow. ಅಲ್ಲ ಇದೇನಾಗುತ್ತೆ, ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್, ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್. ಅಲ್ಲ 6 ಜನ ಇದ್ದಾರೆ, 6 ಜನ
My lord, this is a pending matter. My lord, in this matter, the one small submission, my lord. In this matter, the victim's brother is the complainant. He has colluded with the accused and they've reported settlement, my lord. We have filed an application for recalling of that order. Yeah. My lord, but I request that the matter be heard next week, my lord.
My lord, it's a fresh matter, my lord. My lord, already 3 times I have moved them, I have moved the memo, but it was.
Pending, ಸ್ವಾಮಿ.
ಅಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ತಾವು ಅದಕ್ಕೆಲ್ಲ ಅಲ್ಲಲ್ಲ ಅಷ್ಟು ಸಣ್ಣ ವಿಚಾರಕ್ಕೆಲ್ಲ ತಾವು ದಯವಿಟ್ಟು ಬೇಜಾರು ಮಾಡ್ಕೋಬೇಡಿ. ಅಲ್ಲಲ್ಲ ಹಾಗೆ ಮಾಡಿದ್ರೆ ಯಾರೋ ಒಬ್ರಿಬ್ರು ಮಾಡೋದಕ್ಕೆ ತಾವು ಯಾರು ತಮ್ಗೆ ಆತರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡಕ್ ಆಗಲ್ಲ. ದಯವಿಟ್ಟು ತಾವು ಆತರ ಅಷ್ಟು ಅಲ್ಲಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಅದನ್ನ ಯಾರೋ ಒಬ್ರು ಇಬ್ರು ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿ ತಾವು ಅದನ್ನ ಆತರ ಒಂದು ಫಾಲೋ ಮಾಡ್ತಾ ಇದ್ದ ಪ್ರೊಸೀಜರ್ ಅನ್ನ ದಯವಿಟ್ಟು ಡಿಸ್ಕಂಟಿನ್ಯೂ ಮಾಡಬೇಡಿ. ಅಲ್ಲ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡೋದು ಅಂತಂದ್ರೆ ಈಗ ಏನು ಒಂದು ಅದು ಎಲ್ಲ ತಮಗೂ ಗೊತ್ತಿದೆ, ತಾವು ಬಾರಲ್ಲಿ ಇದ್ದವರು, ತಮಗೂ ಗೊತ್ತಿದೆ. ಎಲ್ರು ಒಂದೇ ರೀತಿ ಇರಲ್ಲ. ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಈಗ ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ಲ. ತಾವು ಅದಕ್ಕೆಲ್ಲ ಬೇಜಾರ್ ಮಾಡ್ಕೋಬಾರ್ದು. ಯಾರೋ ಒಂದಿಬ್ರು ಎಲ್ಲಾ ಸಂದರ್ಭಗಳಲ್ಲೂ ಎಲ್ರು ಒಂದೇ ರೀತಿ ಇರಲ್ಲ. ಅಲ್ಲಲ್ಲ ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಎಲ್ರು ಒಂದೇ ರೀತಿ ಇರಲ್ಲ. ತಾವು ಅದಕ್ಕೋಸ್ಕರ ಬೇಜಾರ್ ಮಾಡ್ಕೊಂಡು ಮೆಮೊನೆ ತಗೊಳ್ಳದೆ ಇದ್ರೆ ಬೇರೆ ಎಲ್ಲ ಜೆನ್ವಿನ್ ಆಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋರಿಗೂ ತೊಂದರೆ ಆಗತ್ತೆ. ಲೈಕ್ ಕೆಲವು ಸಂದರ್ಭಗಳಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು
ರೀಚ್ ಆಗಿಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು
25 ಮ್ಯಾಟ್ರು ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಬರತ್ತೆ.
ಅಲ್ಲ 25 ಅಲ್ಲಿ ಹಾಕಿರೋದು ಬಂದೇ ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಇಲ್ಲ, ಕೆಲವು ಸಂದರ್ಭಗಳಲ್ಲಿ ಏನಾಗತ್ತೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅಲ್ಲಲ್ಲ, ಅದು ಕರೆಕ್ಟ್. ತಾವು 600 ನಡೆಸಿದವ್ರು, 600 800 ಮ್ಯಾಟ್ರ್ ತಗೊಂಡವ್ರು. ನಾವು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಯಾವತ್ತೂ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ, ಅಥವಾ ಈ ಕೋರ್ಟ್ ಮೇಲೆ ಯಾರಿಗೂ ಕಂಪ್ಲೇಂಟು ಇಲ್ಲ, ಗ್ರೀವಿಯನ್ಸು ಇಲ್ಲ.
Very well. Well, I can say this, my lord, that there are some other courts have.
The petitioner is the owner of land measuring 20 quintas in survey number 87.2.
The proceedings in so and so, registered for offence punishable under
126.
so and so. A perusal at the complaint so registered by the second respondent would clearly indicate that a purely civil case is dressed with a color of crime and the criminal law is set into motion. In that light, there shall be an interim order of stay of all investigation qua these petitioners till the next date of hearing. One additional SPP, 2 emergent notice.
Job like.
ವಾಪಸ್ ಇದು records ವಾಪಸ್ ಕೊಡಿ.
This is the matter which my lords had asked us to find out whether any
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
compensation was given. So far as this logistic firm is concerned, my lords, accused 1 and 2 and the deceased who they belong, I am given to understand the logistic firm has not made any payment, but the claim has been done against the insurance for the compensation amount. That they have done, but so far as we are concerned, my lords, we are 3 and 4, we have nothing to do with that logistic firm. So far as we are concerned, could I just make one request, my lords? We will serve respondent number 2, my lords, because let them come before the court. Let us see, my lord, so far as we are concerned, they have no grievance against us at all. It happened in my premises, that's all. And employees, not even the company. 3
That's
and
what-
4 are employees.
No, it happened in your premises.
And they're employees, my
A
lord.
moral responsibility, sir, nothing else.
I understand that, my lords. Probably we will emergent notice to the hand summons to R2, my lords.
Will do.
So if they come here, let us see if, so far as we are concerned, something that we are in a position to do for them.
I am only on the score that it has happened in your premises. Under the Factories Act, if proceedings are instituted, it would be the owner of the premises.
Yes, my lords,
not
here,
not you two.
these are 2
No,
employees
not
there.
you two. Employees ತೊಂದ್ರೆ ಇಲ್ಲ. If I observe that the owner of the premises is responsible, then Factories Act 92 will straight away
ಹೌದು,
spring.
ಅದು correct.
ಆವಾಗ ಬರುತ್ತೆ ದುಡ್ಡು ಆಚೆ ಎಲ್ಲ.
My lords, here what happened is how we got implicated was the father, when he gave a complaint, my lords, he was under the impression it was under our supervision anta. That's how complaint was given. But after investigation, very clearly in the charge sheet, they say A2, my lords, who is from the logistic firms, he instructed A1 to back that truck. And that hit into the deceased who was working under them, very clearly in the charge sheet. So in the charge sheet, my lords, virtually we should have been exonerated, but they just array us as accused 3 and 4. This is what is
No
happening.
problem. I will take it on Monday. Monday ಅಲ್ಲ. We'll take it on Thursday. What's the state now?
Now, my lords.
Bail ತಗೊಂಡಿದ್ದೀರಾ?
My lords, it's await summons. It's await summons.
So you're on bail, right?
I'm on bail.
Then no problem. Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. The learned counsel, this court on 6/2/2026 had passed the following order. Therefore, hearing of the complainant would become necessary. Lest the complainant be served by way of hand summons by the petitioners. The list the matter on 20th.
20th.
List the
Please,
matter on
madam.
20th.
We'll try,
In
my
the-
lords, we'll try to serve them, let them.
No, in the fresh matters list.
In the fresh.
Yes.
Number 3. Lords, appear for the respondent number 2, my lord.
That's my case.
The petition matter had reached before the court tomorrow, yesterday, and it is posted today.
All right.
My lords.
They have come and they have filed an application under 482, where there is
no section or where there is no law which permits the factor complaint to appear
Yes.
and is paid bail.
It's for the court to.
That is for the court to decide, my lords, in that petition, my lords.
They submit the Supreme Court citation, so it will take.
That's all right. It is for the court to consider.
My lords, this matter may be taken up tomorrow, my lords.
No problem. We'll
My
take it Friday.
Grateful, my lords.
Friday, Burley. Oh,
Newly married, I have taken.
you are newly married. Don't disturb him, madam. Yes.
Another case.
You're going to Tirupati? All right. Fine, no problem. List the matter on Tuesday in the fresh matters list.
Grateful.
Number 4.
This
ಏನ್
matter,
theft JC ಇದಾರ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಬಾಡಿ ಈಸ್ ಅನ್ ಬಾಡಿ ವಾರಂಟ್ ಅಂಡ್ ಬಾಡಿ ವಾರಂಟ್
Body warrant is 2-3 years in the has been in
thereafter
JC.
thereafter he seems to have released and then NBW is pending against him in connection with this case. He is in connection with in prison, my lord, in connection with special CC 323 of 2025. That's an NDPS case. In this case only NBW is pending against him.
ಅದರಲ್ಲಿ your honor, the order is being issued to produce the accused.
NBW ಒಳಗಡೆನೆ ಇದಾರ ಆಲ್ರೆಡಿ.
ಅದೇ ನಮ್ಮವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಮಾಡಲಿಲ್ಲ. ಬಟ್ anyway ಈ ಕೇಸ್ ನಲ್ಲಿ there is nothing because
ಅಲ್ಲ NBW ಸ್ಟೇ ಮಾಡೋಣ ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಮಾಡೋದು? Already is in custody. Where is the question of NBW operating?
NBW, it's our lacks that we should have, knowing very well that is inside prison and our officers are not executing. It's our
What is all
mistake.
this? ಸುಮ್ನೆ ಒಂದು litigation ಅದಕ್ಕೆ.
My lord, to be tagged with 305 your honor, to take up this tomorrow your honor.
305 ಆ?
ಇನ್ನೊಂದು ಇದೆ ಸ್ವಾಮಿ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್, ಅದು ಇನ್ನೊಂದು ಸ್ಪೆಷಲ್
Serial number ಅಲ್ಲ petition number 305 ಆ?
ಹೌದು ಸ್ವಾಮಿ.
ಸರಿ. Petition number 305
And
20th.
ಇಲ್ಲ ಸ್ವಾಮಿ tomorrow.
Tomorrow why?
ಅಲ್ಲ ಸ್ವಾಮಿ, because he is in JC my lord. ಅದರಲ್ಲಿ 305 ಅಲ್ಲಿ your honor,
JC ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇದಾರಲ್ಲ ಆಲ್ರೆಡಿ.
your honor 5 years in the he is in JC, he is not produced before through either VC or personally your honor.
My instructions, my lord, last date of production.
At least one date ali he is not produced.
Last
5
date of-
years in the song. Please your honor.
Last date of production before the court is on 22.
ಅಲ್ಲ ಒಂದಿನೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಒಂದಿನೂ
JC
produce
Well,
ಮಾಡಿಲ್ಲ.
my instruction is last date of production is on 22/9/2025. So thereafter custody was
The
extended.
learned additional SPP to secure instructions with regard to the dates of production of the petitioner as he is on body warrant in custody.
Connected matter.
ಅಲ್ಲ, body warrant in a connected case in custody for the last 3 years. List the matter on ಯಾವತ್ತು ಹಾಕೋಣ? 2 days?
ನಾಳೆ ಇರ್ಲಿ ಸ್ವಾಮಿ.
ನಾಡಿದ್ದು ಬರ್ಲಿ. ನಾಳೆ ಒಂದಿನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳಕ್ ಬರ್ಲಿ. ಇಷ್ಟು ದಿನ ಸುಮ್ಮನೆ ಇದ್ದೀರಾ? Yes, day after tomorrow.
Oblige.
Tag along with 305 of
5 to 26.
2026. Writ petition, criminal petition?
Criminal petition.
Criminal petition, yes. Next.
5.
The petitioner is before this court calling in question registration of a crime in crime number 755 of 2025 registered for offences punishable under 318, 319, 336 and 61(2) of the BNS. A proceeding which ought to have been before the competent civil court is now before the competent criminal court by giving it a color of crime. It is purely a civil dispute which cannot be permitted to be continued before the criminal courts. In that light, there shall be an interim order of stay of further proceedings, further investigation by the petitioner till the next date of hearing. 1 additional SPP, 2 emergent notice. Next.
Kindly by hand your
By hand ಯಾಕೆ ಸರ್?
ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಂಡು ಹೋಗ್ಲಿ.
ಪರವಾಗಿಲ್ಲ.
ಲೇಟ್ ಆಗ್ತದೆ ಅದು.
ಮೆಮೊ ಕೊಡ್ಬೇಕು. ಎಲ್ಲಿದೆ ಮೆಮೊ?
ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. Please.
138.
This is a matter which came before your lordships day before yesterday.
Oh, yes, sir.
We brought it to your lordships notice, my lord, that there is a reference to the reply notice which is issued.
Correct. I have one clarification, sir. Is this a partnership firm?
No,
LLP na?
lords, the complainant is an individual.
The complainant individual, the accused are parts of the partnership firm?
Yes, it's a LLP and there are 2 partners. Lords, the question is not that which I am raising. Lords, the reply notice was sent saying that from out of 95 lakh rupees, which is the check amount, the entire amount 96 lakhs and odd has already been paid.
ಅಧ್ಯಕ್ಷರಿದ್ದಾರೆ ಇಲ್ಲಿ.
ಅದೇ
ವಿವೇಕ್ ರೆಡ್ಡಿ ಸರ್.
ಅಧ್ಯಕ್ಷರೇ ಬನ್ನಿ.
ಕೇಸ್ ಇದೆಯಾ?
20.
ಮ್ಯಾಟರ್ ಇದೆಯಾ?
20.
ಅಲ್ಲ ಅಲ್ಲಿ ಬೇರೆ ಮ್ಯಾಟರ್ ಇದೆಯಾ? ಅದು ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
ನಾವು 1:30ಗೆ ಬರ್ತೀವಿ.
ಅದೇ ನಾವು ಮಾತಾಡಿದ್ವಿ ಹೊರಗಡೆ ಬರ್ತೀವಿ.
ಕಮಿಟಿ just to ease out, to help your lordship so that lot of youngsters, Papa.
ಎಲ್ಲದನ್ನು ಸಾಲ್ವ್ ನಾನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಡೂ ಸಮಥಿಂಗ್.
Lords, the complainant is an individual. Accused is an LLP who has purchased the property from the complainant. The complainant presents the checks are bounced, he issues a notice. We sent a reply saying that the amounts has already been paid. Whatever is due under the check has already been paid. That is a reply notice. Now, it is the complaint is presented through the power of attorney holder. The complaint does not make any statement.
No, your submission was it is contrary to AC Narayanan.
That's all. Even now I am making the same statement. The power of attorney holder in the complaint does not indicate that he is aware of the transaction as such. Not in the context of the reply which I have already given, if he does not have the personal knowledge, he cannot come and pursue these proceedings. That is AC Narayan's case.
One moment. Now, transaction between whom?
Lords, between the complainant and the LLP is in the nature of a sale deed.
That's a sale deed. Now, who is the GPA holder?
Son of the
Lords, GPA holder.
Son, and he is also a party in the sale deed.
All right, yes. Amala.
GPA holder. Now, GPA holder, when he wants to participate in this proceeding, saying whether or not, because all the checks are in the name of the complainant only. Now, statement is required to be made in terms of AC Narayan case, that is para 33, where it clearly says it is necessary that he should make an averment in the complaint that he is personally aware of these facts as to whether or not. Now, more particularly in the context of the reply, which he himself makes it as a part of the complaint, that the entire amount stands paid. He has to make a statement. Either in the complaint.
Entire amount pay madidara.
88. Lords, can I just persuade your lords?
What is the consideration, sir?
Lords, the consideration, your lords is what to
3
see.
crores 89,65,000.
Lords, 89,65,000.
All right.
The value of the check, which is subject matter, my lords, of this is 96 lakhs. 91,65,000 is the value of the checks. Now, if your lords is to kindly have a look at the memo which was given, my lords, on the previous hearing date, 9/2/2026. Lords, in that document number 1. Lords, there are the references of payments 15 lakhs, 15 lakhs, 15 lakhs, 15 lakhs, 13 lakhs, and another 15 lakhs.
All right.
So,
totally ಎಷ್ಟಾಗಿದೆ?
88 lakhs.
ಚೆಕ್ ಅಲ್ಲಿ ಪೇ ಮಾಡಿರೋದ?
These are all the account payment. This is account extract.
ಅಲ್ಲ RTGS ಮಾಡಿರೋದ ಇದು?
Yes.
So this is received by them?
Lords, these are all the payments which are made in the name of various persons with whom there are transactions pertaining to this very property. We had to settle that. As a part of this consideration, we had to pay that. That we have paid it. 88 lakhs is the amount which has already been paid.
What is the disputed instrument before the court?
Lords, disputed instrument before the court are the checks which are referred to in the sale deed as the dues which are required to be paid. Now, after the sale deed is executed, these payments have already been made. 88 lakh rupees payment is made.
No, the consideration in the sale deed has not yet passed.
It is now passed.
When? With
Lord,
these
that's
checks.
what I said. From
With these checks.
Under these checks.
Did the sale deed say that you have to pay it to XYZ?
It doesn't say so. It doesn't say
Then
so.
what?
But that is the reason why I said, if a power of attorney wants to present the complaint, can I just persuade your lordships to kindly have a look at AC Narayan's case?
Yes, sir. No problem. ಇಲ್ಲ ಇದೆ.
Lords, 33.3. It is required by the complainant to make a specific assertion as to the knowledge of the power of attorney holder in the transaction explicitly in the complaint, and the power of attorney holder who has no knowledge of regarding the transactions cannot be examined as a witness in the case. Now, complaint should contain an averment. That's the only requirement. If your lords is to see the contents of the complaint. At Annexure A, page 21. G. Manjula, represented by SPO holder S. Manohar. Lords, in the entire course of the complaint, without any fear of contradiction, I would make a statement that there is no reference to the role played either by the power of attorney holder in the transaction or the knowledge which he has pertaining to what has been stated at paragraph number 14 of the complaint at page 26.
Correct.
Lords, in the absence of this statement being made, this complaint cannot be, because ultimately, my lords, if a person wants to come before the court and say whether these payments, whatever has been referred to in my reply notice is,
I am the power of attorney holder, I am aware of
Lord, in the-
mandatory phrases.
My lord, in the sworn statement, my lord, I've stated so.
Where is this one statement?
My lord, I have a copy of it, my lord, paragraph
Kodi.
2. My lord, even otherwise, here, my lord, the.
Alla, wait, mostly.
I tell
Yes. Ravi Shankar sir.
Lordships. And paragraph number 2 is the sole and absolute owner of the property. Lordships, may kindly have a look at that statement. Lords, other than stating, my lords, in the beginning, I submit that I am the special power of attorney holder for the complainant in the above case, and I am well aware of the facts of the case, and hence I am competent to swear. In the remaining portions of the entire sworn statement, he doesn't say what is his involvement, how does he have the knowledge of this transaction. Nothing is stated. My lords, now the threshold is that he should state in the complaint. Lords, I can understand in a simple case where there is a check presented, check is bounced, notice issued, nothing is there, there is a presentation. Now, this is a case where there is a clear statement made in the reply notice saying that 88 lakh rupees has already been paid. Lords, for that they have to make a statement, and a person who is aware of these facts alone has to make the statement. So therefore, my lords, my respectful submission, my lords, is if your lords were to see, they have also filed a civil suit. OS number 5 of 2025.
Same cause of action. Recovery of
Same
money.
cause of action.
Recovery of money.
Recovery.
Page.
Lords, page number 84. There, of course, it is not through the power of attorney holder.
ಅಲ್ಲಿ ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
Cancel the sale deed in the alternative recovery.
I'll get back. Yes. Sale deed cancellation ಕೇಳಿದ್ದೀರಾ?
ಇಲ್ಲ. ಆಲ್ಟರ್ನೇಟ್ ಪ್ರೇಯರ್ ಕೇಳಿದರೆ ಪ್ರತಿವಾದಿಗಳು ಬರಬೇಕಾದ ಸೋನ್ಸುಗಳನ್ನು ರಾಷ್ಟ್ರೀಕೃತ ಬ್ಯಾಂಕ್ಗಳಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಬಡ್ಡಿ ಬರದಂತೆ ಬಡ್ಡಿ ಸಮೇತ ಹಣವನ್ನು ಮರುಪಾವತಿಸಬೇಕು. ಒಂದು ವೇಳೆ ಕೊಡಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅವಾಗ ಸೇಲ್ ಡೀಡ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
In the alternative amount alla. In the alternative sale deed cancellation. Yes, sir.
Lord, your lords may kindly look into the complaint, my lord. Page 23. The complainant submits that the sale deed was executed by the complainant and her family members. Page paragraph 4, my lord. The complainant submits that the sale deed was executed by the complainant and her family members on 14.
Now where is the sale deed?
My lord, annexure L.
Page
48.
Who are the?
My lord,
Manohar is a party here.
Manohar is a party. He is the son of Manjula, my lord, who is the complainant herein. He is well aware about the entire transaction which has taken place.
Alright.
Now, my lord, therefore, he has given a complaint. Now, as far as the suit is concerned, my lord, your lordships have held that it will not bar, my lord, in my lord, in criminal petition 331 of 2022.
Copy. ಏನದು?
Criminal petition 331 of 2022. Your lordships have held that, my lord, that can.
2022 li.
Yes. My lord, relying on the judgment of the Supreme Court, my lord, your lordships have held. In my lord, the Lalaji Keshav Vaid case.
ಯಾವ್ದು ಇಸ್ಕೊಡ್ರಿ?
Yes.
And my lord, in the sworn statement, my lord, I have made a statement.
Now the learned senior counsel is only on this point, that you are not aware of the transaction. You have not averred that you are aware of the transaction.
I am not aware.
Averment, Allah. Averment of awareness is important.
My lord, averment, in that case, my lord, the Supreme Court says, because in that case, the general power of attorney was not aware about the facts of the case. Here, my lord, the facts are slightly different. Where, my lord, the sale deed is there, in that, my lord, I am a party.
All right, we'll consider it. Anything else, Savi sir?
Lord, the other contention, my lord, says that LLP is the first accused. Two of the directors are made as two of the partners are made as the accused.
Partners.
Now, in the complaint, there is no reference to the fact that
role of each of the partners.
Role of each of the partners is not mentioned.
That is
Lords,
not required, my lord.
KK Ahuja's case, my lords, I will just para 27 KK Ahuja's case, which in fact refers to SMS Pharma case. para 27, my lords. At page 61, para 26 of Ahuja's case and para 27. The position under section 141 can be summarized. We are referring to 1. Even if he is a managing director, does not mean that he should be in charge of the concerned transaction, and it is necessary for them to aware. 27, 1.
This is Ravi Shankar, company.
Lords, this is, my lords, LLP is also a corporate entity, my lords.
It's limited liability
Lords,
partnership.
no, it's a corporate entity, my lords, under section 3 of the LLP Act. So far as
Both these judgments that you're saying are distinguished Dana Singh.
Lords, that's true, my lords. The reason why the other judgment, my lords, which I wanted to rely upon.
And yesterday I have written and released one saying one partner is equally liable for the other partner. It is unlike a company where the directors have a specific
There is
role
a
to play.
distinction, my lords, when it comes to the question of LLP under partnership.
That
there is a
we'll see,
distinction.
we'll answer it. Whether
Because
LLP stands on a different footing.
Yes, LLP, my lords, is a body corporate. My lords, the reason why this intermediate entity was brought into existence.
Para 53.
The reported judgment. Yes.
There was an intermediate, my lords, entity which was brought into existence in the nature of LLP is because under the partnership, every act of the partner could bind the other partners as part of the firm.
No, that's why does LLP make a distinction? We will see.
But section 3, my lords, lords, may kindly have a look at section 3 of the LLP Act. It's a body corporate.
See,
Similar to the language employed.
What Supreme Court says in Dana Singh is interpreting Partnership Act.
That's the reason
All
why I
right.
said.
If it is an
Act.
LLP, then we'll see.
Lords, may kindly see the LLP Act, my lords.
Kodi. Idre kodi ilva. Adu limited liability, nam court limited availability. Yes.
Section 3. Similar to section 5, my lords, of the 1956 Act, section 6 of the 2013 Act.
Yes.
Section 3 is a body corporate, as distinguished from a partnership firm, which is not a body corporate.
No, this issue has not cropped up anywhere.
Lords, there are several judgments on the fact that, lords, only on the question, not qua section 138.
That's
but
what.
Section 3 has been interpreted in any number of judgments which says that
Section
LLP is a
3
body corporate.
No, section 3 may have borne interpretation. Is it?
That I will ascertain, lords, if there is any interpretation which has been undertaken with reference to section 138 and section 3 and 141 of the negotiable
This
instruments.
requires an answer.
I understand. Yes. We'll get the answer.
Yes. No, I'll give you the answer.
Very well, my lords.
I'll
I
reserve
leave it
it.
at that.
Yes.
Lords, the only statement which I want to make is
Yes.
the distinction between a partnership and the LLP is partnership specifically provides a partial body corporateness. In the sense, any property of a partnership firm under section 13 and section 17 of the part, only to the extent of the holdings, it is vested with a partnership firm. But it is not a body corporate, because the liability is unlimited. The entire liability of the entire firm can be proceeded only against one of the partners. This is the manner. But so far as LLP is concerned, section 3 says a limited liability partnership is a body corporate formed and incorporated under this act and is a legal entity separate from its partners. That's
So
the
this
reason.
requires an answer. We'll definitely answer.
Because if your lords were to see the pari-materia provisions under the Companies Act, it's exactly the same, particularly section 5 of 1956 Act, which has come up for interpretation, my lords, after the
No, see, 1956 Act has borne interpretation in plethora of cases.
But even with reference to section 141, there are judgments of the Supreme Court which specifically said that when
LLP?
it's a body corporate.
LLP.
No, body corporate.
Body is.
Lords,
We'll see.
Lords, it is simple, my lords.
No, we'll-
Either it's a body corporate or not a body corporate.
It requires interpretation. We'll do it. Yes.
Very well, my lords.
What's the next date there?
March 1st week.
March?
March 1st week.
All right.
March, my lord, 11/3/2026.
11/3. Heard the learned senior counsel for the D.R. Ravi Shankar appearing for the petitioner and counsel Bipin Hegde representing the respondent. Heard reserved. Before that, we will deliver it.
Very well, my lords.
Because this will clear the air.
If there is anything, my lords, which we
You
come
can
across,
always give
we
it.
will.
Yes. New Ashta, you can give it. Yes.
Seven.
Intermodal ಇದೆಯಲ್ಲ?
Take my lords. Please, my lords.
Interim order untalla. Objections ಹಾಕಿದೀರಾ?
Objections I have filed, my lords,
Oh,
and on the
so
previous
spashed.
occasion, my lords.
Ah.
On the previous occasion, my lord was pleased to grant interim stay with respect to the further investigation
Yes, madam.
of the crime. My lords, I would like to submit a few points, my lords. In my statement of objection itself, at point number 10. I
Point
have
number
stated-
10.
Please, my lord.
Your objection is point wise. 1 minute. Point number 10 ಎಲ್ಲಿದೆ? One moment.
I have stated
Yes, madam.
that it is submitted that based on the complaint given by so and so, appropriate legal action against.
ಎಲ್ಲಿ point number 10 ಎಲ್ಲಿದೆ madam?
At page number 6, my lords.
10 ಇಲ್ಲ. 5 ಅಲ್ಲಿ ಇದೆ 10.
Para 10.
Please,
Yes, madam.
it is submitted that based on the complaint given requesting appropriate legal action against Dr. Kalhadka Prabhakar Bhatt for delivering hate speech and also against the YouTube channel Vikasana TV and the organizers of the program who broadcast the
The
speech.
procedure follow ಮಾಡಿಲ್ಲ madam.
Please, my lord.
Procedure by the apex court in Satyendra Kumar Antil is not
My lords,
followed.
we have followed the
There is
procedure.
no-
We have issued.
35 notice ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ. 35
Reply
notice.
ತಗೊಂಡಿದ್ದೀರಾ?
35 notice ಕೊಟ್ಟಿದ್ದೀವಿ dated.
Page ಮಾಡಿ. ಎಲ್ಲಿದೆ ಎಲ್ಲ notice ಎಲ್ಲ?
Dated 22/1/2026, we have issued notice. And on 27/1/2026, he has appeared before the concerned police station and he has given his voice samples that has been sent to FSL, my lords.
Voice sample ತಗೊಂಡ್ರಾ?
ಆಮೇಲೆ
ತಗೊಂಡಿದ್ದೀವಿ.
what happened is, my lord, the petition was filed and there is only no coercive action. That was
ಅವಾಗ ತಗೊಂಡಿರೋದು?
ಅವಾಗ ತಗೊಂಡಿದ್ದು. ಅವಾಗ ಅಪಿಯರ್ ಆಗಿ
35 ಯಾವಾಗ ಕೊಟ್ರು ನಿಮ್ಗೆ?
Notice, my lord, it is not served, my lord. It was pasted in
My
in
lords,
front of
as
my
we
house
tried number
subsequently.
And we have affixed the notice to his wall, my lords. Or ಮನೆ ಹತ್ರ ಅಂಟಿಸ್ಬಿಟ್ಟು ಬಂದಿದ್ದೀವಿ. Thereby he has approached the concerned police station and he has given his voice samples, my lords. And whatever the rulings that has been
FIR ಆಗಿರೋದು 21/1 ಗೆ 22 ಗೆ ಅಪಿಯರ್ ಆಗಿದೆ.
ಮುಗಿಸ್ಕೊಳ್ಳಿ ತಾಳಿ.
And
ಅವ್ರ
what-
ಪಾಯಿಂಟ್ ವೈಸ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. What's the problem?
Please.
Yes.
And whatever the rulings that has been produced before this honorable court does not applicable on the present case on hand, my lords. Because in the first point, my lords, that is the citation number 1 at page number 1. No doubt, my lords, that has been upheld. The judgment has been upheld by the honorable apex court, where the honorable apex court has given 8 guidelines, my lords, in which at page number 3, my lords, 8 guidelines were there. Person aggrieved, my lords, the present complainant before this honorable court in the present case is a social worker, my lords, and he is aggrieved by the post that has been made by this person, my lords. And second, my lords, preliminary inquiry, my lords, before registration of FIR, there has been a preliminary inquiry that has been conducted, my lords. And with respect to the third point, my lords, there is a prima facie case, my lords, because, my lords, the kind of speech that has been delivered by the present petitioner completely against law, my lords, and he has specified certain communities against certain communities, and he has instigated others, my lords. And point number 4, my lords, person who has delivered a speech, my lords, he is not at all a politician, my lords. It is not a politically hate speech, my lords.
So politicians can do,
My lords, that protection has been given in this present ruling to the political speech, my lords, but in the present case on hand, it is not at all.
not to individuals.
It is, he is instigating youngsters against another community, my lords. So a specific community, he is instigating against other community.
Will answer.
My lords.
Yes.
And with respect to 5, my lord, there is no defamation and there is no defamation case has been registered. The present case on hand is completely different, my lords.
All right.
And my lords, he has not taken bail, he has no apprehension of arrest and he
Stay
has
ಮಾಡಿದ್ದೀವಿ.
appeared.
We have stayed.
No, my lords, he has appeared and he has given his voice samples as my lord has told not to take coercive action, my lords. We have not taken any coercive action, but before that, we have issued a notice under 35(3). We have complied the provisions of Anish Kumar, my lords. And in order to say again, at point number 7, my lords, it is not at all a political that he has delivered, my lords. And the second citation, my lords, at page number 5, my lords, it is about 20% commission, read, my lords, it is at page number 9. No vision, no mission, only 20% commission. This is how 15th month rule of Revanth Reddy led Congress government in Telangana. He has spoken only with respect to some politicians, my lords, and with respect to the politics. And in page number 3, the third judgment, my lords, specifically the
ಇದು
page
40%
number,
ಮಾತಾಡಿದಾಗ ಏನು offense ಆಗ್ಲಿಲ್ಲ.
my lords, he has speaking with respect to the policy formation. In
Alright.
that case, he has not spoke anything with respect to any community or any religion. He has not ಯಾವ community ಬಗ್ಗೆನೂ ಕೆಟ್ಟದಾಗ ಮಾತಾಡಿಲ್ಲ ಅಥವಾ ಹೇಳೂ ಇಲ್ಲ.
ತೊಂದ್ರೆ ಇಲ್ಲ.
My lords, the third judgment which he has produced, my lord, page number 34 and 36 are very important. My lords, this is with respect to a poem which has sung, my lords, neither the name of the religion or nor the
Alright.
community. And page number 36, it clearly states, my lords, the poem does not refer to any religion, caste or language. It does not refer to the person belonging to any religion. By no stretch of imagination does it promote enmity between different groups. We fail to understand how the statement therein is detrimental. Well, in this case also, he has not named any of the community or the religion, my lords. My lords, the fifth judgment, the fourth one, in my lords, the petitioner in this case, my lords, has only referred Black Day and Happy Independence Day to other country, my lord. In that also, he has not named any community nor the religion. And in this 79, page number 79, judgment number 5, my lords, the ruling number 5, in which it is about the government land which has been unauthorizedly occupied by some of the politicians, some defamatory statements that has been made by one political leader against another political leader. With respect to the policy of the concerned government, my lords, this is also not applicable to the present case on hand. The sixth judgment at page number 87, my lords, speaks about the tribal attacking and not taking of action. And this also not involves any
Not
community.
applicable at all.
It is also not at all applicable to the present case on hand. And at page number 98, my lords, the ruling number 7. My lords, the FIR initially in this case has been registered for the offences punishable under section 499 and 500 of IPC.
Correct. It was defamation.
Defamation, my lords. But in the present case on hand, it is completely different. The defamatory words not has been used, but it is under 353 clause 2, my lords. And this is also not at all applicable to the present case on hand, my lords. And at page number 8, my lords, until case.
Until
Yes,
what?
my lords. Satyendra
Until.
Kumar, until,
Yes,
please.
yes.
My lords, in this, the procedure that ought to have been followed at the time of arrest that has been made, my lords, but neither in the petition nor in the grounds, my lords, so they have narrated anything with respect to the procedural aspects. They are just seeking for quashing of the FIR, my lords. My lords, at page number 143, my lords, that is ruling number 9, my lords. It is again with respect to the procedural aspect of arrest. Page number 154, my lords, ruling number 10, there where it has the slogan Bharat Mata Ki Jai, my lords. And as I said, my lords, it is not at all applicable to the present case on hand, my lords. My lords, none of the judgments, and my lord's judgment is at page number 11, where it has stated, my lords, there are no documents and no eyewitnesses to the alleged incident. Based on that reason, that has been quashed. And at page number 194, there is no mention of any religion and or community. My lords, so the speech where it has delivered.
That I have seen. I will look into that. You have given a pen drive also.
My lords.
You have given a pen drive as well.
Please, I have given a pen drive and all, my lords.
Will.
My lords,
Yes,
only
sir.
one submission, my lords.
Books
Only
will.
one submission,
Yes,
my
ma'am.
lords. The incident that has been taken place, my lords, it is in the college, my lords, and the petitioner happens to be the Adhyaksha of Vivekananda Vidyavardhaka Sangha. My lords, and the students who were there were around 1,500 to 2,000 students, my lords,
All
and
right.
aged
We'll-
about
we'll
19 to 21, my lords.
We'll consider hearing. Yes,
In
sir.
the meantime, my lord, the DG IGP has come out with a circular citing, my lord, this latest Supreme Court. I will place it on record for your lordship.
Sorry.
Also, my lord,
But this has happened prior to this, sir.
Prior to that.
Not, we'll consider.
Please.
In any.
My lord, also, my lord, some of the points maybe that arises for consideration in this matter.
Point versus point. What do you?
Only thing is, my lord, since it is pertaining to social media and your lordships, my lord, last time heard and expressed, my lord, some mechanism has to be adopted. Some suggestions and, my lord, by way of submission.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಸರ್. ಸ್ಟೇಟ್ಗೆ ಕಾಪಿ ಕೊಡದೇನು?
ಕೊಟ್ಟಿಲ್ಲ.
My lords, I would like to make only one submission, my lords. The petitioner is an habitual in delivering this
we'll
kind
pass
of
orders.
speeches, my lords, and he is,
The only thing is, my
he
lord,
has not even left, spared gods also, my lords.
but so far
Not
as,
only the community's religion.
We'll see, yes.
but so far as complainant is concerned, my lord, notice has not been ordered. Your lordship may, my lord, dispense with the notice because
Why?
he is, my lord, not a agreed person. He is only.
He is agreed to.
ಅಲ್ಲ ನಲ್ಲ ಬಾಲಲ್ಲಿ ಹೇಳಿದಾರಲ್ಲ, who is aggrieved person?
ಹೌದು, ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಸರ್ವ್
does
ಮಾಡಿ
not-
by way of hand summons.
Please, my lord.
Heard the learned senior counsel Arun Shyam appearing for the petitioner and the learned additional SPP Asma Kausar for the state. Learned additional SPP has elaborately taken this court through the objections and the judgments that are relied on by the learned counsel, learned senior counsel for the petitioner to contend that the petition should be dismissed. There is an interim order operating in the case at hand which has been granted by this court on 6/2/2026. The complainant is yet to be served. Therefore, the complainant be served by way of hand summons and file an acknowledgement of such service by Monday. This is the matter on 20th. 20th? 20th ಬರ್ಲಿ, further hearing ಏನ್ ಬೇಡ, ಕೇಳಿದ್ದೀನಿ anyway. Very rest on 20th.
Marie?
For the petitioner, my lord.
Relaxation of bail, where do you want to go, sir?
The
Dubai?
Saudi, my lord.
Saudi? For what? Business?
Business as well as, my lord, I was employed with, my lord, in this case, my lord, the petitioner is a victim, my lord. Kindly see, my lord.
Victim?
Petitioner is a victim, my lord.
Victim? Why?
ಹೌದು, petitioner is a victim. ಜಾಸ್ತಿ ಆಸೆ ಆಗಿದೆ ಹಂಗಾಗಿ. ಇಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ?
ಏನು ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರಿ?
No, no, my lord. What happened, my lord? I have a bank account in the bank, IDBI bank, my lord. Bank manager, what happened, my lord? I have the locker in the same bank. From 10 years, my lord, my house is adjacent to the bank, my lord. From 10 years, I am in the account, my lord. What he paid, my lord, he has, my lord, we required money for our business, for construction company. He is doing the construction work, my lord. So whatever it was there in the locker, my lord, we wanted to pledge, my lord. For revaluation, he has taken the gold. What he did, my lord, he has taken the money, 5 crores cash, my lord. He wanted to give it to some other person in the outside, my lord.
Bank manager?
Bank manager, my lord. I'll come back to it. Then, my lord, what happened, my lord? 5 lakhs when he is transferring, giving to some other person, income tax rated the said person. 5 lakhs was seized by the, my lord, kindly see, 5 lakhs was, 5 crores was seized by the income tax, my lord. Then, my lord, my golden article, my lord, it was there in the bank. Bank, they are not ready to give my bank. I filed a case against the bank manager, 2 bank manager, my lord, in 2023, my lord. Police have filed a B report, my lord. Then I have filed a protest petition in the, and I have also prayed for the further investigation. They are not conducting investigation. They colluded with the bank manager, my lord. They are not conducting a proper investigation. My lord, then, my lord, the ACP of the Sen police station filed an application for further investigation in the case, and he has seized all the gold ornament, my lord, and then it was under the court custody, my lord. Then I filed an application for the release. My lord. Court was rejected for saying that, my lord, it is investigation is under process, my lord. In this case, my lord, I have not received the money as well as, my lord. My golden article is with the court, my lord.
The petitioner?
It's an interesting scam, my lord.
Very interesting.
No, the scam is that they will ask him to give 5 crore rupees.
No, that is a story they have created, my lord.
And in turn, he will return back 7 crore rupees. And that money has to be given in X hours. If you don't give the X hours, you will have to pay penalty of 1 lakh rupees.
ಇದೆಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಬಿ ರಿಪೋರ್ಟ್ ಹೆಂಗ್ ಹಾಕಿದ್ರಿ ಇದರಲ್ಲಿ?
ಈಗ ಮಾಡ್ತಿದ್ದಾರೆ.
They have B filed, my lord. I prayed for the further investigation, my lord. What he did, my lord, he used my check also. ನಮ್ಮ ಮನೆ ಪಕ್ಕದ ಮನೆ ಇದ್ದಾನೆ. He has taken my signature. He has taken a OD also, my lord. Bank manager has taken the OD also. He is now absconding. He is now absconding.
No, neighborhood has no value today. Yes. The petitioner is before the court seeking the following prayer. The petitioner is the accused number 2 in crime number 48 of 2025. On registration of the crime, the petitioner seeks his enlargement on anticipatory bail. On registration of the crime, seeks anticipatory bail as obtaining under section 482 within bracket 2 of the BNSS. The concerned court grants bail to the petitioner, stops him from traveling beyond the shores of the nation. It is therefore the petitioner is before this court seeking relaxation of bail condition, as he has his business in Saudi Arabia and wants to travel for the purpose of business. The learned counsel for the petitioner submits that he is in fact a victim in the entire episode of trickery by the bank officials who had played fraud involving misappropriation of cash of 5 crores of the bank and fraudulent gold loan disbursements and tampering with the pledged gold ornaments in the IDBI bank. They are facing the acts of crime, The learned counsel submits that the petitioner, being a victim, should not be stopped from traveling beyond the shores of the nation for the purpose of business, and that would curtail his fundamental right. The learned additional SPP, though would oppose the petition, would accept the fact that the petitioner is a victim and would vehemently refute the submission to contend that the petitioner, if is permitted to travel beyond the shores of the nation, would not be available for future trial.
Your Worship, I'll concede, my lord, but I will not concede to the extent of he is a victim.
That we'll see. Will not be available for future trial, and therefore submits that, therefore leaves the decision to the hands of this court. I've given my anxious considerations. The afore narrated facts, the link in the chain of events, are a matter of record. What leads the petitioner to the concerned court to seek anticipatory bail is the acts of the other accused, the bank officials involving themselves in serious fraud of alleged misappropriation of 5 crores and fraudulent gold loan disbursements. The petitioner registers a crime against the said bank officials. The police, after investigation, is said to have filed a B report, shocking enough. The B report is contested too, and now there is further investigation that is now happening in the case at hand against the said bank officials. Be that as it may, the petitioner has a fundamental right to travel. It can be curtailed only on circumstances where the petitioner would escape trial or otherwise. The bail conditions are generally imposed that he should not travel beyond the shores of the nation. The petitioner has produced his avocation and his business in Saudi Arabia, and would undertake that he would be available for trial at any given point in time, failing which appropriate action could be taken. In the light of the aforesaid circumstance, I deem it appropriate to, though not declaring that the petitioner is a victim, as the petitioner is shown as accused number 2, I deem it appropriate to relax the condition, subject to the condition that the petitioner, if would escape trial or summons from the hands of the concerned court at appropriate times, unless specific exemption is granted. The appropriate action would be directed to be taken, even impounding of the passport by the passport authorities. With the aforesaid condition, the petition stands allowed, so and so condition stands quashed.
9.
It is a surety.
It's a catch-22 situation. We have given an opinion to challenge this order, and we did not pursue it because he subsequently was NBW was issued and he was arrested.
Surety ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
Correct, my lord. This court passed an order on 28/4. He was released in prison on 5/5/2025. 2 weeks ends on 18/5/2025.
ಆಯ್ತು, ಲಾಸ್ಟ್ ಒಂದಿನ ತಾನೆ. ಒಂದಿನ ಲೇಟ್ ಆಗಿದ್ಯಾ?
No, my lord, we were present on 19th itself. The court did not accept the surety.
The petitioner is before this court seeking the following prayer. The petitioner is accused number 1 in sessions case 15038 of 2025, registered for offences punishable under so and so. The issue is not with regard to the merit of the matter. The petitioner was enlarged on bail.
Please, my lord.
Grounds of arrest.
Grounds of arrest.
The petition.
That is what we challenged it. In fact, the opinion gone, matter was in the committee. By that time, he was arrested.
The petitioner, yeah, where is the order of this court?
92, my lord, page number 92.
The petitioner was enlarged on bail. The petitioner was directed to be set at liberty at the hands of the coordinate bench by the following order. Page 94 to 96. Pursuant to the passage of the order, the petitioner was set at liberty as the condition indicated that the petitioner would give surety within 2 weeks from the date of his release. From the date of his release, bold muddy. The petitioner was released. The order was passed on the 28th of April 2025, but the order was made available on 4th. On 5th of May 2025. These are admitted facts. On 5th of May 2025, the petitioner made arrangements for surety and appeared before the concerned court on 19th of May 2025. On the said date, the concerned court declined to accept the surety and directed the petitioner to be taken into custody. All on the ground that the order of the coordinate bench as quoted supra has not been complied with. The petitioner therefore is back in prison and back to this court seeking his release. In the light of the learned additional SPP though would seek to defend the action of the learned magistrate in directing that the petitioner has not offered surety within the time that is stipulated by the coordinate bench, would submit that to the coordinate bench and seeks dismissal of the petition. The afore narrated facts lie in a narrow compass. The issue in the list lies in a narrow compass at this juncture, whether the petitioner is to be set at liberty, yet again. The petitioner was set at liberty by an order of the coordinate bench imposing certain conditions. The condition was that he should furnish surety within 15 days from his release. The order was made available on 5/5/2025. 5/5/2025. Therefore, the petitioner had time up to 19/5/2025, as the order was unequivocal that surety was to be afforded on its, which was made condition precedent for his release within 2 weeks, which would be till the evening of till 12 a.m. of 11:59 p.m. of 19th. Therefore, the petitioner appears before the learned magistrate on 19th and offers surety. The magistrate, by the impugned order, rejects and directs him to be taken into custody. The order of the learned magistrate is on the face of it illegal, as the order of the coordinate bench was granting 15 days time. Surety was offered on the 15th day. Merely because it is offered on the 15th day does not mean that he would not be entitled to the benefit of the order of the coordinate bench. That like the inescapable conclusion of this petition would be the release of the petitioner from prison with all conditions that are imposed by the coordinate bench. For the aforesaid reasons, the following order. ಅಲ್ಲೇನಿದೆ ಕಂಡೀಷನ್ ಇದೆ ಎಲ್ಲ. ಈಗ ಶೂರಿಟಿ ಏನ್ ಬೇಡ, ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಇನ್ನು ಕರೆಕ್ಟ್ ಸೇಮ್ ಆರ್ಡರ್. ದಿ ಶೂರಿಟಿ ಶಲ್ ಬಿ ಆಫರ್ಡ್ ಈಗ 48 hours.
Give surety and will give surety, thereafter it can be released.
Correct. The petitioner shall comply with the order of the coordinate bench, and the moment he complies with the order of the coordinate bench, he shall be set at liberty without broking any delay.
That order may be quashed by 20.
No, quashed, allowed, petition allowed, quashed. the,
20th January 2026 order is maybe
I-
possible. Please. Wait.
yes.
Number 10.
Then,
The only thing your lordship should say Mihir Rajesh Shah will apply in case if you want to cancel.
ಅಲ್ಲ,
Mihir
ಅದನ್ನ-
Rajesh Shah allows us to.
that will say, we have, ನೀವು ಅದನ್ನ ಇಡಕ್ ಬಿಟ್ಟಿದ್ದೀರಿ.
In fact, we wanted to challenge it. By then NBW the issue was taken to custody, therefore we also did not pursue it.
This petitioner, this matter.
Case, counter case.
That's the lordship has
Interim
granted.
order as spread. One additional SPP, two emergent notice.
There is a video, Miller, that's why that was my submission.
Even otherwise, it is a bottom case against you. ಏನೇನ್ ಕತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ?
No, Miller, not cut, this is 307, Miller. This is property
Attempt to
dispute.
murder. Yes.
There is a video, Miller.
ಅಲ್ಲಿ ಏನು ಫೋಟೋ ಅಲ್ಲಿ ಏನೋ ಕದೀತಾ ಇರೋದು
Yes,
ಹಾಕಿದ್ದೀರಾ?
no, Miller. ಅಲ್ಲಿ ಗಲಾಟೆ ನಡೀತಾ ಇರುತ್ತೆ. The complainant suppressed this video and they, after 8 days, Miller, they says that they use the match it.
ಕೊಟ್ಟಾಯ್ತಲ್ಲ. Yes.
ಇಬ್ರು ಒಂದೇ ಕೇಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇರ್ಲಿ, ಅವರು ಬರ್ತಾರೆ ಬಿಡಿ, ಎರಡು ಸೇರಿ ಸೆಟಲ್ ಮಾಡಿಸ್ತೀವಿ.
It may be connected, Miller.
ಇದೆಯಾ ಇನ್ನೊಂದು? ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ.
ಹೌದಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ದೇನೆ ಕೋಡ್ co-accused 6 and 7.
ಟ್ಯಾಗ್ ದಿಸ್ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ. ಕಂಪ್ಲೇನೆಂಟ್ಸ್ ಬರ್ತಾರೆ, ಅವ್ರದ್ದು ಸ್ಟೇ ಮಾಡ್ತೀನಿ. ಮಾಡಿ ಎರಡು
Case and counter case.
ಎರಡು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ, ಇಲ್ಲ ಅಲೋ ಮಾಡ್ತೀನಿ.
Please, yes.
Please, I appear for petitioner, my lord, sir. This case, my lord, sir.
ರಿಸಾರ್ಟ್
Yes, my lord, sir. I filed a suit on 6/12, my
ಆಯ್ತು,
lord.
ಟೆನೆಂಟ್ ಅಂಡ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್.
ಅಲ್ಲ, ಹೌದು. On 23, my lords, my lease period ಇನ್ನು 2 ವರ್ಷ ಇದೆ.
ತೊಂದರೆ ಇಲ್ಲ. The petitioner is before this court calling in question registration of a crime in crime number 1 of 2026.
ನಂದು 23 ಕೊಟ್ಟಿದ್ದೀನಿ.
ಫಸ್ಟ್ ಕ್ರೈಮ್ ಹೆಂಗ್ ಸ್ಟೇ ಮಾಡೋದು ಕಷ್ಟ.
ಅಲ್ಲಲ್ಲ, ನಂದು 23 ಕೊಟ್ಟಿದ್ದೀನಿ, ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ. I sent it by registered post.
The dispute is between the landlord and the tenant. The petitioner, ನೀವು landlord ಅಲ್ಲ? You are the owner of the resort?
I am the owner of the resort.
The petitioner is the landlord.
Owning on the basis of the lease.
ಒಂದು ನಿಮಿಷ ಸರ್. Owner of the resort who has leasehold rights upon the said resort. The second respondent is tenant.
Owner of the land.
The second respondent is said to be, ಹೆಂಗ್ ಮಾಡಿ, this complainant is the landlord. The petitioner is the owner of the resort which stands on the said land. The two have a transaction. The landlord wants eviction of the petitioner. The eviction is not, it does not come about. Therefore sets the criminal law into motion, invoking the Atrocities Act without there being any semblance of an ingredient. Therefore, there shall be an interim order stay of all investigation query the petitioner till the next date of hearing.
May seek hand delivery.
Why, sir?
ಅಲ್ಲಿ ಹೋಗಿ 11 ದಿವಸದಿಂದ ಹೋಗಕ್ ಆಗ್ತಾ ಇಲ್ಲ.
ರೆಸಾರ್ಟ್ ಗ
ಹೌದು.
ಸ್ವಲ್ಪ ದಿನ ಹೋಗ್ಬಿಡಿ ಬಿಡಿ. ಎಸ್, ಪ್ಲೀಸ್ ಮಾಡುವ ನಾಳೆ. ಎಸ್.
For the petitioners. Happy for the second respondent.
4969.
Yes.
Yes, sir.
I place two judgments of your lordship.
Wait, sir. ಇನ್ನು ಫ್ಯಾಕ್ಟ್ಸ್ ಬಂದಿಲ್ಲ, ಆಗ್ಲೇ ಜಡ್ಜ್ಮೆಂಟ್.
Interesting.
ತುಂಬಾ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಆಗಿದೆ.
ಅಲ್ಲಲ್ಲ, interesting issues. Lordship will take these two petitions and the.
ಅಲ್ಲ, ಎರಡು ಅದೇನೆ. 12 and 13.
Accused number 2 and 3 in first petition, accused number 1 in second petition.
Correct.
Accused number 2 and 3 in first petition, para 10 says that they learned there are multiple complaints against the victim's father. That is the reason for cancellation of marriage.
Maybe.
Yes. Second petition ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ
ಬೇರೆ ಹಾಕಿದಾರ?
ಬೇರೆ.
ಯಾಕೆ?
The relationship between the in-laws and the family, my lords, is different. The relationship, my lords, between the groom to be and the girl is different.
ಇರ್ಲಿ ಬಿಡಿ.
Either which way the family decided, my lords.
ಏನು?
Where after engagement has fixed, this has been, marriage has been cancelled.
ಎಷ್ಟು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ? ದುಡ್ಡು ಏನಾರು ಎಕ್ಸ್ಚೇಂಜ್ ಆಗಿದೆಯಾ?
ಜಾಸ್ತಿ ಖರ್ಚು ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದಕ್ಕೆ?
Engagement.
ಎಷ್ಟು?
ಕೋಟಿಗಟ್ಟಲೆ.
They claim, my lords, 8 crores for an engagement.
No.
8
crores. It's a 3.5 crore.
ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ ಸರ್?
Palace Road.
ಎಂಗೇಜ್ಮೆಂಟ್ ಯಾವ್ದಿದು?
And all upon the insistence of the girl.
No, that's the blame. Insist on a girl.
ಇಲ್ಲ, ಅದೆಲ್ಲ ಮಾಡಬಾರ್ದು. ಈಗ ಎಂಗೇಜ್ಮೆಂಟ್ ನೀವು ಮಾಡಿದ್ದ?
ಹೌದು. Where the materials has been purchased, still it is in the home, in my home itself, the stock.
Their home.
420 ಹಾಕಿಲ್ವಾ? ಮತ್ತೆ ಹಾಕ್ಬೇಕಲ್ಲ ಅದನ್ನ.
69, my lords. And so far as the petitioner.
69 will do it, no problem.
So far as the parents, my lords, 49. Abetment 2.
109 is 49.
Please.
109 IPC is 49.
They say-
69 is new provision.
And your lordships are beautifully encapsulated.
ಅದು ಗೊತ್ತು, yes.
But this
Does
may
not
not be,
punish.
on facts of the case, this may not be. No, I think there are many things, my lordship may see that there are many things which, at least for the
They're not
accused number
placed on
one.
notice.
No, you can't abruptly. And their fact pleading itself.
How
runs
long
contrary.
were you in a relationship earlier?
My lords, may I take a lordship's
No, how
complaint?
long were you in a relationship?
For 2-3 months.
Why?
May I take a lordship's
Come,
complaint?
yes, yes,
Page
come on,
number
facts, let
22.
me
my
see.
lords.
Yes.
May I read? my lords? On September 5th, 2025, my marriage was fixed with one Pushottam in the presence of elders of both families
ಅಲ್ಲ,
at our
ಕಂಪ್ಲೇಂಟ್ ಬೇಡ
home.
ಸರ್, ನೀವು ನಿಮ್ದು ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ಸಾಕು.
My lords,
When did you come in contact with the girl?
It was a setting of an arranged marriage.
Setting?
It was an arranged marriage
Arrangement for
setting.
marriage.
Yes.
Sir,
And
yes.
my lords, the families introduced the both of us. They fixed an engagement. Engagement ceremony takes place. Marriage is
All
also
within the
fixed.
span of?
Yes, my lords.
Span of what?
Span of 2-3 months, my lords.
All right.
Spanning from 5th September 2025 to 16/12/2025.
Then you had physical relationship with the girl?
Yes. Consensually, my lords. Consensually, as accepted by the complainant herself. Then, my lords, for a myriad of reasons, my lords, the relationship tumbles.
Maybe.
The reasons being, my lords, that she had, I don't want to say it, my lords, but if your lordships, I've produced the entire facts, my lords. My lords? She was indulging in multiple other external relationships. After engagement, she's caught. I confront her on chat and otherwise. Now I ask after the engagement, this is the situation, how do I proceed? I say, in fact, I will.
Marriage would have been better.
Sorry?
After marriage, things should have settled.
After marriage, it could have been a disaster for me. These things are able to
One sir, I'll come back to you.
You would have probably been claiming around 50 crores or something of that sort.
50 crores.
Exactly, with an engagement.
Oh, alimony ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಾ? Your future is sticking in thought. Yes, yes, but
There was the intention from the inception was to get married. It was never announced that we don't want to get married or anything of that sort. At best, the legislation judgment that covers the entire issue. The latest judgment of your lordship.
I thought we were giving something else. Yes, I know.
Yes. There is a lordship's hold that.
Both are mine only.
Yes. Section 69 rules that it cannot be used as an instrument for retroactive criminalization of consensual relations. The second judgment that has been and in this judgment, the lordship also took note of the disturbing manner in which family members are falsely implicated. The first question is for only the parent. The second judgment was in identical facts and circumstances at paragraph 12. Once the engagement is materialized, the factor that
Santosh Shetty.
yes,
Supreme Court has come.
yes,
Very.
as is the fateful day that had made upon the first petitioner 11/1/2023.
See, that was a fact where engagement takes place. The night of the engagement, they get physical. He goes away to Bombay. Marriage breaks.
No, there the lordship says because one factor is clear that there was no false promise of marriage. It is a marriage that has been decided by the family. Same situation. Arranged marriage, the family is
Supreme Court will confirm with that. Harish.
September 2025, when on 26th of October 2025, engagement. When marriage also was on 26th of January 2022. Before that they had a relationship.
Only after the families sat together and not before that. So it was not that they were in love earlier. They had physical relationship after the talks were materialized. Talks failed. Engagement fails.
Engagement has happened.
Engagement happens, marriage fails.
Reason the marriage failure according to state because according to husband, according to DMC because these criminal cases are waiting to try to do against the father of the. It's nowhere else. Before that, it will come faster second day.
Reason ಬೇರೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅದನ್ನ ಹೇಳಿದ್ರು.
There was great study against us. In the event that you don't come forward and conduct this marriage, you do an acid attack. Acid attack against the. We have filed a complaint to the commissioner informing about all these activities and the manner in which they threatened us. On 5/1/2026, almost 1 week before the complaint to the private complaint.
Consider ಮಾಡೋಣ. Take it next week only. ಅದಕ್ಕೆ let me interpret 69 ಅದೊಂದು ಆಯ್ತು ಇನ್ನೊಂದು ತರ. Because 69 is new.
Correct. I am of the opinion that 69. Nothing else to recover.
So, ಏನಿರೋದು? Let me see. Is arrest ಮಾಡಿದ್ರು. Is in custody now? No. What? What is in custody? ಮದುವೆ ಬ್ರೇಕ್ ಆಗಿದೆ. ಅದು ಕಸ್ಟಡಿ ಇದೆ. Tomorrow you may be that side. What has happened? Well, what has it? My request regard to one. Section 69 only. That like 498A.
So one aspect probably somewhere we may have to challenge. With the section 69 being introduced in BLS laws, despite the judgments laid on by the Supreme Court where promise to marry is not an offense, probably one of the cases, my lords, at least we have to fetch to see if in a case like this, if they're going to be doing it, we could assist, my lords. Somewhere, my lords, we have to look into section 69 the wires of section 69. It goes against what Supreme Court has said in a number of cases, promise to marry, it's not going to be an offense. To introduce it in NPS. Understandable levels where the very basis of it was, but this may not be so.
Because the act had become rampant. That's the reason there was a recommendation to introduce.
Probably Melons will have to test that. Promise to marry. Because Melons, and we get cases where the girls are 25, 26 years old, and here they complain to promise to marry.
No, that promise to marry a 5 years relationship, that's okay that we are.
But that comes now under 69. That's the problem.
We'll have to judicially interpret that. We can't hold the legislation back.
We may have to test it is what I feel, Melons, on the basis of how Supreme Court has interpreted. Oh.
No, see, that way 498 has been there, its misuse is there. Is it taken away?
Well, it's 376 LA. Promise to marry was not there at all. 376. There's no concept of saying promise to marry and then it was not there. But
That's a new thing. That is why.
Now, 369 going to be leading to a situation where all interpretations that have been done by us, whether it affects interpretations is something, we'll see. Probably we may have to look into this.
Let him be released with us. That is not. Yeah, not correct at all. The petitioner, ಯಾವುದು accused number 1 ಯಾವುದು? ಯಾವುದು? ಅದು ಕೊಡಿ ಮೇಡಮ್. The petitioner, perfect name also is. The petitioner is before the court calling in question registration of a crime in crime number 4 of 2026, registered for offences punishable under section 67A of the Information Technology Act and sections 49 and 69 of the BNS, which would be 109 of the IPC and the new provision that is introduced in the BNS. The petitioner has, pursuant to the registration of the crime, taken into judicial custody, remains in custody even today. The reason for registration, the backdrop of registration of the crime is the parents of the petitioner and the complainant hold talks of marriage of the two. The talks materialize. The talks, the materialization leads to fixing of a betrothal ceremony of by the second respondent complainant. After the betrothal ceremony, it transpires that on consensual acts, the complainant and the petitioner have had physical relationship. The reasons, for manifold reasons, which were beyond the control of the parents or otherwise, the marriage tumbles. Since the engagement, between the marriage and the engagement is what forms the fulcrum of the entire list. It is for this reason that section 69 has sprung in the case at hand. For the petitioner having a physical relationship with the complainant on a particular night, after the engagement happens. Since the engagement, since the marriage breaks down, the crime is registered for offense punishable under section 69, which punishes a which punishes a accused of deceitfully having physical relationship with the victim without an intent to marry. In the case at hand, the marriage talks, in the case at hand, the petitioner and the complainant did not know each other prior to the talks of marriage. The talks of marriage leads them to, brings them together. The marriage talks fail. It cannot mean that the petitioner was not, petitioner had a physical relationship with the complainant by deceitful means or otherwise, albeit prima facie. In that light, there shall be an interim order of stay of, in that light, there shall be an interim order of stay of all investigation qua this petitioner till the next date of hearing. In the light of the interim order granted, all consequential action would follow, which would mean that the petitioner would be set at liberty. The companion petition, I know next, madam, the companion petition is filed by the parents of the petitioner in criminal petition 2247 of 2026. Father, parents, parents of petitioner in 2247 of 2026. ಇದು ಸಂಧಿ ಯಾವುದು? ಸಂಧಿ ಯಾವುದು ಪೆಟಿಷನ್? ಕರೆಕ್ಟಾ? ಪೇರೆಂಟ್ಸ್ ಅಲ್ಲಿ ತಾನೇ ಇರೋದು. The companion, ಸುಮ್ಮನೆ ಇರಿ. The companion petition is preferred by the parents of the petitioner in 2247 of 2026. The petition, the parents of the petitioner who have challenged the proceedings in criminal petition 2244 of 2026 are also before the court on the score that they had, the marriage talks, the engagement happens and the marriage breaks down on irretrievable problems between the members of the family. The allegations galore by the petitioner by the complainant against the petitioner or the petitioner against the complainant. The issue is the parents could not be dragged into the web of proceedings for an offense under section 69 of the BNS, which is purely between two individuals as individuals with regard to a physical relationship on marriage. Therefore, there shall be an interim order of stay where the investigation against the petitioners as well, parents as well, who form the petitioners in petition, criminal petition 2244 of 2026. Objections, if any, be filed by the respondent in the next 2 weeks. The petitioner shall serve. Badrinath, name idya? Learned counsel R. Badrinath accepts notice for the complainant in both these cases. In both these cases, list the matter on 27th. List the matter on 27th. Objections, if any, by the respondent complainant by then. In the light of the interim order granted in criminal petition 2247 of 2026 and the petitioner in custody today, the intimation be sent by the registry forthwith to the prison authorities to enable release of the petitioner from prison. Yes. Order on IA ಅಂತ ಮಾಡ್ಬಿಡಿ. Yes. ಎರಡು IA ಇದೆಯಾ? ಒಂದು ಸ್ಟೇ ಒಂದು ರಿಲೀಸ್. ಮೇಡಮ್ ಒಂದು IA for stay ಅಲ್ಲಿ reasons ಕೊಟ್ಬಿಡಿ. For the reasons indicated in the application seeking stay, the petitioner shall be released ಅಂತ ಲಾಸ್ಟ್ ಎರಡು ಲೈನ್ ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್, ಅದನ್ನ ನೆಕ್ಸ್ಟ್ IA ಗೆ ಹಾಕ್ಬಿಡಿ.
14.
ಅವರು ಸಿ ರಿಪೋರ್ಟ್. I will take on Latif. I heard the learned senior counsel Vikram Hooligold appearing for the petitioner. The learned counsel B. Latif is directed to accept notice for the respondent. First respondent. Second yaru? Irade obro. Idare ella ಸುಮಾರು ಜನ ಇದ್ದಾರೆ. ಬೇರೆಯವರೆಲ್ಲ ಯಾರು? ಅವ್ರಿಗೇನು ಹಿಯರ್ ಮಾಡಬೇಕಾಗಿಲ್ಲ ಈಗ. ನಾಟ್ ನೆಸೆಸರಿ. Why have you made them parties? Accused need not be made parties here. ಕೇಳ್ತಿರೋದು investigation. Yes. Notice to the accused need not be issued as the accused has no right to be heard at the juncture where the prayer is for investigation. Therefore, the copy be served upon B. Latif alone. Delete ಮಾಡ್ಬಿಡಿ. ಅವ್ರಿಗೆ ಅಕ್ಯೂಸ್ ಕೇಳಬೇಕು ಅಂತೇನೆ. ಡಿಲೀಟ್ ಅನ್ನು ಇರಲಿ. ಸರ್ವ್ ಮಾಡಿ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. ಎಸ್. 20th? List on 20th.
15.
13.
Three aspects in this case which I point out. One is section 17 order method is not produced before the court without producing itself for its action. That, my lords,
No, that cannot happen.
It can never happen. Now we applied for certified copies and we got the certified copies, no 17 order.
So why do you do this?
You can't have a 17 order.
So why do you do this?
Kindly, earlier BB Patil was appearing. They frustrated they saw me the copy because
ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿದೆ.
Yeah, last time we were asked to serve it on the
Please,
because he had some
KDB
conflict,
official
yes.
is involved. Kindly have it on Monday, I'll file my objection.
Again, what is the bail ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು.
ಸರಿ.
ಇದರಲ್ಲಿ DA case.
DA ಅಲ್ವಾ? Not 7A. All right. Yes.
So, three aspects of this cross check. One is, my lords, check period is not defined. Two is, my lords, you take the income of the wife, and you have not taken the income of the wife where you have taken the assets, which gets covered by Nirnkanath Pandey's case. Where this
ಅದೆಲ್ಲ ಬೇಕು, ನನ್ನ ಕಂಪೈಲೇಷನ್ ಬೇಕು.
This was that in the compilation because now they are only relying on Sudhakar Reddy and Channakeshava.
Correct.
I will point out, my lords, 2 points which have been still kept open. One is desirability of being, that is still open, my lords. Second is application of fine for an order under 17. Now, third aspect which my lords have considered is, without an order under 17, can a search warrant be issued? That, my lords,
This will have to.
that can never happen. Because, my lords, the court should first satisfy
No,
itself.
where are the records? Get the records, sir.
I will get the record.
When did you pass an order under
17 order is
17?
there, my lord.
When did you seek search warrant?
But I'll produce original.
Toli, madam.
This is what we get from the court. The Gangadhar Iyengar's case, my lord said once notice. my lord,
Yes.
so hotel under
Supreme Court.
things later.
True, but
But here, my lords, we will be able to demonstrate if the search warrant is issued without an order under 17, the whole thing is fine.
no, if that was to be followed, corrective measures if you had taken, there would be no loopholes left if what I wrote in Gangadhar was followed.
They have a circular now. If that circular they follow, my lords, meticulously, we would have no defense at all.
I'll just
But
go through,
take
I'll go
instruction
through
and
this.
produce the original file.
You produce the original
Please,
file.
please,
Well, I'll take it on Wednesday. Yes.
Please.
Wednesday in the fresh matters.
Please.
What?
Not anyway, my lord, now, matter of 1 week, my lord, now already. my
No,
lord,
don't
source
take
report is
any
filed.
coercive steps. Coercive steps ಏನಿದೆ?
I'll,
They've been coming to his house, serving.
no, my lord, my
ಆಮೇಲೆ
instruction
one more
ಇಲ್ಲ.
thing, ನೆನ್ನೆ
ಇಲ್ಲ.
ಲಕ್ಷ್ಮಿ ಮೇಡಮ್ ಅಪೇರ್ ಆಗಿದೆ.
What had happened?
See, ಇವ್ರಿಗೆ ಏನೋ ನೋಟಿಸ್ ಕೊಡ್ತೀರಾ? Madam, yesterday's case that, how does the Lokayukta do this? I don't understand.
Please.
Now, father is the accused. You conduct a raid. ಏನೂ ಸಿಗಲ್ಲ. ಆಮೇಲೆ you seize the mobile. Mobile ಅಲ್ಲಿ photographs ಅಲ್ಲಿ jewelry ಹಾಕಿರ್ತಾರೆ wife. Get that jewelry and come on 35(3) notice ಕೊಡ್ತೀರಾ? What is this? You're wearing some jewelry in a photograph, so get that jewelry and come on. You did not find anything in the house.
But I'll.
What is this? ಶುರು ಮಾಡಿ ಇನ್ಸ್ಟಾಗ್ರಾಮ್ ಅಲ್ಲಿ ನೋಡೋದು, ಫೇಸ್ಬುಕ್ ಅಲ್ಲಿ ನೋಡೋದು, ಜ್ಯುವೆಲ್ರಿ ಇದೆ ಅದಿದೆ ತಗೊಂಡ್ಬನ್ನಿ.
That is not.
Especially in DA cases, my lords, that is not to be resorted to. DA case stands to be slightly.
But what will happen?
ಅಲ್ಲ, for the alleged
Happen.
acts of the father,
Please.
you inquire the father, he will justify or not justify. Why do you trouble the mother and the children?
I do agree.
ಅಲ್ಲೆಲ್ಲೋ ಕಾಣ್ತಾ ಇದೆ, ನಿಮ್ ಫೋಟೋ ಕಾಣ್ತಾ ಇದೆ, ಜ್ಯುವೆಲ್ರಿ ಕಾಣ್ತಾ ಇದೆ.
Definitely, my lord.
Investigate ಮಾಡಿ. If father is cooperating, cooperate. Why do you trouble the I was shocked to see that yesterday. 35(3) notice ಅಲ್ಲಿ ಜ್ಯುವೆಲ್ರಿ ಕಾಣ್ತಾ ಇದೆ, ಸ್ವಲ್ಪ ತಗೊಂಬನ್ನಿ ಜ್ಯುವೆಲ್ರಿನ ಅಂತ.
Normally, my lord, during
Also, my
search.
lords would have noticed, if they say it is Benami, my lords, then the burden is on them because Krishna and agree with you. You can't
No,
just
if
say
they
that
had, if they had found it at the time of search,
That's different.
that's
That's different.
ownership goes by possession.
Yes.
So now they have not found it. Photograph will not go to this is yours.
I don't think the whole object is that disproportionate asset is only against that public servant.
That's precisely why
Against the others.
Anna Lakshmi madam had appeared in that. I was
Will
shocked to
instruct the
see that.
officials, my lord, will orally.
Not correct.
Please. And my lord,
But
yes.
I think we have produced what certified copy which we have applied and what we got, 17 orders are not there. Now if they produce it, we will see.
But I'll produce the original.
Heard the learned senior counsel Sandesh Chota appearing for the petitioner. The learned senior counsel has projected a threshold procedural aberration. The learned senior counsel submits that without an order under 17 and registration of a crime, the search warrant cannot be taken from the hands of the concerned court. The learned counsel has produced certified copies of the order sheet maintained before the concerned court where there is no order under section 17 at all placed before the concerned court prior to issuance of search warrant. This, according to the learned senior counsel, is a serious procedural aberration, which the matter would require consideration. The learned counsel Prasanna Shetty seeks a week's time to secure the original records and place it before the court. In the light of the aforesaid circumstance and the matter requiring a decision, the respondent shall not take coercive steps against the petitioner towards investigation.
My lord, in fact, they took 1 month time, my lord. We, my lord, called for some.
ಯಾವುದಕ್ಕೆ 1 month?
ಇನ್ನೊಂದು ತಿಂಗಳು ಕೇಳಿದ್ದಾರೆ. Even they have not produced all the documents.
They will produce it.
ಈಗ ಏನು ನಾವೇನ್ ಮಾಡ್ತಾ ಇಲ್ಲ. In fact,
produce ಅಲ್ಲ ಅದು ಕೂಡ schedule ಗೆ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
ಅದು ಕೊಡ್ತಾ ಇಲ್ಲ ನಾವು schedule ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
Always takes time. Schedule that, my lords, when they ask for a schedule, my lords, we have to take time before giving a schedule to them.
Correct, you can't give it in a hurry.
In fact, my lord,
ಅಲ್ಲ,
initially,
ಒಂದ್ ನಿಮಿಷ, ಓವರ್ನೈಟ್ ಮಾಡೋದಲ್ಲ ಅವರು, ನೀವು ಮಾಡಬೇಡಿ.
ಚೆಕ್ ಪೀರಿಯಡ್ ಇರ್ಬೇಕು, ಇಲ್ಲಿ ಚೆಕ್ ಪೀರಿಯಡ್ ಇಲ್ಲ.
ನಾವೀಗ ಮಾಡ್ತಾ ಇಲ್ಲ.
I must know if they want a schedule.
No, if you, 1 minute, if you satisfy the court
Please.
that you have 17 orders prior to the search warrant,
Please.
I will vacate the order that I have.
Please. In fact, initially, my lord, while filing source report, lord, assets fund 163.5%. Now it has become, lord, after preliminary investigation, it is 245.27%.
Oh.
I'll produce the document, lord, during next day.
Very rich man, sir.
Yes. Percentage ಅಲ್ಲಿ ಹೋಗೋದು ಬೇಡ ಮೇಡಮ್.
Well, technical aspect will produce the argument.
Right. Patil sir.
Please.
My lords, my name may kindly be deleted.
And registry to delete the name of BB Patil as appearing for the respondent. ಅಲ್ಲಿ ಇವರು ಹಾಕಿದ್ದಾರೆ ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ is on record.
Deeply obliged, deeply obliged.
ಇನ್ ಮಿಕ್ಕಿದ್ರಲ್ಲಿ ನೀವು ಇದ್ದೀರಾ ಇಲ್ಲಿ? ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ ಇದ್ದೀರಾ ಇನ್ನು? ಅಲ್ಲಿ ಹೋಗ್ಬೇಡಿ, ಇರಿ
There in
ಅಂತ.
others, my lords. There in others.
ಇರಿ ಅಂತ ಹೇಳಿದೆ.
Please.
ಇನ್ನೊಂದು 35 ಅವರ್ ಹೆಸರು ಇದೆ, ಅದಕ್ಕೂ ಕೇಳಿ. I will undertake.
ಆಯ್ತು, ಚೇಂಜ್ ಮಾಡೋಣ.
Please.
ಅದ್ರಲ್ಲೂ ನೀವೇನಾ? ಅದ್ರಲ್ಲಿ ನೀವು ಆಯ್ತು.
Obliged.
ಅದ್ ಬಂದಾಗ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು.
ಎಸ್.
16.
Yes, right.
ಏನಿದು?
My lord, is this case, my lord, my right to travel, my lord, is curtailed. If your lordship were to recollect the LOC case, my lord.
Correct. Where do you want to go?
ಏನಾಗಿತ್ತು, there was, due to my oversight, my lord, I had mentioned 2 passport numbers. That's now been rectified. Your lordship may kindly come to page number 12, my lord.
How many passports you have?
ಅಲ್ಲಲ್ಲ, ಇರೋದು ಒಂದೇ, I have surrendered that. I'm filing a memo to that effect also.
ಆಯ್ತು.
It's also a part of the document, my lord.
ಆಯ್ತು, ಏನು?
Leading ಅಲ್ಲಿ ತಪ್ಪಿತ್ತು ಅಷ್ಟೇ. My apologies. Lord, an FIR, my lord, it seems to be filed against me. And also, my lord, I have filed an FIR against the accused number 1 and 2. My lord, the allegation that is leveled against me, my lord, is that I have taken 2 lakh and 3 lakh from a agent, my lord, from a real estate agent. If my lords were to come to page number 40, my lord.
That's the allegation against you?
That's the only allegation against me, my lord. That's the only allegation. My lord, I travel all the way from England, I'm sorry, United Kingdom, my lord, and I will, your agent, 2 lakh and 3 lakh, my lord. That too in cash. In the month of November 2024, and the complaint is, my lord, is filed in the year 2025, after a span of 6-7 months. And my lord, I come to Bangalore, my lord, in the month of November 2025. And my lord, I've been intimated that, yes, there's a lookout circular against you. We are impounding your passport. I have not been served a copy of the LOC also, my lord. I don't know whether there is any LOC till date.
ಎಲ್ಲಿ ಇವರು LOC? ನೀವು?
But so far as the.
ಎಲ್ಲಿದೆ ಕೊಡಿ?
I have to just get
Last time
secure
ತಾವ್
that
ಹೇಳಿದ್ರಿ.
the LOC.
Where is the LOC?
By the next date of hearing, I'll just secure it.
Last time itself I told you.
Please, my lord, I will just secure, still we didn't get it. Next date of hearing, my lord, I'll
madam.
just place
This
it.
can't go on.
Various
Because my lord, the originator will be the.
Originator is the government of Karnataka. Yes, sir.
The originator is.
Various investment, it made them to invest various amounts, my lord.
ಯಾರಿಗೆ?
To the
General public or the complainant?
Then I'll secure that records. Looks like it is something more than what.
No,
just.
ಆಯ್ತು. But if you have hoodwinked general public for investment,
Understand.
we will not spare them.
I understand.
But if it is only between the complainant and this, our investment ಗೆ ಜಾಸ್ತಿ ದುಡ್ಡು
Lordship,
ಬೇಕು ಅಂತ
I would-
ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ?
Lordship, I would Friday, my lord, and I'll place.
Lord, my daughters and my son, my husband, my lord, are there in United Kingdom, my lord.
ನೀವು
I have
ಹೋಗ್ಬೇಕು.
been compelled to stay here from November, my lord, for no
ವಾಪಸ್
reason.
ಹೋಗ್ಬೇಕಲ್ವಾ?
ಅದಕ್ಕೆ, only for that effect.
Stay ಇದೆ. Lordship, I would Friday, my lord.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ?
ಅದ್ರಲ್ಲಿದೆ. ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ.
ಅವ್ರು ತಗೊಂಡಿದ್ದಲ್ಲ, ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀವಿ.
Apologies.
Words matter, sir.
I'm so sorry, madam. My apologies. I take back my words.
Friday, my lord, and I'll.
ಇಲ್ಲ, we'll take it on Tuesday. Let the LOC also come. And if LOC is not produced, I'm going to set aside everything. Heard the learned counsel appearing for the petitioner. The petitioner is unable to travel back to the United Kingdom where her husband and the children are. The allegation is that the petitioner has taken cash from the complainant in the 6 months prior to the registration of the crime. The learned counsel, Alva? The learned counsel submits, therefore the complaint has full of embellishments. The learned additional SPP seeks 3 days time to secure the original records and place it before the court, as the apprehension is that the petitioner or the family may have hoodwinked several general public. In that light, list this matter on Tuesday in the fresh matters list. The learned counsel Swamini is also appearing for the Union of India. Your CGSC.
CGC.
The CGC is directed to place the LOC for a perusal of the court.
Lord, may I make a
If any.
submission? I am required to travel urgently, my lord. If the allegation so, my lord, without prejudice, my lord, and without conceding, I'll
Unless-
deposit like whatever it is, my lord.
No.
Before this honorable court.
Unless I see the investigation papers, I will not. Yes, Tuesday will permit you.
Please.
Yes. Interim order subsisting in the companion petition shall continue till the next date. Yes, next.
17.
Say appear for petitioners. The FIR registered by the respondent Lokayukta under section 13(1)(a) of the PC Act. Notes, it is only due to administrative lapse in the record keeping.
Records.
Investigation.
Notes, the acts of
Investigation papers. Investigation.
You are Chiranjeevi.
yes.
Yes. Notebiಟ್ಟು ಮಾಡು. Friday. Friday. Disproportionate assets ತಾನೆ?
No, my lord.
13(1)(a).
No.
Misappropriation.
What has happened is the government apparently in 1992 bought this land from the erstwhile owners.
All right.
The allegation now, my lords, is that they in connivance with the government officials have got their names reinstituted into the Kata. After the death of one of the earlier predecessor in title whose name had continued in the Kata. Now, incidentally, after that incident, they take an affidavit from him and the Assistant Commissioner Vidayan order cancels that entry. Now, at this point in time, an FIR is registered.
Criminal
saying
misconduct.
Misappropriation.
It's not disproportionate.
It's not disproportionate.
Yes.
1992, there is a clear sale deed.
Note. We'll see. Yes.
By their own admission, 1992, there is a sale deed in favor of the government.
Their own admission, my lords, it is Kata and
ಆಯ್ತು,
RTC.
ನೋಡಿ.
Matter of record.
Yes, list the matter. ಹಾಗಾದ್ರೆ ಒಂದು 3 ದಿನ ಆಗ್ಲಿ. Tuesday fresh matters.
Please.
18.
Yes.
Please, deeply obliged.
Yes. Grandmother.
Yes, my lords. That's one mistake that I have done, my lords.
Grandmother is alive.
Allah, my lords. My lords order dated 9/2/2026, my lords.
What is that order? 9/2/19/2006. Last date of order. Will he come? You give me the will he come separately.
My lords order dated 9/2/2026. The third line, my lords, in the second paragraph.
The grandmother.
Grandmother passed away in 2017. My lords, the ECIR has sprung in 2023. My lords.
Proceedings stood abated then itself.
It's in 2017 proceedings abated. The notice which has been issued contains the file number, my lords.
No, the predicate offense is closed.
Closed. Predicate offense is closed in 2017. On the death, there's an order passed and it is abated. Once it is abated, my lords, 2017, after about 6 years, they open a file, my lords, that the notice may be seen in page 29, my lords. The file number is 38/2023.
Whether abatement will take away abatement.
Abatement takes away, my lords, abatement, the Latin maxim, my lords, for that abatement they say, my lords, a personal action dies with the person, which they use is actio personalis meritus cum persona. So they say, my lords, a person is presumed to be innocent unless there's an order of guilt against him. So if if the death takes place before he is pronounced guilty, then the whole proceeding abates. One judgment we have.
I have rendered a judgment whether abatement will take away abatement. No, that's
yes, my lords.
PC Act there. No.
My lords, could I just point out this?
Mohan had appeared in
Yes.
that.
Could I just
2022.
point out a 2025 decision, what happens on abatement? They fall back on the same Latin maxim to say, he is presumed to be innocent.
Yes.
Now, in our case, my lord,
My lord, first thing is that the challenge is with respect of the summons.
Summons cannot be challenged.
I will.
whole action.
Yes, I will, yes. That particular summons, he was supposed to appear on one particular date, that date has expired. Then my lord, Willel Comma, Supreme Court.
Willel?
Como.
Summons.
The summons.
Cannot be challenged.
Yes, when there was a discharge also, the summons cannot be challenged. That was the order which has been passed by the Supreme Court, my lord. Now, with respect of the question, what is framed by this honorable court, when there is an abatement, my lord, my submission is that, my lord, the provision what is contained in the PMLA Act, more or less the similar provision is available in SAFEMA. My lord, here, unlike in other cases, my lord, the leave had been granted in that case, my lord. Then, my lord, he was discharged from the schedule offense. Then summons was issued. That particular summons was set aside by the High Court, my lord. Then that order was challenged by the department before the Supreme Court. Supreme Court held that it is premature. He has to appear before the authority. He has to cooperate with the agency. And then accordingly, that particular special leave petition was allowed, my lord. So my submission is that, my lord, the same judgment holds good for this particular case. Now, with respect of this particular case, more particularly with reference to PMLA, my lord, I just want to draw
You tell me one.
Yes.
Criminal case was registered, illustration.
Yes, ma'am.
Criminal case is registered in the year 2015.
Yes, ma'am.
All the accused die.
Yes, ma'am.
In the criminal case.
Yes, ma'am.
Some legal heirs are there.
Yes,
holding on to those properties of those accused.
Yes.
They are not aware of anything.
Yes.
After 8 years, you spring into action, saying, we are enforcement directorate.
Yes.
We are armed under the PMLA.
Yes.
So we will summon you.
Yes.
And see if this is proceeds of crime.
Yes.
Correct.
Yes.
You are entitled to see proceeds of crime.
Yes.
So if this is proceeds of crime, 8 years from the children.
Yes. My lord, my submission is that, my lord, in this particular case, this particular children are involved. Children are involved.
Other involvement is
that is the reason why, my lord.
In the name of the grandmother, if everything is done and
Yes,
proceeds
my
of
lord.
crime
That
are
is the
now,
fact. And this is also
is now being enjoyed by the
the complaint from the agency, my lord. That is the KIDB again in this particular. Not with respect of Dharwad, my lord. This
66 reference.
No, not 66 reference. Not 66 reference. This is an independent complaint which was submitted, my lord.
No, how did you get independent complaint registration when there is no predicate offense?
My lord,
Did the KIDB inform you under 66?
My lord, sometime the agency will inform, my lord. Sometime agency will not inform, my lord. There are other websites are there, my lord, which
website will inform?
No, definitely, my lord. There is a fatwa agency is there. The fatwa agency will provide those information. Yes, my lord.
What is that, sir?
My lord, that is the one particular agency which collect all the information with respect of the schedule offense. That particular information will be consolidated and then it will be shared with us.
So which is that extra legal agency?
No, it is not an extra legal agency, my lord. That is the agency which is established under a particular. I will explain, my lord. My lords asked me whether you have immediately on your own registered.
Which agency is this?
FATF fatwa. On that basis, my lord.
FATF fatwa.
Yes, my lord.
FATF is not.
My lord, let me complete, my lord. With respect of the questions my lords have posed, I will explain, my lord. First of all, my lord, with respect of PMLA, it is not only punishing the person who is involved in the commission of the crime, but it is also with respect of the confiscation of the property. Insofar as the maxim with respect of the abatement.
No, in a predicate offense.
Yes, my lord.
That the person should be held guilty.
Yes, my lord.
All right.
Yes, ma'am.
Then you, on that guilt that comes about in a predicate offense, you can confiscate a property after determining that it is proceeds of crime.
No, that is the reason why I will try to explain, my lord. And that is the reason why in Willel, my lord, the Supreme Court did not quash the summons. And the Supreme Court held that it is premature to quash the summons, and he is supposed to.
Well, let's say here the question.
I will explain, my lord. My lords, because I will try to explain because I am trying to draw parallels from the Safema also. Safema.
Who is that?
That is the. I will just.
ಯಾವ್ದು ಸಫೆ ಹೋಮ ಅಂತೀರಾ ಫತ್ವಾ
ಅಲ್ಲ ನಾನು ತಮಗೆ ನಂಗೊಂದು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ರೆ ನಾನು ಹೇಳಕ್ಕೆ ಇದನ್ನ ಮಾಡ್ತೀನಿ ಅಲ್ಲ ನಾನು
ಇಟ್ಸ್ ಫ್ಲೈಯಿಂಗ್
ಅಲ್ಲ ನಾ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ಏನು ಅಂತಂತಂದ್ರೆ this particular proceedings, there are twin object. One is punishing the person as well as the confiscation of the property. With respect of the confiscation of the property, it need not be dependent always upon the conviction of the order. If that particular during the inquiry or the trial, that particular person passes away, then section 8(7) provides that that particular person who is in possession of the property is supposed to appear before the special court and he is supposed to seek for the release of the property. Then the special court is that is the scheme of the legislation,
sir,
my lord.
will it not become draconian?
That is, my lord, that has been challenged. Section 8(7) has been challenged and the constitutional validity has been upheld.
No, that is in a particular circumstance. Constitutional validity is correct.
Yes,
Not a problem.
Yes, my lord.
In cases of this nature, where 10 years in the ella close agid yarno karkon bandi
I request my lords, I request my lords to kindly look into section 8(7), my lord. Section 8(7), which is similar to that of the provision under section 6(1) of the SAFEMA. My lord, I will take my lords through those provisions, then
What
I
is
will
that
try to explain.
SAFEMA?
Yes, my lord, SAFEMA is the smugglers. The provisions are more or less the same, my lord. Smugglers and Foreign Exchange Manipulators Act, 1976. The forfeiture provision, what is provided there, is similar to that of section 8, my lord.
So you want to take shelter under a different enactment to...
No, I am taking shelter under the very same provision. With respect of that, my lord, there are already judicial precedent and I want to rely upon those judgments also.
Yes, sir.
First, section 8(7), my lord, I may be...
PMLA.
PMLA.
Information of an order of sorry.
Where the trial under this act cannot be conducted by reason of death of the accused or the accused being declared a proclaimed offender or for any other reason or having commenced but could not be concluded, the special court shall, on an application moved by the director or a person claiming to entitled to possession of the property in respect of which an order has been passed under subsection 3 of the section 8, pass appropriate orders regarding confiscation or release of the property as the case may be involved in the offense of money laundering after having regard to the material before it.
One nimisha.
Yes, sir.
Now,
yes.
Where a trial under this act cannot be conducted.
Yes, ma'am.
By reason of the death of the accused, one circumstance. Accused being declared a proclaimed offender,
yes.
Second circumstance.
Yes.
Third, could not be having commenced but not concluded.
Yes, ma'am.
On an application moved by the director, so and so pass appropriate
Yes.
orders. Now, how do you reconcile to this fact that there is no predicate offense at all?
Well, whether there is a predicate offense or not, that has to be examined.
No.
Just
Where, 1 minute.
Yes, ma'am.
Where a trial under this act, under PMLA cannot be conducted by reason of death of the accused.
Yes. Now the question is that, my lord, we are at the nascent stage of the investigation. It is not possible to come whether there is a schedule offense exist or not. The schedule offense was in existence and that particular schedule offense, the investigation was conducted and charge sheet has been laid, my lord. And during that particular stage, yes, my lord. And that particular sole accused has passed away.
What's the offense?
My lord,
breach of trust and cheating.
Breach of trust.
Breach of trust, cheating, predicate offense.
406, 420.
When, yes, well, the abatement in 2017.
So my submission is that, my lord, we have to investigate and what is the, who are involved in this, how it has been done. Just because one particular person is, the sole accused is passed away, that particular crime is not vanished.
Oh.
And we are supposed to investigate with respect. Yes, ma'am.
Criminal top seat turvey agoga.
Allah, if it is only an offense, if it is only with respect of that particular person, and if that particular offense is committed, for example, murder is committed, and for that particular murder there is no proceeds of crime. Proceeds of crime is not attached. Only with he has committed the offense of murder. In such an event, my lord, along with him, that particular proceedings would die. But if it is with the angle of proceeds of crime, he has earned money out of that particular commission of the offense, that particular proceeds of crime has to be identified. And that cannot remain in the hands of the legal representative.
Who is the complainant there?
Yes, ma'am.
But the
Predicatally?
KIDB, my lords. Complainant is KIDB in the predicate offence.
What's the allegation?
The documents have been forged, my lord, on the basis of the forgery,
Fabrication,
the compensation has
fabrication.
How
been
much
refunded.
compensation is taken?
Breach of trust and cheating.
Well, how much
16
compensation is taken?
16 crores was the predicate offence.
Hmm.
And what they say now is, my lords, out of that 16 crores, what was there, 50 lakhs came to the grandson. This 50 lakhs, there was an order of attachment and it has been recovered by the bank. Even the so-called proceeds of the crime is not with the grandson at all, even according to the documents which are on record, which has been recognized by the court, coordinate bench.
1 minute. What happened to the 16 crores?
Well, that they will, I don't know. So far as I am concerned, by virtue of orders that are passed,
Is that released?
my lords,
Have to
can I just
investigate,
point
my lord.
out the attachment
1 minute.
orders?
I want to get the fact. Is
My
that
lord,
released?
my lord, earlier also we had issued the,
1 minute.
Yes,
Is that 16 crores released from the coffers of the board to the petitioners?
my lord, in 2024 also we had issued the summons to their family members. They did not appear. This honorable court, they filed the writ petition. That particular writ petition also interim protection was given. In spite of that particular direction, they did not appear.
No, no. Did you receive that 16 crores?
And that,
My lords, attachment order at page 162 may be
Attachment
noticed.
order BD. Now,
Additionally, they specify,
1 moment. 16 crores is the determination of compensation, correct?
yes, my lords,
Correct, Alva?
that so far as the grandmother is concerned.
Correct,
Yes,
whoever it is.
yes.
16 crores is the determination of compensation. The allegation is forgery. Charge sheet was filed. Now I want to know whether 16 crores has been transferred or not.
Transferred to,
Grandmother Itkode.
who is it transferred? To her? She received it. My lords, the allegation is grandmother received that 16 crores.
Ah,
And my lords, she received 16 crores. She gave to various persons is the allegation.
Hmm.
Further allegation now which they say is of them, the present petitioner 50 lakhs was given. That 50 lakhs they have recovered is their entire allegation which my lords would get through the attachment order. But before all this, my lords, before all this, now their contention is threefold, my lords. What I've challenged here is the summons. That is not so. My lords, page
No,
26.
you forget about that kind.
Entire
I will
proceedings.
answer that.
So that is the first aspect. Second is, my lords, Vijay Madan Lal Chaudhary says, now if there is going to be either a discharge, acquittal or quashment, then PMLA proceedings doesn't lie. Now, my lords, a sole accused, 2017, abates against her. The effect of it abating is she is innocent. So we don't have a predicate offense post 2017. Now, post 2017, if there's no predicate offense, how is it in 2023 that ED springs into action in saying we will issue notices? On what basis? You should have a predicate offense. You should have a schedule offense. From 2017, it is not there. So, my lords, Vijay Madan Lal Chaudhary, in my respectful submission, my lords, very clearly covers the situation. Now, if they say predicate offense, they fall back on 2017, they can't. If they have any other predicate offense, they can point it out. But the whole predicate offense is 2017. And 2023, they start the process.
The beneficiary was only the grandmother?
Lord,
In the
my lord,
acquisition?
my instruction,
beneficiary is only
my
grandmother.
instruction is that
She is the accused in the predicate offense.
the grandmother is only a face. All the amount, everything has been created by the family members and
No, no,
thereafter
no.
they have received in their account.
That is not the issue.
And my lord, the technical closure is no closure. The offense is not wiped out. The offense is still in existence. Just merely the demise of a particular person, the offense is not wiped out.
You mean to say demise of the sole accused would not lead to demise of the criminal case?
The criminal case may come to an end because of the death of the person. That particular lady cannot be punished, but the offense is not wiped out. And in such
Offense
an
is quay the lady.
that is what I'm trying to explain, my lord. If it is only an offense,
If the charge sheet had been filed against any other accused,
No.
you tell me.
my lord, the charge sheet has been filed only against that particular lady. I agree with that, my lord. Now the question is that, my lord, whether the offense is in existence or not is the question.
Offense cannot hang in thin air. It is quay someone else. That someone else goes. Would not the offense die with someone else?
No, my lord. That is what I am trying to explain, my lord. If the confiscation of property is involved, my lord, in such an event, my lord, proceedings would continue. And then, my lord, that is what the section 8(7) speaks about.
You can confiscate.
That is the legislation, my lord. That is how it has been worded. And there was a challenge with respect of that.
This forgery, yes, definitely needs
My lord,
examination.
with respect of SAFEMA, my lord,
Is
SAFEMA will not
fatwa
come
bada,
here.
wait.
PMLA is dependent on a schedule offense.
The
PMLA stands
object
on
of
a
both
very
the
different
legislation are
footing.
the same, and the provisions from, there is certain provisions which are akin to the SAFEMA.
Adella, I will not.
Well,
do.
it's for
Now, on
P-
the basic things, you convince the court whether the offense.
My lord, I may be permitted to place this particular judgment and refer to some of the facts which are similar to this particular case.
Is umbilical cord da.
Illa, this is separate.
Oh.
This is under SAFEMA. I request my lords to kindly take.
Is the interplay between SAFEMA and PMLA?
That has not been considered.
No.
My lord,
Schedule offense.
I'm trying to explain, there was also a notice was issued, and when the notice.
We'll see.
My lords, 2025 ruling which I have given Rajasthan, kindly notice paragraph 4, my lords. That was a case where charge was framed in the predicate offense. My lords, has that today we gave it to the memo.
Lakshman Singh.
My lords, in this paragraph 3, they lack, and paragraph 4, what is the effect of it? Kindly notice, my lords, as per the principles of criminal jurisprudence, until the guilt is proven, every accused is presumed innocent. Herein, now, my lords, 2017, when death takes place, it abates, predicate offense goes. How can they have PMLA in 2023? They can't say, my lords, after 7 years, we have come to know that there's some proceeds of crime. That is not how PMLA works. It works on schedule offense.
My lord, in Villel Como, my lord, the Supreme Court has considered this. He was discharged from the schedule offense, and thereafter summons was issued.
My lords,
and in such circumstances also, the Supreme Court held that it is premature.
My lords,
that is
in Kamo's
that is how
case,
the Villel
kindly
Como has
notice
been
the very first paragraph. It was not a case of abatement.
No, it was a discharge. It was a discharge. Even if he is discharged from the schedule offense, the Supreme Court says that summons can be issued.
Please notice what they've held there.
It was a case of discharge.
They restrict themselves to the point of law in summons. That's the only point.
Here
which
also
they
the
consider.
question involved is summons. And the summons is under
Here,
challenge.
my lords, in my
And that
respectful
event has
submission, we
completed.
don't have a predicate offense. Forget discharge.
He
One
has been
person getting
discharged. He
discharged
was
later.
discharged. And in spite of that, my lord, the Supreme Court says that it is at the nascent stage. The investigating
So, my
agency
lords,
should be
after
allowed to
7 years,
continue with the
anything they do,
proceedings.
they can't say it's in the national state.
That
2017
is how it
predicate
has been
offense has
interpreted by
gone.
the
After
Supreme
7
Court.
years, you issue notice and say we're still in the preliminary stage. No way. That schedule offense itself is not there.
Wednesday, 4:30 will dictate. Heard the learned senior counsel Sandesh Chowta appearing for the petitioner and objections in Badwa.
I want to file objection, my lord.
You
I
want,
need some-
ಮತ್ತೆ again stay ಕೊಟ್ಟಿದ್ದೀನಾ?
For consideration of stay, it was
I
posted.
will file my objection.
Anyway, matter requires consideration for abatement, my lords. Let there be an interim order protecting.
My lord, the question of interim order does not arise. The reason is that challenge is with respect of summons.
No.
And
We
that
have
particular
challenged the
event
entire
has.
proceedings.
that-
Page
the
26.
ECR cannot be
first
challenged.
Sir, summons cannot be challenged.
No.
ECIR cannot be challenged.
And
That's the law, sir.
all the judgments, my
That's
lord.
the
Here,
law.
all the
Division bench
matters where
judgment,
quashes
everything.
That's the law,
have taken
sir.
place has to
Yes,
go,
my
my
lord,
lords.
that is what, that is how it has been interpreted by this court. This court has also interpreted it.
Then
And
we
this
can't
is what
come
we
to
are
the courts
arguing.
at all.
That's the law.
We can't
Not
come to
the law.
courts.
That is how it has been interpreted by this court.
No, law in the sense as interpreted by the court division bench. Justice Kameshwar judgment.
Alladu summons ಬಗ್ಗೆ ಇತ್ತು, summons ಬಗ್ಗೆ. But when the proceedings are challenged, it's always open for the court. And here I've challenged the proceedings. My first prayer in page 26A.
I think ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಒಂದು ವಾರಕ್ಕೆ ಏನಾಗಲ್ಲ.
Alla, but let's state because a matter on abatement, if it has to be considered, they want to file their
Let
objections.
them file it. Yes.
I will file objection,
there-
my lord,
let
but
there be
only
a
thing is
ಒಂದು
that
ವಾರ. I'll take it on 20th. By then if you don't file, I'll grant an interim
21st, my
order.
lord, 20th, I have some difficulty.
21st,
Yes,
ಇದಿದೆಯಲ್ಲ.
20,
Saturday.
any other date, my lord, except
22nd.
20. Yes, 23rd.
23rd
But
Monday.
21st is a working day.
It's a working day,
Yes,
21st.
21st.
21st. List on 21st. After that, arguments are over, I'll take it. It requires an answer.
Yes, but and also a very dangerous proposition. Anything that is closed any point of time, ED can say today we'll start proceedings. It's going to be
Let's see.
very, very dangerous, my lords. The whole concept of schedule offences will
This
go.
is not considered by any court?
No, my lords. No.
No, there are no precedents
Directly on the point, my
on
lords.
abatement.
On abatement, only the interpretation of what
No,
it amounts to.
abatement que PMLA.
No, we don't have that.
I'll see. Yes. 21st.
21st.
If there's any problem, If there's any problem, you move the matter, don't worry.
My lord, the summons has been issued. He was supposed to appear on 26th. Earlier, 2024 also we had issued the summons that was challenged before my lords. It was
Again, I
listed
think-
before the Dharwad bench.
That is
No, no,
father.
that
My
is
lords,
father.
can I
That is what
point
I'm trying
out?
to
So
explain.
Dharwad bench.
In Dharwad bench also I had appeared before my lords. I have
Many a
argued.
time you
Sir,
appeared.
yeah, no, the Siddharth summons, some.
That
used
was to
appear
the
in that
father,
matter.
my lords
And
said,
my lords
let him
specifically
participate in
directed-
investigation.
Specifically directed him to participate in the investigation.
My lords, I
In
will
spite of that, he did
ಏನು
not.
ಹೇಳಿದ್ರು ನೀವು? ಏನದು?
The Siddharth Suman used to appear in this
That's-
matter.
ಹಾ, ಸರಿ, ಸರಿ. All right.
In fact,
ಏನು ಬೇರೆ ಏನೋ ಕೇಳಿ.
ಅಲ್ಲ ನಾನು ಹೇಳಿದ ಅವ್ರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅದ್ರಲ್ಲಿ ನಾನು ಅಪೋಸ್ ಮಾಡಿದ್ದೆ ಅಂತ and then my lords directed him to participate in the investigation. In spite of that, there was no participation.
That's the father,
Not
isn't it?
me, my lords.
Yes,
Not the
that
petition.
particular order is also placed in this particular
ಆಯ್ತು,
compilation.
21st.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದೇನು ಅಂತಂದ್ರೆ
ಅವತ್ತು
ಸಮನ್ಸ್
ಹೇಳಿ.
ಇಶ್ಯೂ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ ನಾವು
ಅಲ್ಲ, ಅವತ್ತು
ಇನ್ನೇನ್ ಬೇರೆ
ಹೇಳಿ.
ಏನಿಲ್ಲ.
Summons issue ಮಾಡಕ್
ಪೂರ್ತಿ
ಬರುತ್ತಾ?
ಅವತ್ತು ಹೇಳಿ.
In the first place.
21st, yes.
19?
Lords, if there is any difficulty
If there's
before
any
that, we will.
difficulty, you move the matters, no problem, yes. Which is the first FIR?
Lordship may see this. In fact, the subsequent FIR
Annexed
has been
H1,
clubbed with the original
page
FIR.
121.
Connected matter is there. And it can be placed along with,
Tag the petition along with
and we have clubbed the, in fact, clubbed the FIR.
ಅರುಣ್ ಜಿ ಅಪಿಯರ್ ಆಗ್ತಿರೋದು, ಅದ್ಯಾವ್ದು?
Same, arranging ಕೂಡ same.
ಇಲ್ಲ, ಇದು ಅರುಣ್ ಅಪಿಯರ್ ಆಗೋದು 9, ಇದೇನಾ?
ಅಲ್ಲ. This is different.
ಸೀಲ್ ನಂಬರ್ 18 ತಾನೆ?
19, serial number 19.
19, so and so. Tag the petition along with so and so. In the light of the interim order subsisting in the companion, interim order there.
ಇದೆ ಅದರಲ್ಲಿ there is direction to continue further investigation in CC.
Whatever is there.
Yes, same order.
Yes. In the light of the interim order of the kind subsisting as granted by the coordinate bench, the similar order would govern this case as well till the next date of hearing. The order dated 18/11/2025 reads as follows. Yes.
In any way, the FIR is not exist because we have clubbed the FIR with the other FIR.
Clubbing is permissible.
I placed the order also, my lord.
We'll see. Anyway, order ಇದೆಯಲ್ಲ, club ಮಾಡಿ we'll close it then. ಇವ್ರೇನ್ ರಿಲೀಸ್ ಮಾಡಿದ್ರಾ?
20?
Yes, ಅರುಣ್.
Please.
ಏನಾಗಿದೆ?
I have one
ನಿಮ್
submission.
ತಪ್ಪಲ್ಲ ಇದು, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್.
I know.
ಓರಲ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಯಾರಾದ್ರೂ ಒಳಗಾಕ್ತೇನೆ.
I have one
I
additional.
concede. ಪಾಪ next day ಅವ್ರು is elaborately written.
ನೆಕ್ಸ್ಟ್ ಡೇ ಬರೆಯಕ್ಕಾಗಲ್ಲ ಸರ್.
ಮಧ್ಯರಾತ್ರಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು.
ಯಾವಾಗಾರು ಮಾಡ್ಲಿ. 2-2ಗೆ ಒಳಗಾಕಿ ಅನ್ಬಿಟ್ಟು 3-2ಗೆ can you release the order? Oral instructions ಮೇಲೆ ಒಳಗಾಕಿ ಅಂದಂಗ ಆಯ್ತದೆ. Then it's not
Liberty of a citizen.
then
I'm not commenting on that. ಈ ಮುಲಾಡ್ ಒಂದ್ ಏನಾಗಿದೆ? ಇದರಲ್ಲಿ now this order has
I
spent
have one
itself.
submission.
Let me
Before,
just,
please. sir.
ಆಯ್ತು ಹೇಳಿ.
this order has spent itself. Now your lordships have intervened and
Yes,
he
he's released.
He is released.
All other statutory remedies will be available.
Open. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಒಂದೇ ಮಿನಿಟ್ ತಮ್ಗೆ.
ಏನಾಯ್ತು?
This is the original. A letter comes to me. I am the complainant in this case. A letter comes to me by a unsigned letter. Now this letter is deposited by the Blue Dart company into my house.
ಅದೇನ್
ಇದ್ರಲ್ಲಿ ಏನು-
ಇವ್ರದೇನಲ್ವಲ್ಲ.
ಅಲ್ಲ ಇವ್ರದೇ ಲೆಟರ್. ಏನಾಗಿದೆ ಈ ಲೆಟರ್ ಮೇಲೆ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಆಗ್ತೀನಿ. Somebody is extorting me for 6 to 7 crores ಅಂತ. ಈ ಲೆಟರ್ ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? I am a weapons dealer. You give me 6 to 7 crores ಅಂತ ಹೇಳ್ತಾರೆ. ಇದಾದ್ಮೇಲೆ ಏನಾಗುತ್ತೆ? They trace the person who delivered it in the Blue Dart. That person says that this person, the accused, he has given him this letter. He has drafted it and he took it from a computer. All of this is seized.
Circumstance that came before me was that an arrest is directed, police custody is directed on an
Without
oral
an order.
Without an order. That I have found it to be illegal. Now I will set it aside and leave the statutory remedies open.
But there is one other on, though the score, on the score of order being illegal, rightly, which has been, in fact, the petitioner was lettered free. If your honor may kindly appreciate page 51. They, in the remand application, they concede that 35(3) is not served.
All that
They concede. 51, for a
ಏನಾಗಿದೆ?
moment if it is seen. Sir, I will complete, sir, please, sir.
Around mostly that.
They say that on one day they go, they say that his house is not traced. Second day they go, his house was locked, his phone was not reachable. Third day they pick me
One
up.
moment.
Please.
You mean to say complaint springs from on this
From this
communication?
ಅದು ಇದಕ್ಕೆ ಹಿಸ್ಟ್ರಿ ಏನಂದ್ರೆ ಇದಕ್ಕೊಂದು ಹಿಸ್ಟ್ರಿ ಇದೆ.
ಆಯ್ತು, ಹಿಸ್ಟ್ರಿ ಅಲ್ಲ,
ಅದ್
ಅದ್ರಲ್ಲಿ ಬರೀ
ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಮಿಸ್ಟ್ರಿ ಇದೆ.
ಅಲ್ಲ ಅಲ್ಲ.
And one
ಒಂದೇ
other
minute.
aspect, Your
ಏನಾಗಿದೆ?
Honours, on the last occasion, in
ಆಯ್ತು,
fact, there was a
ಮುಗಿಸ್ತೀನಿ.
direction.
ಒಂದ್ ನಿಮಿಷ.
On the last occasion, there was a direction in respect of connecting that other matter. Why this whole object of FIR being registered? Criminal
Which other
petition-
matter?
No, in fact, no, though this is a matter pertaining to where arrest being illegal. The court, in fact, expressed, somehow it has not come to the order sheet, saying that where this petitioner is targeted for the sole reason that he is a friend of a victim who has filed a complaint against
ಏನ್
a
ನಾನು ಆರ್ಡರ್ ಬರೀಲಿಲ್ಲ.
Please, no, in fact, the court expressed it, but it has not.
Expressed ಅಷ್ಟೇ.
Please. So in that context, what I would request is that if that matter is also taken up, the real facts would also.
Matter is that.
That is in criminal petition 15085.
This has nothing to do with
In
that.
fact, the state also very fairly submitted, there was a direction, oral direction in that earlier matter where this first informant was not to trouble the victim in any manner. Now.
No, in fact, senior counsel was there.
ಇವ್ರು ಆ ಕಡೆ ಇದ್ರಾ?
ಇವ್ರು ಆ ಕಡೆ ಇದ್ರು. Court was directed.
ಟ್ಯಾಗ್ ಮಾಡ್ಬೋಣ.
ಅಲ್ಲ ಅಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ. ಏನಾಯ್ತು, ಐ ಸ್ಪೆಂಡ್ ಮನಿ ಆನ್ ಅ ಗರ್ಲ್ ದಟ್ ಇಸ್
ಅದು ಗೊತ್ತಾಯ್ತು. Very on that.
we spend money, about 3 crores I spent. That girl she was moving around with this boy.
I completely opposite, my lord.
They
cannot say.
Story ನನ್ನ version ಹೇಳ್ಬಾರ್ದ.
Yes.
ಸದ್ಯ what I am suffering he doesn't know. That is my client. So
ಅಲ್ಲ, ಕ್ಲೈಂಟ್
Same here, sir.
not him, his client. So then what happened, she used to go, I used to give her money to go to South Africa, idu wild safaris ella.
ವೈಲ್ಡ್ ಸಫರ್ ಆಫ್ ಮಾಡಿ ಸರ್.
I was innocent. I didn't know. She used to go with him, taking my money. Not only wild safari, other places. Then I objected to him, and very serious objections. There was a promise to marry. All that part. What happened? She said that somebody had given a letter against her, saying that making allegations against her, and that I was that somebody, and she got a case filed. That case, what has happened? The case was registered.
ಅದು ಕನೆಕ್ಟೆಡ್ ಮಾಡ್ತಾ.
ಇಲ್ಲ, that case was registered. Our case registered ಆದ್ಮೇಲೆ I came out in the open and said that ಅದು bailable offense ಇದ್ರು LOC ಹಾಕಿ ನನ್ನ ಶ್ರೀಲಂಕಾ ಇಂದ ಬಂದಾಗ ಇಟ್ಕೊಂಡು ಹೋಗಿ ಯಾರು ಅಲ್ಲಿ ಮೋದಿಗೂ ಮಾಡಿಲ್ಲ, ಅಂಬಾನಿಗೆ ಇವ್ರಿಗೆ ಕಲ್ಯಾಣ ಮಾಡಿಲ್ಲ, ಹಂಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ನನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಎಲ್ಲ ಆಲ್ ಸಾರ್ಟ್ಸ್ ಆಫ್ ಹರಾಸ್ಮೆಂಟ್ ವಾಸ್ ಮೀಟೆಡ್ ಔಟ್. They did that. ಆದ್ಮೇಲೆ I was wondering who has given the letter against her, because I had not given any letter against her. ಆದ್ಮೇಲೆ ನಮ್ಮ ಪಡೆದಾಗಿದ್ದ it became state news. Arvind Reddy has been harassed by the state news. In the meantime, what happened? He sent this one day unsigned cover came with this letter. Immediately he gave a complaint to the local HM police station asking this as to address. ಯಾರಿಗೂ ಇದರಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ, ನೀವು ದಯವಿಟ್ಟು ಎಲ್ಲ ಮಕ್ಕಳು ಈಗ leave this lady also, she Kapata, and leave this Nisha. This entire 5 to 6 crores delivered tomorrow morning. We will see that all this is settled. And then we understood this is being done as part of a larger scheme to extract not only the 3 crore, but again another 6 to 7 crore from the extract. This is being done. We tried to trace where is this letter come from. In the blue dot, they got out of a boy called Shashi. Then he was brought. He was the employee of Vaishak. And they said, deliver this money in a certain workshop. This Vaishak is running a workshop, car workshop. Then we took a print. He narrated how this came. It was sent from his mobile phone. And he is the architect of all this. Incidentally, but a previous yaro consider the Rishi Kapanda that lady. ಅದನ್ನು ಇವರೇ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದು ಮೆಟೀರಿಯಲ್ಸ್ ತಗೊಂಡು.
Anyway, now ಯಾರು? No. That, see, if the matter is sub judice, all of you will not do that.
My lord.
That should stop. That we will not encourage. When the matter, see, I'll tell you, when the matters are before the court, it should be before the court. You should not Plurge it everywhere.
It might
That
be, my
we'll
lord,
see.
my lord, I am in fact filing on, I am filing an affidavit, my lord, of the petitioner as to what transpired in the police station. They asked that person to come to the police station. They scold me. I'm putting it in affidavit, my lord. I'm putting it in affidavit.
ಒಂದ್ ನಿಮಿಷ.
Please.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಪ್ರೀತಿಯಿಂದ ಮಾತಾಡ್ತಾರ?
ಅಲ್ಲಲ್ಲ, not first informant ನ ಕರೆಸಿ ಮಾತಾಡೋದಲ್ಲ. The person who is, in fact, even the victim is called. Even the victim is called. I'm in fact filing the affidavit to that effect as to what transpired. What was the whole object for breaching 35(3)?
ಈಗ ಅದು ಟ್ಯಾಗ್ ಮಾಡೋಣ.
ಮಾಡಿದ್ರೆ let it be tagged. Let it be tagged, my lord, so that even the victim will be before the court, if at all, if she has, so that all facts are before the court. All.
What? All right, anyway, that we'll see. ಇದು ಈಗ ರಿಲೀಫ್ ಏನ್ ನೀವು ಕೇಳಿರೋದು ಇದ್ರಲ್ಲಿ?
My lord, first is to quash the impugned order. Two is,
ಆಯ್ತು, ಕಾಸ್ಟ್.
ಅಲ್ಲ, second prayer is to initiate the disciplinary action, my lord.
Against whom?
Against all the persons who are responsible, especially respondent police, where 35(3) is not complied. The offense punishable is less than 7 years. In fact, up to 7 years. That has to go on, my lord.
35(3) ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಾ ಇವ್ರಿಗೆ? ಏನೂ ಕೊಟ್ಟಿಲ್ಲ.
Their remand application concedes.
ಕೊಟ್ಟಿದಾರಾ ಇಲ್ವಾ?
The remand application concedes.
ಇದೇನಿದು ಅದರದೇನ ಇಲ್ಲ ಇದು?
Just to show, because he claims that he's in page 42, he claims that he's an advocate. The first informant claims that he's an advocate. Respondent number 2.
ನೀವೇನು?
I run a garage.
Garage?
Please. I run a garage. I have a workshop. I'm a married person. I'm a married person. And in fact, page 26, victim takes my name. Because he is my friend, this person is targeting this person also. Page 26, victim takes my name.
Promise to marry? ಅದು ಬಂದಿಲ್ವಾ? ಆ ಕ್ರೈಮ್ ಬಂದಿಲ್ವಾ? ಸೆಟ್ಲ್ ಅಲ್ಲ, ಸೆಟ್ ಆಫ್. ಅಲ್ಲ, ಇದಾಯ್ತು. You avail of all statutory remedies that are available. ಈಗ ಇದನ್ನ ಕಾಸ್ಟ್ ಮಾಡ್ತೀನಿ ನಾನು.
I'm placing the affidavit, my lord, on record as to what transpired in the police.
ಆಯ್ತು, I will record that, not a problem.
Please.
But will permit you to avail of such remedy, even challenge to 35(3), whatever it is.
Please.
Now you are set at liberty.
Please.
Yes.
And prayer number 2, my lord, as to initiate disciplinary action, direction, my lord. Because on the face of it,
Against policeman?
Please, because Satyendra and.
One minute, who is the SHO?
My lord, I've been told that they've made an attempt. According to me, the law mandate that register post has to go if they're not available. That is not been done.
Where are the SHO is present? She is the SHO or what? Station house officer?
Sub-inspector.
Which station?
HL police station, sir.
HL police station. ಅಷ್ಟೊಂದಿದೆ, ಮತ್ತೆ ಏನ್ ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ? 35(3) notices were not issued?
Sir, 2 times ಕಳ್ಸಿದ್ವಿ ಸರ್, ಅವರು ಎಬ್ಸ್ಕಾಂಡಿಂಗ್ ಇದ್ರು ಸರ್.
Self-serving statement in the remand application saying that one sari ಕಳ್ಸಿದ್ವಿ ಸಿಗ್ಲಿಲ್ಲ, ಎರಡನೇ ಸರಿ ಹೋದ್ವಿ ಫೋನ್ ಸ್ವಿಚ್ ಆಫ್ ಆಗಿತ್ತು, ಥರ್ಡ್ ಟೈಮ್ ಸಿಕ್ಕಿದ್ರು.
That is recorded. If you are
no, third time they say, third time they meet him, they arrest him. How it is possible? Within a span of 2 days.
That also is incorrect. See, once you serve 35(3) notice, if it does not appear and not cooperate with the investigation or whatever questionnaire, whatever it is, then you can arrest. Power of arrest cannot be while serving a notice under 35(3). What is this?
So there is one misconception, my lord. Since up to 7 years mandatory serving notice. According to me, it is not mandatory. Your lordships also held. It is not mandatory. You can record a reason and then you can arrest them. There is a misconception among police saying that no, we'll have to serve a notice, so we'll serve a notice and then arrest him. That is not correct, my lord.
That is not correct at all. You serve a notice. If it does not appear and cooperate with the investigation, you definitely take him into custody. That's not an issue.
Lord, in fact, once a notice is issued, that is also an inference saying that the IO has made up a mind that notice is sufficient at the initial stage. They have formed the opinion to serve the notice.
Who is
It
the
can't
IO?
be said that it is a misconception.
You are the investigating officer?
Sir, half of the investigation I have done, sir.
Half.
Arrest and all.
Inspector is the investigation officer. She is a sub-inspector. Your Lordship, I'll keep my present.
One
Is all
other
this.
Respondent number 4. Respondent number 4 is the IO.
ಇನ್ಸ್ಪೆಕ್ಟರ್ ಬೇಲ್ ಮೂವ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಅದಕ್ಕೂ ಸಂಬಂಧ ಏನು ಸರ್? I am on the ground of.
I think Your Lordship may have to settle my lord. I think.
No, this something is needed, yes. You can't arrest like that. Arrest cannot, ಆತರ ಎಲ್ಲ arrest ಮಾಡಿಸ್ಬಿಡ್ತಾರ.
I have expressed my displeasure. I told them that what is done is not correct. Should have been, procedurally should have been followed.
No, after that I come before the magistrate. I place your honor's judgment in that Tauragi. I place that judgment, it is recorded. Even then the magistrate authorizes.
No, that is an illegal
on a
order on
different
the
score.
face of it.
No, because I have placed that judgment.
Unknown.
I placed that judgment.
Nobody should even support that order. Tomorrow you may be that side.
There should be a written order.
ಇವರೇ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಆ ಕಡೆ ಹೋಗ್ಬಿಟ್ಟು ಆಮೇಲೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್.
Records that I placed that order.
2 ಗೆ take him into custody and but 3 to order break ಆಗುತ್ತಾ? What sort of court is this?
That day,
Magistrate should not behave like this.
let it now go.
Open court ಅಲ್ಲಿ ಆರ್ಡರ್ ಬರೆಯಕ್ಕೆ ಏನಂತೆ? ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ಕೊಡಕ್ಕೆ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಬರೀಬೇಕು ಇಲ್ಲ ತಕ್ಷಣ ಮಾಡಬೇಕು. 2ನೇ ತಾರೀಕು ಒಳಗೆ ಟೇಕ್ ಹಿಮ್ ಇಂಟು ಕಸ್ಟಡಿ ಅಂದ್ಬಿಟ್ಟು 3ನೇ ತಾರೀಕು ಸಾಯಂಕಾಲ ಸೈನ್ ಆರ್ಡರ್ ಬರೆದ್ರೆ?
We are not here to justify. We wish the magistrate had recorded it.
You should have recorded everything then.
A, there is a violation of not serving the notice. B, I go before the magistrate. Even there I am not protected. Even on, no, who is running away? Who is running away?
He will cooperate with the investigation, there can be no doubt about it. But investigation or the initiation should be in accordance with law. 35(3) does not empower arrest without the accused not displaying non-cooperation with the investigation. 35(3) is meant to serve a notice, it is not take him into custody.
Page 66, I write a letter to commissioner.
ಒಂದ್ ನಿಮಿಷ, non-cooperation ಹೆಂಗ್ ಹೇಳಿದ್ರಿ? ಬಂದ್ರ ಅವ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ? ಅಲ್ಲ, ಅಬ್ಸ್ಕಾಂಡಿಂಗ್ ಅಂತ ಹೇಳಿದ್ರು. ಸಿಕ್ಕಾಗ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೋಟಿಸ್ ಸರ್ವ್ ಆಗ್ಬೇಕು, ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬನ್ನಿ ಅನ್ಬೇಕು, ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಕರೆಕ್ಟ್ ಕಸ್ಟಡಿಗೆ ತಗೋಬೇಕು.
FIR was registered on 24/1/2024. Arrest is on 2/2.
And 30th I write a letter to the commissioner. 30th I write a letter to the commissioner.
ಎಲ್ಲ ಕಡೆ ಓಡಾಡಿದ್ದಾರೆ.
10 days later.
No, 30th I write a letter to the commissioner as to what is the mischief which has been adopted against.
I am not on all that.
No, I am ready to cooperate. It is not about that.
On merits of the matter, he will cooperate with the investigation. There has been procedural aberration, no doubt about it. Adikke we will, anyway he is out. We have to pass the order with regard to the magistrate writing that. And all statutory remedies I will make madhyana dictate ಮಾಡ್ತೀನಿ.
Please.
2:30 ಮಾಡ್ತೀನಿ.
ಏನಾಗಿದೆ, that informant, the post courier boy who delivered the courier, as soon as he was apprehended, he notified him and therefore he switched off and ran.
These are all managed.
merits
Senior is speaking from the remand application, how they have
investigation
employed
madli,
the-
let the investigation go on. But madhyana will pass some order.
Please.
Because magistrates
My
will
lord,
not behave like.
My lord,
Wholly incorrect.
I may have to put this submission very categorically.
Ah.
In the pretext of calling me to the investigation, because that is the reason I'm placing it with the affidavit. 6th, when this honorable court passed the order, what they do? By that time, the first informant, respondent number 2, this victim, he's called in the police station. In the chambers of inspector, they say, Kaliduko, plead saying that you don't interfere in the lady's life. After that, what transpires in the entire television, they show petitioner in such a way that this person, a married person, is behind this with this lady and colluded with this lady to exploit this person. And the order of this court is not published anywhere. I have a grievance for that. I will certainly adopt it. But how it is been projected with the power what the respondent number 2 have? Please,
answer.
Please.
Purely on what the scope of the petition is. ಅಲ್ಲ ಆಯ್ತು.
ಅವರೇ ಮಾಡ್ಕೊಂಡು. He has invited.
ಅಲ್ಲ, if he is conceding yes ಇದು ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ I don't have to say anything. He is conceding saying that yes it do take place. ಅಲ್ಲ ಅವರೇ ಒಪ್ಕೋತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ saying that yes police station ಎಲ್ಲ ನಡೆದಿದ್ದು ನಿಜ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ ಇಲ್ಲೇ ಹೆಂಗಾದ್ರೆ police station
he is conceding to it.
All right.
He is conceding.
He should not have interfered with any of this.
All right, we'll see.
Even respondent number 2 for that matter. Respondent number 2 for that matter, even respondent number 2. ಸರ್ ಹೇಳಬೇಕು ಅನ್ಸುತ್ತೆ. ಸರ್ ಹೇಳಬೇಕು. ವಿವೇಕ್ ಸರ್ ಹೇಳಬೇಕು.
That of course, it has hurt you.
Into the records of that case, I can't say that it was illegal or
It's not only saying that's possible to do it.
Humiliated, and for 3 or 4 days, this became news.
And he circulates the
It is because of misinformation planted by this accused that day. And now it is being praised that they allege that I wrote a letter against her for which he gave a complaint. That letter also was brought in by this part.
I could not 230 class. 130.
But 230 against.
That one I will pass it.
Please.
And only on the, I will pass orders on the merit. Screenplay, story, line.
Investigation.
It's already well screened and already partially executed.
Yet to release. Yes.
21.
Milord, some inconvenient senior counsel.
I also need to
Not-
file my counter. It's a disproportionate asset case.
No, correct.
Where
But
the
I have
source
gone through the
inform-
papers. Everything is declared.
My lords, let him present it before the investigating officer. For all I know, he may file a B report.
Everything, we reported ನೀವು.
ಯಾಕೆ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿಲ್ಲ
ಆಯ್ತು,
ಇನ್ನು.
ಯಾವಾಗ ಬೇಕು?
ನಾಳೆ.
I'll file a counter also.
ನೋಡಿ, ಆಗತ್ತಾ?
Please, my lords.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ನಾಳೆ ಬೇಕಂತ. We'll see
ನಾಳೆ no.
tomorrow. ಆಯ್ತು, you counter ಏನ್ ಹಾಕ್ಬೇಡಿ. You just be present ಅಷ್ಟೇ. Yes,
Please.
tomorrow.
Grateful.
Obliged.
Admission 22.
CCTV,
ಅದು.
please. Appearing for art.
No adjournment, please. Yes, ಕೊಡಿ.
Due to some personal.
No, any
inconvenience,
personal inconvenience, no adjournment.
A small adjournment.
No,
would be
madam. Last time itself, I have passed an order that it will not, in the event learned counsel would not make submissions, the petition would be disposed on hearing the petition. Yes, yes, madam.
Your Lordship, this is a matter wherein Your Lordship asked against A7, order came to be passed, confirmed by the Honorable Supreme Court. And that was one of the worst of case. In these, they were not even present on the, at the spot, Your Lordship.
The-
Lordship's orders also,
The petitioners, I've heard it enough and more, yes. The petitioners are before this court calling, you want to argue still?
no, not at all.
The petitioners are before this court calling Ibridara Obra. Obrena?
Your Lordship,
One sole
three
petitioner?
three of them, Your Lordship.
The petitioners are before this court calling in question proceedings in CC 51315 of 2021, the 2021 arising out of crime number 638 of 2021 registered for offences punishable under section 447, 506 and 34 of the IPC. Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner, and what's her name?
I'm the proxy counsel.
Who is the counsel on record? Yes, so and so representing the respondent. The proxy counsel appearing for the respondent seeks time yet again. This court on 6/2/2026, owing to the fact that the respondents have gone on seeking adjournment for 3 years, had 3 years, 2 years, 2 years, had passed the following order. Even today, a proxy counsel is put forth to seek an adjournment in the matter. Therefore, in the light of the earlier order being conditional, the matter is heard. The learned senior counsel, Srimati Lakshmi Iyengar, appearing for the petitioner, submits which accused was that?
As against A7.
Accused number 7 had quashed the proceedings in terms of its order dated for September the 1st, 2023. The very complainant had tossed the said order before the apex court and the apex court has rejected the special leave petition so filed by the complainant against the order of this court dated 1st September 2023. The learned senior counsel further submit that the petitioners in the case at hand are accused number, more petition idea.
1 to 6, Your Lordship.
Petitioners 1 to 6.
Please.
Petitioners 1 to 6. Sorry. ಇಲ್ಲಿ ಒಬ್ರೇ ಕಾಣ್ತಾ ಇದ್ದಾರೆ. Petitions more ಇದೆಯಾ? These petitions are accused 1 to 6. All the allegations of criminal trespass and the other criminal trespass and 506 of the IPC was against the 7th accused, whose petition this court has accepted and quashed the proceedings. The learned senior counsel would further take this court to demonstrate that there is these petitioners were not even present on the alleged date of the incident, as it was the CCTV footage that led the 7th accused to be drawn into the web of crime. The present crime is registered only to wreak vengeance against these petitioners by the complainant.
Your Lordship, 4, 5 and 6 have not gone to the property. 1, 2 and 3, that is the wife and parents. They are there.
Accused
This is
4,
their
5
own
and
property.
6 were not even present at the alleged scene of crime. Accused 1, 2 and 3 are
The wife and parents whose house it is.
the wife and parents who did reside in the house. The learned senior counsel submits that the wife and parents who were residing in the said house.
This is the matrimonial home.
1 minute. The wife and parents who were residing in the matrimonial house cannot be said that they have trespassed into their own house.
Parents don't reside there, but they come to their daughter's home, Your Lordship.
Whatever, it's their house, yes. Cannot be alleged of trespass into their own house. That's a submission, you see. We'll tweak it. The learned additional charge sheet ಆಗಿದೆಯಾ?
Charge sheet.
ಆಗಿದೆಯಾ? The learned additional SPP.
In this matter, after the charge sheet's also done, 2021, when they go to Supreme Court as against Your Lordship's order, since it's dismissed, they mischievously add that as against the others, further investigation can proceed. Honorable Supreme Court is unaware of the matter. Misusing, and Your Lordships had stayed these orders, yet they went before the police and tried to get a reinvestigation done. And that also Your Lordship had observed in an earlier order.
All right.
Please.
Yes. The learned additional SPP would however submit that there are, the charge sheet has been filed against these accused for offences punishable under 447, 506, huh?
Yes, ma'am.
447 and 506 of the IPC. Therefore, it is for the petitioners to come out clean in a full-blown trial. I have given my anxious considerations on the phrase, Madam Clerk. The afore narrated facts are all captured, the facts that are necessary for consideration of the list are all captured in the order passed by this court on September the 1st, 2023 in criminal petition 3531 of 2021. Therefore, it would suffice if the facts would be paraphrased into the subject order. The order along with the facts and the reasoning reads as follows. Entire order 45 in the up to, where is the SLP?
SLP is filed.
ಹಾಕಿದ್ದೀರಾ?
Hand over.
ಹಾಕಿದ್ದೀರಾ?
Separate memo ಕೊಟ್ಟಿದ್ದೀವಿ.
ಆಯ್ತು. The said judgment is said to have been tossed before the apex court by the complainant. The apex court rejects the special leave petition by the following order. The issue now would be whether these petitioners would be can be alleged of offence punishable under section 447 and 506 of the IPC. Section 447 has its ingredients in section 441 of the IPC. Section 441 punishes a person who enters into trespasses into another's property by use of criminal force. Therefore, it is criminal trespass into another property. In the case at hand, 3 of the petitioners accused
4, 5, 6.
were not there.
Not there.
3 of the petitioners accused 4, 5, 6 were not even inside the property. Therefore, the said offence cannot be laid against them. The remaining accused 1, 2 and 3, who are the wife, the parents, The wife was entitled to stay in the matrimonial house as it was the matrimonial house. And the parents of the wife who had come to visit the wife cannot be said to have trespassed into the property belonging to the property, i.e. the matrimonial house. Therefore, the offence under section 447 does not meet the ingredients that are necessary under section 441 of the IPC. The offence is thus loosely laid against the petitioners. What remains is the offence under section 506 of the IPC. For an offence under section 506 of the IPC, the ingredients under section 503 is necessarily to be present. The ingredients of 503 is borne interpretation by the apex court in the case of Muhammad Wajid versus so and so, 2023 SEC online SC page 951. The apex court formulates an issue as to how the offence under section 503, 504 and 506 should be proved, qua the ingredients under section 503. The apex court has held as follows. If the elucidation of law by the apex court is considered on the facts obtaining in the case at hand, it becomes unmistakably clear that none of the ingredients that are necessary to be present for an offence under 506 is also present in the case at hand. Therefore, permitting any further trial against these petitioners would undoubtedly become an abuse of the process of the law and result in miscarriage of justice. Thus, this court is exercising its jurisdiction under section 48 of the CRPC and obliterating the proceedings, failing which it would become a proceeding with patent injustice. For the aforesaid reasons, allowed quashed.
All the petitions, 3 petitions. Judgment could be operative portion.
Your Lordship, requesting operative portion to be released.
ಯಾಕೆ ಏನಾಗಿದೆ? ಕಸ್ಟಡಿ ಇದ್ದೀರಾ?
Passport, in fact, they've lost out on 3 promotions so far.
ಆಪರೇಟಿವ್ ಪರ್ಸನ್ ಕಾಪಿನೇ ಬರುತ್ತೆ.
Please.
2 days ಇರಿ.
Please.
ಇಷ್ಟು ದಿನ ಇದ್ರೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅವ್ರು ಕೇಳ್ಕೊಂಡು ಮತ್ತೆ.
Obliged.
23.
Page number 83, my lords. Civil suit of the year 2010.
ಇದೇ ವೆಂಕಟೇಶ್ ಬರೋದೆಲ್ಲ ರೆಸ್ಪಾಂಡ್ ಅಂದಂಗೆ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
ಎಲೆಕ್ಷನ್ ಬಿಸಿಲಿ ಇರಬೇಕು. ಅವರು ಎಲೆಕ್ಷನ್ ಬಿಸಿಲಿ
ಓ ಎಸ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ.
This is the fourth time that they have not appeared.
This court on 24/6/2024 had passed the following order. The interim order was extended from time to time. On 29/1/2026, the counsel for the petitioner was heard and the counsel for the respondents 2 and 3 was not present. Therefore, passed the following order on 29/1/2026. Even today, there is no representation on behalf of the respondent complainant. Therefore, as a last chance, list this matter on 18th, 18th for admission. In the event the counsel for the respondent would not be present, the orders would be passed upon hearing the counsel for the petitioner and the additional SPP for the state. Interim order subsisting will continue to the next date of hearing.
24.
Petitioners in this matter.
This
Last time ನಾನು
Matter is pertaining to
ಮಣ್ಣಂದ
ಅಲ್ಲ PGCET.
PGET.
Oh, yes, sir.
2006 my lord.
ಇವರು ಡೈರೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಇವ್ರು ಬೇರೆ ತರ ಇದೆ. ಇವ್ರದ್ದು this needs to be not dismissed.
ಕೊಡಿ.
I'll convince your lordship on merits, my lords. Even I am standing with the same footage with who has been quashed by this honorable court, my lords.
Are you the beneficiary?
No, my lords, I'm not the beneficiary. I'm the candidate. I'm a student, my lords. I'm the student. I'm the candidate.
ಪಾಸ್ ಆಗ್ಲಿಲ್ವ ಇವರು?
Pass agidi, my lords. My lords, it is a definite case of the prosecution is that, my lords. In the earlier exams, in the MBBS and COMED K, we were very poor in the getting marks. That is the
past detailed order.
Yes, my lords. My lords, I am standing with the order which were quashed by this honorable court, my lords. I am not standing with on different footing, my lords. Even, my lords, where accused number 3, who is obtained the first rank, he's, as against him also, my lord, there is an allegation in the entire charge sheet which is filed by the CBI. Then he, during previous exams in the MBBS and Comet K, he's very pure in getting the marks. Then, my lords, he was also subjected for narco analysis and also under brain mapping. His brain mapping test also were positive.
ಯಾರ್ದು?
Accused number 3, who gets the first rank in the PGET entrance
Pass
exam.
ಆಗಿದ್ಯಾ?
He has been discharged by the trial court. Trial court, my lords, he was discharged.
ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ನಾನು.
They were not challenged at all, my lords.
ನನ್ನ ಮುಂದೆ ಬಂದಿಲ್ಲ.
Discharged by the trial court. Then, my lords, they have not challenged his order. A very similar role, my lords, similar allegations. And subsequently, my lords, the accused number 6 and 7, your lordship's order, my lords, though their brain mapping test and the polygraphy test were negative, as against them also, my lords, the general common allegation with these petitioners. Accused, as against accused number 17, my lords, he's also gets with 17th rank. Then, my lords, his polygraphy and brain mapping also positive. He has been discharged by this honorable court. The CBI has challenged it before the Honorable Supreme Court. The matter is pending before the Honorable Apex Court. Then Honorable Apex, they challenge it, my lords. They challenged it. This Honorable Court has been discharged, my lords, accused number 17.
My order?
No, my lords, the coordinated bench of this Honorable Court, my lords. Then, my lords, CBI challenged it before the Honorable Apex Court. The Honorable Apex Court, my lords, has categorically directed the CBI whether the order of your lordship has been attained finality or the CBI has taken any steps to prefer the appeal before this Honorable Court. Then the matter is still today, my lords, the pending before the Honorable Apex Court. Let's, I'm placing the synopsis, what has happened, my lords, with respect to all the accused persons. Let's kindly see first page itself, my lords.
I will take it. 20 ತಗೋಣ.
Sorry.
ಅವತ್ತು finish ಮಾಡಿ. I'll also go through this.
Please.
List on.
One submission. The entire issue revolves around the polygraphy and narco, the brain mapping, my lords. This Honorable Court may consider only that allegation is that, my lords, their polygraphy and brain mapping is positive merely because the brain mapping and the polygraphy is positive. They cannot, my lord,
That I have held.
Selvi, my lord,
Correct.
Selvi.
ನನ್ನ ಜಡ್ಮೆಂಟ್ ಎಲ್ಲ ಬರ್ದಿದ್ದೀನಿ ನಾನು. ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋ ಕೇಸಲ್ಲಿ ಪ್ರತಿಯೊಂದು ಬರ್ದಿದ್ದೀನಿ.
ಇಲ್ಲ ನೋಡಿ, I have considered. ಯಾರ ಮೇಲೆ ಮಿಡಲ್ ಇದೆ ನಾನು ಹೇಳಿದ್ದೀನಿ. The same manner,
General common allegation, my lords, my submission
This is exactly what Prasanna Kumar did.
Yes, my lords.
That ಯಾರು ಇಲ್ಲ ಇದು ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
Dismiss
I have considered.
only.
See, Selvi ಪ್ರಕಾರ the brain mapping test will not be conclusive. There should be corroborative material.
Latest judgment.
Corroborative ಇದೆಯೋ ಇಲ್ವೋ ಅಷ್ಟೇನೆ.
Latest judgment of the Honorable Apex Court, my lords. Latest judgment 2025 Justice Sanjay Karol's judgment, my lord, says that even if they consented, even the polygraphy or brain mapping test or narco analysis is positive, that cannot be a substantive piece of evidence.
Followed,
Selvi is followed, my lords, but in detail, my lord, the Honorable Apex Court has discussed the latest judgment, in the latest judgment, my lord.
ಜಜ್ಮೆಂಟ್ ಬದಲು ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ?
Facts and
ಇದೇನಾಗುತ್ತೆ ಅಷ್ಟೇ
I'm squarely with, I am standing with the other accused who has been quashed by this Honorable Court and also the Honorable the coordinated bench, my lords.
No.
On the principle of parity, my lords, and purely before this Honorable Court on the principle of parity.
We'll see. Yes.
Please.
I'll read.
Please.
ಓದ್ಕೊಂಡ್ ಬಂದ್ರೆ I'll get clarity to decide parity. Yes. Next,
documents, I'll place on record, along with objections, documents ಕೆಲವಿತ್ತು ನೋಡಿ, I'll place it on.
ಆಯ್ತು, ಏನಿದೆ ಕೊಡಿ. Yes, next.
25.
Entry order.
Two petitions, my lord. It's a triangular suicidal story.
Triangular suicide?
3 suicides, my lord. The both petition. I am the complainant in the second petition.
Who committed suicide, sir?
Three members of the same family has committed the suicide. May I place the synopsis, my lord?
ಹೇಳಿ ಸರ್.
First husband and
ಇದು ಅದು ಆ ಕೇಸ್ ಸಂಬಂಧಪಟ್ಟ. ಅದು ಇನ್ನೊಂದು ಯಾವ್ದು ಇದೆ ಅದಲ್ಲ.
and thereafter, after hearing the death, wife also.
Mike. No, husband commits suicide first.
Husband and his mother committed suicide by hanging. Then wife committed the suicide after hearing that.
So,
and there was a family discord. And my submission before this honorable court is that there is no nexus insofar as the commission of offense.
Now, who is the accused for that suicide?
In the first petition, in my petition, my lord.
You are the accused?
I am the accused, my lord. If my lords take my synopsis, my lord, one Danuja and Raju got married in 2018. There were differences between Danuja and Raju. Both of are deceased now, my lord. In 2022, they filed a case for one for matrimonial issues. On 10/8/2022, my lord, this Danuja informs.
All three have committed suicide, fine. Now who is charged of abetment?
The Raju's sister is charged of
Each other.
abetment.
Each other. And there is, I humbly submit, there is no nexus insofar as both the.
We will allow all. Quash everything.
That's
ಆಗೋಗಿದೆ ಯಾರು ಇವ್ರನ್ನ ಇಟ್ಕೊಂಡು 230 will dictate.
Brief.
ಈಗ ಒಂದೊಂದು ಪೆಟಿಷನರ್ ಯಾರು ಅಂತ ನೋಡಿದೀರಾ?
First petition, husband and wife committed, husband and mother-in-law committed side.
Now the 4 ನಿಮಿಷ. First petition ಅಲ್ಲಿ
2305.
Who is Kanyakumari?
Kanyakumari is the sister of the husband.
Now this complainant Gayatrama yaru?
Mother of the wife.
Mother of the wife. Now the wife commits suicide.
Wife commits suicide.
Husband also commits suicide.
First husband and his mother commits suicide, my lord.
When
On
and
hearing the news,
his mother.
the wife commits suicide.
His mother committed suicide. Thereafter, after hearing that, next day,
ಇವ್ರೇನ್ ಮಾಡಿದ್ರು?
there was a family discord. Because of that, all these things happened. But there is no nexus insofar as the commission of offense in both the cases. That is my humble submission after going.
We'll allow everything. Yes. Madhyana dictate. ಇರ್ಲಿ, ಕರೀರಿ. Yes, next.
26.
For the respondent, my lord.
2010, my lord, the petitioner filed an application to strike up of the company, my lord. 2011, my lord, the accused number 1, accused number 2 company was strike up from the register of companies, my lord.
Correct.
As per the complainant, my lord, 2014, I have taken the hand loan of 60 lakhs. He has paid by wife cash, my lord, 60 lakhs. And 2007, my lord, return, my lord, I have issued the checks, my lord. That is again, now the accused number 1 company was dissolved in the 2011, my lord. The already the strike off from the company, register of companies, my lord. Now he is saying that 2017, the accused number 1 is issued the check and it is dishonored and 138 is filed, my lord.
You're not the signatory?
I'm the signatory, my lord, but the company was strike off from 2011, my lord.
Why did you issue the check?
My lord.
Why did you issue the check?
My lord, it was a security. He is, my lord, he has given
partner. Who is he?
No, I only issued he has given me a loan, my lord, in 2005, my lord.
All right.
See, I have paid 80 lakhs, 20 lakhs was obtained from him, 80 lakhs was paid, my lord. Now still he is asking for the principal amount, my lord. 2000, my lord, 2010, I have filed application for the dissolution of the company. I am the managing director of the company. 2011,
Where did he get that check?
Earlier, it is 10 years back, it was issued by the petitioner, my lord, as a security.
Yes, Balakrishna.
Now the legal issue, my lord, whether after striking of the company, my lord, whether the director liable.
Yes.
If I have cheated, my lord, if I am liable for for example, if I issue
138, you will not be liable.
I am not liable, my lord.
So here in the
And
case,
moreover,
my
my
lord,
lord, one more point, my lord. At the time of, he is saying that, well, at the time of issuance of the check, I am not in India. At the time of lending up the loan also, I am not in India, my lord. I have produced the documents also with regard to that, my lord. And third point is that, my lord, even the legal notice also not given to only to the company, my lord. The petitioner, there is no legal notice, my lord. I given the synopsis also, my lord. There is citation
here in
also,
the
I
case,
produced
my
last
lord,
page of petition, my lord.
the issue raised by the petitioner in the instant petition is having serious disputed facts. Cannot be examined under section.
Company close ಆಗಿರೋದು dispute ಇದೆಯಾ?
No, your lordship kindly see.
ಅಲ್ಲ ಅದು dispute ಇದೆಯಾ? Why are you surprised? ಅದು dispute ಇದೆಯಾ ಇಲ್ವಾ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
It is also disputed
Why
facts.
company close ಆಗಿಲ್ವಾ?
It is also disputed facts.
Company close ಆಗಿಲ್ವಾ?
I am not aware of it. It is a disputed fact.
Public domain.
Two, serious disputed facts. It cannot be examined under section 482, my lord.
Yes, sir.
There is no legal issue in this case, my lord.
Yes.
And dissolution, just because dissolution of the company, he cannot escape from the liability. under section 138 of the Act.
420 ಹಾಕಿ ಬರುತ್ತೆ.
He has admitted the signature. He has not replied to the legal notice.
You ಬೇರೆ ಯಾರು ಕೊಟ್ಟಿದ್ದೀರಾ ನೋಟಿಸ್?
We have issued
ಇವರು
the
ಕೊಟ್ಟಿರೋ ನೋಟಿಸ್ ಕೊಡಿ.
both the parties.
With the parties.
I produced all the documents.
Where are both the parties?
Rakesh Ramakant, who is the authorized signatory of accused number 2, my lord. He has not replied to the legal notice. He has admitted the signature found in the exhibit P1.
Notice ಎಲ್ಲಿದೆ sir?
Yes.
Page number 42 is the notice, my lord.
One moment, sir. 42 notice,
Notice,
Yes, my
notice.
lord.
Giga Networks.
Giganot and accused number 2 ಅಂತ recash ಮಾಡಿದ್ದಾರೆ. But in the acknowledgement, my lord, he has sent to both the notice to the accused number 1 company only.
ಎಲ್ಲಿದೆ?
45, my lord. 45, 47,
ಎರಡು ಅಲ್ಲಿಗೆ ಕಳಿಸಿ.
ಅಲ್ಲಿ ಕಳಿಸಿದ್ದಾರೆ.
ಆಯ್ತು. ಆಮೇಲೆ ರಿಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅವರು.
He has not replied to the legal notice and he has admitted the signature found in the legal notice.
Where is he admitted?
He is not disputing. He is not disputing.
Where did he have the occasion to
the
dispute?
fact of issuance of check.
Where did he have the occasion to dispute?
No, he is not at all disputing the
He is
fact of
disputing,
issuance
sir.
of the check. And it's a serious disputed facts, my lord. There is no legal issue at all. Company is dissolved. Let us presume that company is dissolved, but personal liability is not dissolved. Which covered under section 141 of the NA.
Presumption. Presumption.
No liability.
The presumption of the signature.
So it's a serious disputed facts.
Serious.
Cutting off decisions, honorable
ಏನು
appellate
serious
court has-
ಇಲ್ಲ, sir.
No, your lordship kindly say, I am
There
relying
is
upon.
nothing serious in this case.
There is a judgment of honorable appellate court.
What is it?
There is no legal issue at all.
Absolutely.
Page number 16 kindly be seen, my lord.
I'll now pass an order. Legal issue gets created.
Page number.
Yes.
When disputed questions of facts are involved, which need to be adjudicated after parties adduce evidence, the complaint under section 138 of Act
Balkrishna,
ought not to have been quashed by the High Court
Correct.
by taking recourse.
Correct. ಇದನ್ನು ತೊಂದರೆ ಇಲ್ಲ. That is too rudimentary for a judgment. Seriously disputed questions of fact we can't go into. But here there is no dispute at all.
I have disputed.
Who may dispute?
No, where is the legal issue, my lord? Where is the legal issue?
I will answer.
So
sir. That is the
disputed
legal
fact
issue.
has to be thrashed out before the trial court,
No doubt about it.
not under section 482.
Absolutely.
No legal issue at all.
ಆಮೇಲೆ good effort.
And I have also produced one more judgment of the honorable appellate court, my lord, along with the memo of authority already been produced. With regard to dissolution of the company and the liability of the directors and managing directors. Page number 121, my lord, 121, para 108. Thus, the upshot of all the decisions referred to above is where the proceedings under section 130 of the Act had already commenced with the magistrate taking cognizance upon the complaint, and during the pendency, the company gets dissolved. The signatories, directors cannot escape from their penal liability under section 130 of the Act by citing its dissolution. What is dissolved is only the company, not the personal penal liability of the accused covered under section 141 of the Act. The ratio of the honorable appellate court in this judgment is squarely applicable to the facts and circumstances of the present case, and serious disputed facts, no legal issue. He has admitted the issuance of check. All these things has to be adjudicated before the learned magistrate, not under section 482 of the.
Yes, sir.
141 is clear, my lord. At the time of issuance check, my lord, he was not the, and Anita had also, my lord, it's squarely covered under Anita, my lord.
Company ಮಾಡಿದಾರಲ್ಲ party.
Company ಮಾಡಿದ್ದಾರೆ, but if the company is liable, the director liable. When company is not liable, director is not liable. Para, my lord, 58, my lord.
ಕೊಡಿ ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡೋಣ.
I produced the other judgment also in Delhi High Court, my lord. It is squarely covered, my lord.
ಯಾವ್ದದು?
Earlier occasion I produced, my lord. Page number 28, my lord.
Same issue, my lord, strike off of the company, my lord, page number 28, my lord. By quoting the Companies Act as well as the notification of the central government, my lord. Para 9, my lord.
The petitioner is before this court calling in question the entire proceedings in CC 263 of 2018 registered for offences punishable under section 138 of the Negotiable Instruments Act. The petitioner is the accused number one, the respondent, the complainant. It transpires that the company in which the petitioner was a managing director when the company was in existence issues a check in favor of the respondent complainant against a loan that was against a transaction in cash. The petitioner claims that he has returned the entire amount, however, had issued a check at the time of the transaction. The issuance of the check is not in dispute. The check was presented on 8/8/2017 and a legal notice then caused to the petitioner. The complainant then registers a private complaint in PCR 13006 of 2017, which is now pending as CC 263 of 2018. The learned counsel, the pendency of the subject petition is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the company got dissolved in the year 2011. Closure of the company was communicated to all statutory authorities, and the petitioner had left to the United Arab Emirates later. The complainant, after about 6 years of the closure of the company, presents the check for its realization. The check obviously gets dishonored. The dishonoring, the learned counsel further submits that a company that has stood closed in accordance with law would not mean that it would face proceedings for offence punishable under Section 138 of the Negotiable Instruments Act. He would seek to place reliance upon certain judgments rendered by the other courts. We'll continue it.
This court also.
Yes.
Humble submission. Lordship told to commit 130 regarding the submission of the memo for posting.
Vivek Reddy sir idralla.
Vivek Reddy ಮಾತಾಡಿದೆ. Said it appears Milords he has requested Milords for a time in the chambers Milords, that's what.
ಆಯ್ತು ಬನ್ನಿ. Hand delivery. ಆಯ್ತು, I'll take it. ಇವತ್ತಿಗೆ ಬೇಕಾ ಯಾರಿಗಾರು? ಏನು?
On 9th Milords, the 138 matter complainants petition.
130 complainants petition.
Complainants petition. Filed recall and reopening application on the ground that when the matter was posted.
Next date ಯಾವತ್ತು?
13th ಗೆ judgment ಇದೆ.
5 days since FIR.
ಅವ್ರದ್ದು ತಗೊಳ್ಳಿ. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
5 days since FIR, 5 days since
13th.
PF not used that, but yesterday I filed application before one magistrate says not transfers it to another. Today I filed it. 2:30.
My lords, seeking adjournment tomorrow.
Adjournment ಆಮೇಲೆ ಕೇಳಿ. You're not hungry? Then?
Liberty was given by 2:30 and it was filed.
Liberty ಯಾವ್ದು? ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್, ಚಾರ್ಜ್ ಶೀಟ್.
My lord, may I request for tomorrow, my lord, husband and wife, my lord.
Pubblic servants.
ಇಲ್ಲ ಪ್ರೈವೇಟ್ ಅಲ್ಲಿ ಐ ಆಮ್ ಎ ಪ್ರೊಫೆಸರ್ ಇನ್ ಲಾರ್ಡ್ ಡಾಕ್ಟರ್ ಅಂಬೇಡ್ಕರ್ ಕಾಲೇಜ್.
ಏನಾಗಿದೆ?
Rift between husband and wife. Wife's sister, my lord, gives a complaint against husband and my lord his brother. Sexual harassment. Harassment anta she gives a complaint.
Bail ತಗೊಳ್ಳಿ.
Bail is my lord, it is for framing of charge, my lord, on
after.
Friday.
We'll see.
Tomorrow or day after.
Friday.
Right.
My lord, 498 AM at 498 AM matter, my lord, 2 B reports.
Madam. Friday garu kodi madam.
Madam. Madam.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
Madam, 28 still 28. Tax matter ಇದೆ. Dictation ಆದ. Madam.
Madam, I'm not. Court officer.
ಗೊತ್ತಾಯ್ತು ನಾನು ಹೇಳಿದ್ನಲ್ಲ ಫ್ಲಾಟ್ ಎಲ್ಲಿದ್ದು ಎಷ್ಟು ವರ್ಷ ಇದ್ದು ಅದೆಲ್ಲ ಕಳಿಸ್ತೀವಿ ಡೀಟೇಲ್ಸ್ ಕಳಿಸ್ತೀವಿ ನಾನು ರೆಡಿ ಮಾಡ್ಕೊಳ್ತೀನಿ. ಹುಡುಗನ ಹೆಸರು ಮೊಬೈಲ್ ನಂಬರು ಹುಡುಗಿ ಮೊಬೈಲ್ ನಂಬರು ಮತ್ತೆ ಚಿಕ್ಕಮ್ಮನ ಹೆಸರು ಚಿಕ್ಕಮ್ಮನ ಫೋನ್ ನಂಬರು ಅದೆಲ್ಲ ಕಳಿಸ್ಬೇಕು. ಯಾವ ಕಂಪನಿ
ಬರ್ತಾರೆ ಸರ್ ಅವರು ಕೋಡ್ ಆಫೀಸರ್ ಬರ್ತಾರೆ.
ಟೈಪ್ ಮಾಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಇಟ್ಟಿದ್ದೀನಿ ಟೈಪ್ ಮಾಡಿ
ಇದ್ರದ್ದಾ?
ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕನೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಅಷ್ಟೇ ಓಪನ್ ಮಾಡಿ This was like not that ರಿಸರ್ವ್ ಆಗಿದೆ ಇದಷ್ಟೇ ಇಷ್ಟೇ ಸೆಕ್ಷನ್ ಏನು ಗೊತ್ತಾಗಿಲ್ಲ ಸರ್ ಮಾಡು ಯಾವ ಫೈಲ್ ಮಾಡಿದ್ರೆ 28 ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಬೆಳಗ್ಗೆ ಅಷ್ಟೊತ್ತಿಗೆ ಕೆಲಸ ಈಗ ಮಧ್ಯಾಹ್ನ 1:30 ಬರಬೇಕು ಎಲ್ಲರೂ ಸುಮ್ಮನೆ 4-5 ಇಲ್ಲ 25 ಒಂದೂವರೆಗೆ ಏನೂ ಬರಲಿಲ್ಲ ಹಂಗಾಗಿ ಏನು ಕೆಲಸ ಬೆಳಗ್ಗೆ ಇದ್ದೆ ಏನು ಕೆಲಸ ನಿಮ್ಮ 2:30 ಯಾವಾಗ ಇಲ್ಲ ಅಷ್ಟೇ 12:02 420 ಏನು ಅರ್ಜೆಂಟು ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕಳಿಸ್ತೀನಿ. ಹಲೋ ಸರಿ ನೆನ್ನೆ ಮಾಡಿದ್ರಲ್ಲ ನೆನ್ನೆದು ಅಲ್ಲೇ ಇದೆ as per legal but our appeal ಅದು ಒಂದೇ
ಏನಿದು ಅದು ಇವರು ಸುರೇಶ್ ತಗೊಂಡಿದ್ರು ಈ ಫೈಲ್ ಇದು ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲ ಇಷ್ಟು ಊಟನೇ ಮಾಡಿಲ್ಲ ನನ್ನ. ಐ ನಾಟ್ ಡನ್ ಊಟ ಆಲ್ಸೋ. ಯೂಟ್ಯೂಬ್ ಆಫೇ ಮಾಡಿಲ್ವಾ ಲಂಚ್ ಟೈಮಲ್ಲಿ?
ಇದೇನು ಕಂಟಿನ್ಯೂಸ್ ಅಂತ ಇದೇನು ಇಲ್ಲ ಇತ್ತು.
ಹೇಳ್ಬೇಕು.
ಇಲ್ಲೇ ಇತ್ತು ನೀವು
ಇದು ಇವರು ಕೊಡ್ಬೇಕು.
ನಟರಾಜ ಇರಲ್ಲ 18 ತೊಗೊಳೋದಾಯ್ತು. ಮೇಡಮ್ ಕಂಟಿನ್ಯೂ ಸೆಕೆಂಡ್ಸ್ ಮೇಡಮ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ.
ಯಾವ ಡೇಟ್? ಇದು ಟ್ಯಾಗು. ಅದಕ್ಕೆ ಅಂಚನ ತಗೊಂಡೋಗಿದ್ರು. ನಾನು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 6/2026 ಅಂತ ಮಾಡಿದ್ದೆ. 8 ಯಾವ ಟ್ಯಾಗ್ ಮಾಡಂಗಿಲ್ಲ. ಇದು ಏನ್ ಮಾಡೋದು? ಈಗ ತರ್ಸ್ಕೋಬೇಕು ಫೈಲು. ಇದು ಫೈಲ್ ನನ್ನ ಹತ್ರ ಇದೆ 15.
ಮೇಡಮ್ ಮಿಡಿಯೇಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ಕರೀತಾರ ಈಗ 4 o'clock.
ಹಾ ಇದನ್ನೆಲ್ಲ ಚೇಂಜ್ ಮಾಡಿದ್ವಿ ನಾವು. ಚೇಂಜ್ ಆಯ್ತು. ತಪ್ಪಾಗಿ ರಾಂಗ್ ಆಗಿತ್ತು ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಿಸ್ತೇನೆ. ಆರ್ಡರ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಯ್ತು ಇಲ್ಲಿ. ಹೌದು ಚೇಂಜ್ ಆಯ್ತು. ಮಾಡಾಯ್ತು. ಮತ್ತೆ ಇದು ಮತ್ತೆ ತಗೊಂಬಂದಿರೋ ಫೈಲ್ನ. ಯಾವ ಫೈಲ್ನ? ಇದು ನಾನು ತಗೊಂಬಂದಿರೋ ಫೈಲ್ ಚೇಂಬರಿಂದ. ಬ್ರಾಂಚ್ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಚೇಂಬರ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾನು ಹಿಂಗೆ ಹಾಕಿದ್ದೀನಿ ಆರ್ಡರ್ನ. ಇದು ನೆನ್ನೆ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ಡಿಸ್ಪೋಸ್ ಆಗೋಯ್ತು. ಇದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ಎರಡು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ಇದು ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಹಾ ಇದು ಆರ್ಡರ್ ಆಗಿದೆ. ಕೇಸ್ ಸುಮತಿನ. ಅಯ್ಯೋ ಇವಾಗ ಏನ್ ಮಾಡಿದಾರೆ ಗೊತ್ತಾ? ಇದನ್ನ ಹಳೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಿಲ್ಲ ಬೈ ಮಿಸ್ ಆಗಿ. ಅದನ್ನ ಮೇಡಮ್ ಕಾಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕೆಳಗಡೆ ಬರ್ತಾರೆ. ಏನ್ ಮಾಡ್ಕೊಬೇಕು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಲ್ಲ ಕೇಳಲ್ಲ. ಇಲ್ಲ ನನ್ನನ್ನು ಕೇಳಲ್ಲ ಅವರು. ಏನ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ ಆರ್ಡರ್ ನೀವು ಬರ್ಕೊಳ್ಳಿ. ನನಗೇನು ಅಲ್ವಾ ಕೇಳ್ಬೇಕು ಅಟ್ಲೀಸ್ಟ್ ಅಯ್ಯಮ್ಮ ಸುಮ್ಮನೆ ಇದಾಗಿ
Sorry, I'm late. Had to be late.
Your Lordship, list one, serial number 58. The matter has been settled, Your Lordship.
Settlements I'll take at 4 o'clock. ಎಲ್ಲಿದ್ ಮಾಡಿದ ವಾಲ್ಯೂಮ್ ಕಮ್ಮಿ ಮಾಡಿದ್ರಿ. ಫುಲ್ ಕಮ್ಮಿ ಮಾಡಿ.
Memo for posting my lord. Tomorrow, fresh matter.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Sir, 420 my lord.
420 ಅಂದ್ರೆ ಅರ್ಜೆನ್ಸಿನಾ?
ಅಲ್ಲ urgency ಅಂದ್ರೆ my lord, he is the government employee my lord.
ಅದಕ್ಕೆ
Question
ಅರ್ಜೆನ್ಸಿ.
stall ಆಗಿದೆ.
ಸೋಮವಾರ.
My lord, 2006 case was split up my lord. In 2007.
ಸ್ಪ್ಲಿಟ್
Yes my lord. So in
21st ತಗೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅವತ್ತು.
much obliged.
Lord, seeking adjournment.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ವೈ ಸರ್?
So the other side has informed us that they also are not unable to appear, and consequently we also require some time due to a judgment passed by court.
We will see when it is reached, when the matter
My
reaches. Don't worry.
My lord, this is offense under the Companies Act. Complaint is filed by Registrar of Companies. Cognizance has been taken and I am participating in the trial. However, the complainant has not come forward to lead evidence in the last 7 years. They have sought 41 adjournments. But my difficulty, my lord, based on this complaint, PMLA proceedings have been initiated.
Disposal.
Illa, my lord.
What do you want?
The complainant does not have the authority to file the complaint. I want the matter to be heard because.
Pending matter.
Illa, my lord.
Fresh matter.
Yes. Matter may kindly be heard tomorrow, my lord. The difficulty is, my lord, on Monday at least, my lord, PMLA proceedings have been initiated. My house has been attached where I reside with my family. That there's threat of disposition, arrest, my lord.
Give it tomorrow.
Much obliged, my lord.
138 proceedings my lord.
ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ.
Monday.
ಎರಡು ಡಿಟೆಕ್ಟ್ ಮಾಡಿ ಒಂದು ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದು ಅದು ಅಲೋಡ್ ಕಾಸ್ಟ್ ಅಂತ ಮಾಡಿ ಮೇಡಮ್ ಒಂದು ಅವ್ರಿಗೆ ಸುಮಾ ಮೇಡಮ್ ಕೊಡ್ತಾ ಇದ್ದೆ ಅದು ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರಾ? ನಿಶ್ಚಿತ್ ಎಲ್ಲಿ allowed cost I will pass out. I will consider all your legal submissions.
Liberty may be extended to the respondent to avail other remedies under the project IPC, my lord.
Provision IPC. I will not give that because
liberty may be extended.
No, ಅದು ನೀವು ಏನ್ ಬೇಕು ಮಾಡಿ ತೊಂದ್ರೆ.
To avail other remedies.
ಅದು ಏನ್ ಬೇಕು ಮಾಡಿ ತೊಂದ್ರೆ.
ಅಲ್ಲ, that observation may
be. No. ಅದ್ ಬಿಟ್ರೆ ಹೈಕೋರ್ಟ್ ಹೇಳಿದರೆ ಅನ್ಬಿಟ್ಟು 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತೀರಾ?
Not like that.
Only like that. We'll answer this and leave it at that. Yes. All right. ಇನ್ನೊಂದೆರಡು ಮಧ್ಯಾಹ್ನ ಡಿಟೆಕ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದೇ ಟ್ರಿಪಲ್ ಸೂಯಿಸೈಡ್ ಇತ್ತಲ್ಲ ಯಾವುದು?
25.
ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಅದು ಇತ್ತು ಮೇಡಮ್. ಅಲ್ಲಿ ವಾಲ್ಯೂಮ್ ಕೊಡಿ.
Madam. Please, no. May I request it on 27, my lord, as I have informed the other side.
You already informed?
Yes, my lord.
Yes. At the request of the council, 230 matter, madam, in list number, Dharwad list. At the request of the council appearing for the petitioner, Srimati Archana Magdum, list the matter 27th.
27, my lord, because senior council is available on that day.
27th.
I'm sorry, my lord, in the last occasion I made a mention that I'll appear personally.
Yes, that's all right. 27th.
Yes,
Your lordship may kindly record our appearance also on behalf of NHAL.
ಯಾರು ನೀವು? ಪದ್ಮನಾಭ ಹೊಳ್ಳನ?
I appear for.
ಅಲ್ಲ, ಇವ್ರು ಯಾರು? ರೆಕಾರ್ಡ್ ಮೈ ಪ್ರೆಸೆನ್ಸ್.
I appear for number 1. In the leading matters WP 106478 and 10893 I appear.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಎಲ್ಲರನ್ನು ಹರ್ಡ್ ಅಂತ ಹಾಕ್ಬಿಡಿ, ಲಿಸ್ಟ್ ಆನ್ 27th ಅಂತ ಹಾಕಿ. Sorry?
At 2:30, my lord?
2:30, yes. ಕೊಡಿ suicide.
Second matter I appear for, in second matter I appear for the petitioners.
We'll go matter by matter. First petition ಯಾವ್ದು ಮೇಡಮ್? ಇದೇ synopsis ಅಲ್ಲ? This one? Yes. The petitioner file ಅಲ್ಲಿ order sheet ಇದೆ. Oh, ಇಲ್ಲ, sorry. The petitioner is before the, ಅಲ್ಲ, these ಹಿಂಗ್ ಮಾಡೋಣ. ಎರಡು petition ಇರೋದಲ್ಲ. These petitions arise out of a common proceeding in SC 5067. ಇಲ್ಲ, separate crimes.
Separate charge sheet, separate crime numbers.
The first ಇದು ಬರ್ಕೊಳ್ಳಿ madam. The subject petition is preferred by accused number 1 and 2 in SC 5067 of 2023, calling in question the proceedings pending before the Court of Session in the aforesaid sessions case. Heard so and so. Facts in brief germane are as follows. The first respondent is the complainant. A complaint comes to be registered. The first respondent on a complaint registered by the second respondent. 498 ಏನು ಇದೆ ಅದರಲ್ಲಿ?
Earlier, the deceased Tanuja has given a complaint,
family
so they have invoked 498.
306 498 ಎಲ್ಲ ಇದೆ.
Yes, ma'am.
The second respondent is the complainant. A complaint comes to be registered on
20.
A complaint comes to be registered on 10th August ಅಲ್ಲ? 20th August 2022 by the second respondent alleging that who is Danuja?
Danuja is the wife
Second
of
Alleging that what the relation with the complainant?
Second respondent's daughter is Danuja.
The daughter of the complainant has mother Amel Satidda? Mother and the daughter.
My mother died. First petitioner's mother died earlier.
Adu by
That is second petition, my lord.
Adu by suicide.
Suicide.
But first ತಗೋಬೇಕಾದ್ರೆ
First ತಗೊಂಡ್ರೆ
correct ಆಗುತ್ತೆ.
ಅದು ಕೊಡು. Sorry madam.
32981.
32981 ಹಾಕಿರೋದು ಇದೆ ಫಸ್ಟ್.
ಹೌದು, ಅದೇ ಫಸ್ಟ್ ಸ್ಟೆಪ್. 32981 ಇದೆ.
Madam Mitholi, writ petition 32981 of 2024. The second respondent is the complainant, the petitioner in the companion petition.
Number 1.
First petitioner in the companion petition. A complaint comes to be registered by the second respondent against these petitioners accused 2 to 6, alleging on 10/8/2022, alleging offences punishable under section 306 and 149 of the IPC. The police conduct investigation and file a charge sheet against the present accused. Filing of the charge sheet is what has driven the petitioners to this court in the subject petition. Heard so and so. Facts in brief germane are as follows. It is the case of the prosecution that on 10/8/2022 at 11 p.m. the daughter adu ಈ ಕನ್ಯಾಕುಮಾರಿ ಅವ್ರ daughter adu
Brother and mother.
Kanyakumari sister of the husband.
ಅಲ್ಲ sir.
Kanyakumari's brother and mother committed suicide.
ಇದರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
Idರಲ್ಲಿ brother and mother.
ಇಬ್ರು. The brother and mother of the complainant commit suicide. The acts of the law falls upon these petitioners, alleging them to have abetted the commission of such suicide. The backdrop of the commission of suicide is the institution of proceedings for offence punishable under section 498A or otherwise, as the family dispute was subsisting between the parties. The complaint becomes a crime in crime number 68 of 2023. The police conduct investigation and file a charge sheet, and the matter is presently pending before the Court of Session in SC 81 of 2023. This forms the fulcrum of the subject petition. The companion petition is filed by the complainant in the subject petition, calling in question registration of a crime in crime number 180 of 2022, registered pursuant to registration of a complaint on 20th August 2022 for offences punishable under section 504, 498A, 306 and 34 of the IPC. The illi son alva? His daughter, Dhanuja is the daughter.
Wife, second respondent's daughter.
The second respondent's daughter is said to have committed suicide, which forms the fulcrum of the list in the companion petition. Therefore, there are 3 deaths in these 2 cases. One, the mother and brother of the complainant in the petition 32981 of 2022, and the daughter of the complainant in criminal petition 2305 of 2022. The issue is who has abetted whom in commission of suicide, for this court to permit the trial, if any, to be conducted. Since the entire issue has now sprung from the registration of the complaints in these respective cases, I deem it appropriate to notice the complaint that led to respective registration of the crimes as afore noted in both these cases. Madam, complaint ide, errallo ide. The complaint then becomes the ground for investigation. The investigation leads to filing of the charge sheet in both these cases. The summary of the charge sheet as obtaining in column number 17 in both these cases read as follows. If the complaint and the summary of the charge sheet is noticed, what led to commission of suicide of the mother and the brother in writ petition 32981 of 2024 led to commission of suicide of the daughter of the complainant in the companion petition. The reason is lurking family dispute between the parties. Cases had been registered against each other. It transpires that that all the persons who died by committing suicide did commit suicide out of desperation or the reason that the legal proceedings had been preferred against each other. Whether this would amount to abetment to suicide is necessary to be considered. The abetment to suicide is dealt with under section 306 of the IPC. Section 306 reads as follows. For an offence to become punishable under section 306 of the IPC, what is necessary is abetment. Abetment is defined under section 107 of the IPC. Section 107 reads as follows. If an offence is to be proved if an offence has to be driven home for abetment of suicide, ingredients as necessary under section 107 must necessarily be present, which would mean that there should be immediate proximity, goading, instigation, which leads the victims in any given case left with no choice to commit suicide. This is the interpretation of the apex court, interpretation by the apex court in plethora of judgments while interpreting section 107, interpreting section 306 and 107 of the IPC. The apex court in 2025 SCC online SC page 2332 in Yadvinder Singh has held as follows, para 16 to 18. The apex court holds that the apex court in the said case was considering commission of a suicide of a victim on the score that the accused refused to marry the victim. Therefore, the apex court held that it would not amount to abetment to suicide. Likewise, the apex court in Geeta versus State of Karnataka 2025 SSC Online SC page 1938 holds as follows, para 17 to 23. The apex court considers the entire spectrum of the law with regard to what would amount to abetment under section 107 if it can become an offense under section 306 of the IPC. The apex court holds that the human mind would be an enigma at certain times. Unfortunately, a life is lost. That would not mean that that persons who are treated as accused, who have no role to play or have not committed the act of goading, instigation, or the acts are not proximally involved to the incident of a commission of suicide, they should not be permitted to undergo the rigmarole of trial. Taking cue from the observations of the apex court, if the afore narrated facts are noticed, it would unmistakably emerge that these petitioners cannot be alleged of either goading, instigation to the victims who have committed suicide for commission of such suicide. Institution of legal proceedings against each other cannot become instigation or abetment to commission of suicide, while there may be depression or otherwise of those persons who did commit suicide. This will not mean the fulcrum of the list. The fulcrum of the facts obtaining in the list would not mean that the petitioners would be liable to be tried for abetment to suicide, as permitting trial in this case would run foul of the principles laid down by the principles elucidated by the apex court in the aforesaid judgments. In that light, the petitions deserve to succeed. So and so allowed, quashed. Great. ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳು. ಇನ್ನೊಂದು ಯಾವುದೋ ಒಂದು ಪಾಸ್. ಹಾ, ಅರುಣ್ ಜಿ. ಎರಡೇನಾ ಇನ್ನು ಯಾವ್ದಾರು ಇದೆಯಾ? We'll answer the merit of this. Please, let me not get into the loop of your problems. Court ಹೇಳಿದ್ರು. Yes.
I think your lordship, somewhere I think reiterate about the issuance of notice in the manner in which.
ಅದು ಕೇಳಿದ್ದೀರಾ ಅರುಣ್? ಇದರಲ್ಲಿ 35(3) ಬಗ್ಗೆ ಹೇಳಿದ್ದೀರಾ?
ಹೇಳಿದೆ ಸರ್. In fact, there is a violation. I have urged.
ಅಲ್ಲ, ಹೇಳಿದ್ದೀರಾ ಇಲ್ಲಿ?
Please.
Reading ಇದೆಯಾ?
Please.
Then we will follow Nallabalu and lay down something.
Nallamadu may not help me. In fact, your lordship's order, my lord.
ಅದು ಕೊಡಿ, ನಂದು ಆರ್ಡರ್ ಕೊಡಿ. 41 ಏದು. R3. ಅದೇ ನಾಳೆ ಮಾಡ್ತೀನಿ. ಅದೆಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ವಿಲ್ ಪಾಸ್ ಮಾಡೋ ಟುಮಾರೋ. ನಾಳೆ ಮಾಡ್ತೀನಿ.
ಪ್ಲೀಸ್.
ಪ್ಲೀಸ್ ಟುಮಾರೋ. ಫ್ರೆಶ್ ಮೆಟಲ್ ಬರಲೇ ಮಾಡಿ.
Can it be day after tomorrow?
Why?
ನಾಳೆ ಒಂದು ಟ್ರಯಲ್ ಇದೆ.
ಟ್ರಯಲ್ ಇಂಪಾರ್ಟೆಂಟ್, ಇದು ಇಂಪಾರ್ಟೆಂಟ್.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಬ್ಲಿಗೇಟ್ ವಿ ಶುಡ್ ಬಿ ದೇರ್.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮಾಡಿ.
ಹಂಗಾಗಿ ಅದಕ್ಕೋಸ್ಕರ
ನೀವು ಇರೋದೇನ್ ಬೇಡ. ಡೋಂಟ್ ವರಿ.
ಸಾರಿ.
ಯಾರು ಇರೋದು ಬೇಡ.
ಪಾಸ್ ಮಾಡಿ. Day after, if subject to.
We'll see.
Please.
Till Tuesday.
Please.
Tuesday fresh mat.
Please.
ಹೆಂಗೋ ಆಚೆ ಬಂದಿದ್ದೀರಲ್ಲ.
ಅದಕ್ಕೆ.
Yes. Next. ಟೂ 30 ಯಾವ್ದಿಲ್ಲಲ್ಲ ಮೇಡಮ್? 230 ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಯಾವ್ದಾರು ಇದೆಯಾ? 15 ನಿಮಿಷ ಇಲ್ಲಲ್ಲ? ಎಸ್. ಎಸ್ ಸರ್. 498.
Please, in-laws. I appear for respondent number 2.
time.
No time, sir. Time matra kelbedi.
Senior is in out of station.
Case also out of station. Nothing doing. Yes.
Because weeks time maybe.
No, sir. List ಆಗಿರೋದು ಮುಗ್ಸಕ್ಕೆ. My interim order is 3 pages. This is the final order. In-laws ಏನಿದೆ ಹೇಳ್ಬಿಡಿ. ನೀವು ನೋಡಿಲ್ಲ ಫೈಲು? ಮತ್ತೆ ಹೇಳಿ ಸರ್.
Lord,
No, I'm not granting time at all. If you want to argue, argue. ಇದು ಮತ್ತೆ ಲಿಸ್ಟ್ ಮಾಡಿಸೋದು. Listing is a huge problem and taking time should not happen at the hands of the councils.
Please, my lords.
No, please ಅಂದ್ರೆ ಆಗಲ್ಲ. Should not take time. Once it is listed in admission, yes. If there is any lurking problem in the petition, then which information will be required, I will definitely. 498 ಅಲ್ಲಿ ಏನಿದೆ? ಅದು in-laws.
Accused number 4 is the grandmother's only, 72 years. She's a resident of Coimbatore. She comes here only for 10 to 12 days.
ಅಷ್ಟರಲ್ಲೇ ಬಂದು ಎಲ್ಲ
ಬಂದು ಕೈ ಹಿಡ್ಕೊಂಡ್ಬಿಟ್ರು ಅಂತ.
ಕೈ ಹಿಡ್ಕೊಂಡ್ಬಿಟ್ರ?
ಅವ್ರು ಹೊಡಿಬೇಕಾದ್ರೆ ಕೈ ಹಿಡ್ಕೊಂಡ್ರು.
ಮೋಸ್ಟ್ಲಿ ಬಹಳ ಪವರ್ಫುಲ್. ಹಳೆ ಜೀನ್ಸ್ ಬಹಳ
ಪವರ್ಫುಲ್. ಅಷ್ಟೊಂದು ಕೈ ಬ್ಲೂ ಆಗೋಯ್ತಾ ಕೈ ಹಿಡ್ಕೊಂಡ ತಕ್ಷಣ? There should be some semblance of fairness in drawing every person of the family. 62 ವರ್ಷ 80 ವರ್ಷ ಏನಿದೆಲ್ಲ ಏನ್ ನಿಮ್ಗೆ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ? You take care of the husband, no problem. The husband is not here, we will not spare. Why all these family members if they are living elsewhere? Registration of a crime has become a joke for complainants. And the police register the crime. ಕೇಳಿದ ತಕ್ಷಣ 498 ಬನ್ನಿ ಕಾಯ್ತಾ ಇದೀವಿ. This should stop. This is why the apex court wrote 85 should have been tweaked up. All complainants ಗೆ malicious prosecution ಕೊಟ್ಬಿಡ್ಬೇಕು ವಾಶ್ ಆದ್ಮೇಲೆ. ಆವಾಗಲೇ ನಿಲ್ಲದಿದು. Otherwise this misuse will not stop. ಇದರಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ ಅವ್ರಿಗೆ? ಆಯ್ತು, ಆ ಥರ್ಡ್ ಪೆಟಿಷನರ್ 75 years ಇದಾರಲ್ಲ, ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು?
That's the contention of the complainant is that, my lords,
ಅಲ್ಲ, what capacity does she have to torture you?
No, that's by joining 4 people, sir.
That is omnibus statement. If you have a grouse against the husband, you draw every member of the family into the crime.
No, that's
The criminal case is not a joke. ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ ತಕ್ಷಣ ಬೇಲ್ ತಗೋಬೇಕಾಗತ್ತೆ, ಬೇಲ್ ಆದ್ಮೇಲೆ ಟ್ರಯಲ್ಗೆ ಹೋಗ್ಬೇಕಾಗತ್ತೆ. ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಖಂಡಿತ ಮಾಡಿ. ಸುಮ್ನೆ ನಿಮಗ್ ಮನೇಲಿ ಅವ್ರು ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮದರ್ ಇನ್ ಲಾ ಟ್ರಬಲ್ ಡ್ಯೂ ಅಂದ್ರೆ ಕೆಲಸ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ, ಅದ್ ಮಾಡಿದ್ದಾರೆ, ಆದ ತಕ್ಷಣ ನಿಲ್ಸ್ಬೇಕಲ್ವಾ? ಅದಂತೂ ಇಲ್ವೇ ಇಲ್ಲ. ನಿಲ್ಸ್ಬೇಕಲ್ವಾ ಅಂದ್ರೆ ಕೇಸ್ನಲ್ಲ ನಾನು ಹೇಳಿದ್ದು. 498 ಏನು? Yes. The petitioners. No, sir. Vehemently argued ಅಂತ ಹೇಳ್ತೀನಿ.
The allegation is that, my lords, for
allegation ಇದ್ರೆ ನಾನೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ, ತೋರಿಸ್ಬಿಡಿ.
No, my lords.
I will myself dismiss.
In complaint, my lords. In complaint.
ಸಾಶೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸರ್.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬನ್ನಿ. ಇದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ವಿಲ್ ನಾಟ್ ಎಂಟರ್ಟೈನ್. Yes.
Page number 15, my lords.
Yes, sir. 15.
Yes, my lords.
15 is your petition, sir.
No, my lords.
ಇನ್ನೊಂದು petition ಇದೆಯಾ?
Page 23. Page 23, my lords.
Page 23.
In 24, my lords. Page number 24. The allegation is against husband and father and mother of the husband, my lords, and along with that, the aged mother, my lords.
Grandmother.
And girlfriend. Paramar
and girlfriend.
ಅದು ಕ್ವಾಶ್ ಮಾಡಿದ್ರು.
Girlfriend ಕ್ವಾಶ್ ಆಯ್ತು. Previous date. It's common objection has been filed. To petition, my lords.
ಇಲ್ಲಿ ಎಲ್ಲಿ ಒಂದು ಇಂಗ್ರೀಡಿಯಂಟ್ ಇದೆ ಹೇಳ್ಬಿಡಿ.
Let's the demand demand of dowry, my lords, section 3 and 4 also attracted, my lords. They have given nearly for marriage 10 lakh, my lords. 10 lakh they have collected as
that is for marriage. After marriage,
my lords, ಯಾವಾಗ್ಲೂ ಮನೆಗೆ ಹಬ್ಬಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗುವಾಗೆಲ್ಲ ಚಿನ್ನದ್ದು ಅಥವಾ ಏನಾದ್ರು ಒಂದು ಕೊಟ್ರೆ ಮಾತ್ರ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ, ಇಲ್ಲಾಂದ್ರೆ ಕರ್ಕೊಂಡು ಹೋಗಲ್ಲ ಅಂತ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಬರಲ್ಲ. ಆಮೇಲೆ ರೋಡ್ ಅಲ್ಲಿ
ಅದೇ
ಕರ್ಕೊಂಡು
ಗೊತ್ತಾಯ್ತು,
ಹೋಗುವಾಗ
ಪೇಜ್ 32 ಅಲ್ಲಿ ಟೈಪ್ ಕಾಪಿಲಿ ಇದೆ. ಬೆಲೆ
ಕರ್ಕೊಂಡು
ಬಾಳುವ
ಹೋಗುವಾಗ
ಚಿನ್ನಾಭರಣವನ್ನು ನೀಡಿದಲ್ಲಿ ಮಾತ್ರ ಹಬ್ಬಕ್ಕೆ ಬರುತ್ತೇನೆ ಅಂತ ಯಾರಂದ್ರು?
husband and Velots at the time where is a relationship
ಇಲಿಸಿಟ್ ಆಗೋಯ್ತು ಬಿಡಿ.
Velots
ಇದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟದ್ದು ಯಾಕೆ ಅಂದ್ರೆ ಇಲಿಸಿಟ್ ರಿಲೇಶನ್ಶಿಪ್ ಇದೆ ಅಂತ.
ಅದ್ ಕೇಳಿದಾಗ ಅವರೆಲ್ಲ ಸೇರಿ ಕೊಲೆ ಮಾಡ್ತೀನಿ ನಿಮ್ನ, ಏನಾದ್ರೂ ನಿನ್ ಮನೆಗೆ ಹೇಳಿದ್ರೆ
ಅಂತ ಹಸ್ಬೆಂಡ್ ಎದುರಿಸಿದ್ರು.
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ Velots the parents of the husband.
ಪೇರೆಂಟ್ಸ್ ಗೂ ಗೊತ್ತಿತ್ತು ಇಲಿಸಿಟ್ ರಿಲೇಶನ್ಶಿಪ್.
ಎಸ್ Velots ಅದನ್ನ ಕೇಳಿದಾಗ Velots ಲೆಟರ್ ಸಿಕ್ತು, ಲೆಟರ್ ಸಿಕ್ಕದ್ಮೇಲೆ ಲವ್ ಲೆಟರ್ಸ್ ಅದನ್ನ ತೋರಿಸಿ ಮನೆಯವ್ರಿಗೆ ಕೇಳಿದಾಗ ಹಸ್ಬೆಂಡ್ ಮದರ್ ಅಂಡ್
ಹಸ್ಬೆಂಡ್ ಟ್ರಯಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಡೀತಾ ಇದೆಯಾ? ಸ್ಟೇ ಮಾಡಿಲ್ವಾ ಅದು?
No, he has not come as far as I know.
ಆ ಟೈಮ್ ಅಲ್ಲಿ ನೀನು ಇದನ್ನೆಲ್ಲ ನೀನು ನಿಮ್ಮನೆಗೆ ಹೇಳಿದಾಗ ಅದು ನಿನ್ನ ಕೊಲೆ ಮಾಡ್ತೀನಿ ಅಂತ ಎದುರಿಸ್ತಾರೆ.
ಅಷ್ಟೇನಾ? The petitioners accused 2, 3 and 4 are before this court calling in question the proceedings, registration of a crime in crime number 13 of 2024 registered for offence punishable under section 498A, 504, 506 and 149 of the IPC read with 3 and 4 of the Dowry Prohibition Act. The accused heard so and so. The accused number 1, Rahul Selvan and the complainant get married on 18 marriage date on 24/1/2021. The marriage, the relationship between the accused number 1 and the complainant appears to have floundered. On floundering of the relationship, the complainant registers a complaint before the jurisdictional police, which becomes a crime in crime number 13 of 2024 for the aforequoted offences. The registration of the crime is what has driven the petitioners to this court in the subject petition. The relationship between the parties are that the second respondent is the complainant. The accused number 2, Phil, Mill and grandmother. 3 is grandmother of the accused number 1. The learned counsel appearing for the petitioner would vehemently contend that a perusal at the complaint would indicate that all the offences are goaded against the accused number 1, the husband, while there is nothing against these petitioners that would become the ingredients of section 498A, 504 or 506 of the IPC. The learned counsel submits that the third accused number 4, who is a resident at Coimbatore and now 75 years old, is also a grandmother, is also dragged into these proceedings only on the score that she has instigated the husband to demand money. The learned counsel submits, well, the allegations against all the petitioners is instigation for commission of certain acts at the hands of the husband. The learned counsel appearing for the respondent would vehemently contend that the complaint is in detail. It pins at overt acts committed by every person, and therefore investigation in the case at hand must be permitted. The learned counsel would seek dismissal of the petition. The learned additional SPP would also submit that the matter is still at the stage of investigation. Therefore, investigation, if permitted, the jurisdictional police would continue the same, and maybe a B report could also be filed against these petitioners. Therefore, this court should not interfere with the registration of the crime. I have given my source. The aforenarrated facts are not in dispute. The relationship between the parties is what is narrated herein above. The husband, accused number 1, is not before the court. The relationship between the husband and the complainant turns sour 2 years after marriage, and several proceedings galore against each other. One such proceeding is the subject complaint. A complaint comes to be registered before the jurisdictional police by the by the second respondent complainant, which becomes a crime in crime number 13 of 2024. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. Madam, typed copy there, page 29 in the 32. So a perusal at the complaint, a cursory perusal at the complaint would clearly indicate that all the allegations against the petitioner are against two persons. One, the husband, the other, the alleged paramour of the husband. In the light alleged paramour of the husband. The further contention is when the letters between the husband and the paramour was put before the parents did not take any action. Even the grandmother who stays in Coimbatore had instigated the husband to demand dowry and torture the complainant. Therefore, all these names spring in the complaint. Whether this would be whether on these ingredients a crime, the investigation should be permitted to be continued or otherwise is necessary to be noticed. The section 498A reads as follows. Section 498A deals with cruelty by family members towards the demand of dowry. The interpretation of section 498A need not detain this court for long or delve deep into the matter. The apex court in Kashkan Kaushar versus State of Bihar in 2022 SEC Online SC page 162 has held as follows. The said judgment is subsequently followed in plethora of judgments of the apex court on the issue. The in 2025 SEC Online SC 2890-2913 Erudu court. So, in the light of the judgments rendered by the apex court as quoted herein above, and the unequivocal facts that are noticed herein above, permitting investigation even against these family members accused 2, 3, and 4, particularly against the fourth accused, who is the grandmother of the first petitioner, would, on the face of it, become first accused, would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, the following order: allowed, quashed. Husband trial should go on. Yes. Charge sheet hakidira husband mele. Hakilva.
Might have filed.
Yes. Next.
But I represent the respondent. This is with regard to additional accused under section 319, my lord.
May I submit your honor?
Oh, really?
An order was passed.
My lordship, the impugned order is passed on application filed on 19 of CRPC, my lord.
Recent development is that according to the information of the state, B report has been filed with respect to another accused who is not before the court. I will have to verify that and I will have to. Because now they say, so far as this accused is concerned, no B report. Only the another accused.
Yes,
who is
how
not
many accused were brought in?
Yes, my lord.
ಎಷ್ಟು ಜನ ಒಳಗ್ ಬಂದ್ರು 319 ಅಲ್ಲಿ?
Two persons.
Further 319 ಮತ್ತೆ ಇನ್ನು ಬಿ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
Hello, that is what the investigation they have done it and.
Sir, they are called back during trial. Where is the question of B report?
That's one. Milord,
I have produced your honor that
petitioner, Milord, yes.
Himself has furnished.
Yes,
ಏನ್ ಹೇಳಿ sir?
My lord, you have not given the copies also.
ಒಂದು ನಿಮಿಷ ತಾಳಿ. Yes.
The impugned order is passed on application filed on 19 of CRPC, your honor. Your honor, this petitioner is the charge sheeted witness CW15, your honor. And further, your honor, the.
ನೀವು ಇಲ್ಲಿ ತಿರುಗಿಸಿದ್ರೆ ಆಗಲ್ಲ, ಪೇಜ್ ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
ಹೇಳ್ದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಓದೋದಲ್ಲ, ಓದ್ಕೊಂಡು ಬರ್ಬೇಕು.
ಓದಿದೆ ಸ್ವಾಮಿ, ಹೇಳ್ದೆ ಸ್ವಾಮಿ.
ಹೇಳ್ಬಿಡಿ.
Earlier, my lord, the complaint has been filed at the instance of the respondent number 2 against unknown persons. After investigation, the police have submitted charge sheet against 2 existing accused, your honor. And after framing charge, your honor, the trial conducted. And after recording of evidence of the CW 1 to 5, your honor, the special public prosecutor has filed a application under section 319 CRPC for summoning this petitioner and other two petitioners, other two persons, Your Honor. These persons are CW14, CW15 and CW17, my lord. And afterwards, Your Honor, the impugned order has been rejected in favor of CW17. And it has been allowed in respect of this petitioner and the CW14, my lord. Thereafter, this petitioner approached the Honorable Court and get stayed in respect of his case, Your Honor. My lord, under section 319, there is no piece of evidence in the evidence of the PW, that is respondent number 2 PW1, Your Honor. Your Lordship may kindly look into deposition of PW1, my lord. My lord, at page number 55.
What is the crime for?
302, my lord.
302.
Yes, 302, my lord. As a page number 55, my lord. ಮುಖ್ಯ ವಿಚಾರಣೆ ವಿಶೇಷ ಸರ್ಕಾರಿ ಯೋಜನೆಯಿಂದ ಮೃತ ಸದಾಶಿವಮೂರ್ತಿ ನನ್ನ ತಮ್ಮ
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದ
ಹೌದು ಸ್ವಾಮಿ
ಇವರು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ
ಇಲ್ಲ ಸ್ವಾಮಿ
ಫಸ್ಟ್ ಟೈಮ್ ಡ್ರಾ ಮಾಡಕ್ ಕಾರಣ ಏನು
PW1 evidence, my lord. So
ಏನ್ ಹೇಳಿದ್ದಾರೆ
may permit to read you.
1 minute. PW1 was not examined at the time of investigation.
Yes, he was examined.
Why he did not say so?
He said so.
Then why did they not file a charge sheet against him?
That is the allegation, madam. That is the allegation by the complainant.
My lord, no, ಆ ರೀತಿ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಈಗ ಹೊಸದಾಗಿ ಹೇಳಿದಾರೆ, ಹೊಸ ಸ್ಟೋರಿ ಹೇಳಿದ್ದಾರೆ. I may permit to read your honor. Deposition. ಮೃತ ಸದಾಶಿವಮೂರ್ತಿ ನನ್ನ ತಮ್ಮ, ಚಾಸ 5 ನನ್ನ ತಂದೆ, ಚಾಸ 6 ನನ್ನ ತಂಗಿ, ನಾವು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಆದಿ ಕರ್ನಾಟಕ ಜನಾಂಗಕ್ಕೆ ಸೇರಿರುತ್ತೇವೆ. 1ನೇ ಆರೋಪಿ ಒಕ್ಕಲಿಗ ಜನಾಂಗಕ್ಕೆ ಸೇರಿರುತ್ತಾನೆ.
ಅದೆಲ್ಲ ಇರ್ಲಿ, ಕರೆಕ್ಟ್ ಇದಕ್ಕೆ ಹೋಗಿ ನೀವು ಸ್ಟೋರಿ ಹೇಳ್ಬೇಡಿ.
ಪೇಜ್ ನಂಬರ್ 57, your honor. 57, your honor. ಕೆಳಗಿಂದ 5ನೇ ಲೈನ್, your honor. ಇಲ್ಲಿ ಅದೇ ರೀತಿ ಬುಲೆಟ್ ಅನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಪಕ್ಕದಲ್ಲಿದ್ದ ಗಂಗೋತ್ರಿ ಸ್ಟೀಲ್ ಅಂಗಡಿಯಲ್ಲಿದ್ದ ಸಿಸಿಟಿವಿ ಫುಟೇಜ್ ಅನ್ನು ಪೊಲೀಸರು ತೋರಿಸಿದರು. ಸಿಸಿಟಿವಿ ಫುಟೇಜ್ ಅನ್ನು ನೋಡಿದಾಗ ನನ್ನ ತಮ್ಮನಿಗೆ ಹೊಡೆದವನು ಯೋಗೀಶ್ ಅಂತ ಗೊತ್ತಾಯ್ತು. ದಟ್ ಇಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, your honor. And further, your honor, next page, your honor. Next page number 60, my lord. ಇಲ್ಲಿ 3ನೇ ಲೈನ್, your honor.
No. ಎವಿಡೆನ್ಸ್ ಇವ್ರನ್ನ ವಾಪಸ್ ಕರ್ಕೊಂಡ್ ಬರಕ್ ಎಲ್ಲಿದೆ?
ಅದು ಸ್ವಾಮಿ, ಅದು ಹೇಳ್ತೇನೆ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೋಗಿ.
ಲೋಕೇಶ್ ಎನ್ನುವರು ನನ್ನ ತಮ್ಮನಿಂದ ಸಾಲ ಪಡೆದಿದ್ದರು.
Don't recreate the scene of crime. You take me to that particular evidence where the accused number 1 would reveal that these people are involved.
Page 59 in the
59 start ಆಗುತ್ತೆ.
59
Last line.
Last part.
May read, my lord.
ಈಗ ಯಾರು ವಾಪಸ್ ಬಂದಿರೋದು? ಲೋಕೇಶ?
No, Girish.
Girish,
ಬಾಲಗಂಗಾಧರ್, ಯೋಗೇಶ್.
And Lokesh. So far as Lokesh and Girish is concerned, the petition was allowed. Application was allowed and they were implemented.
They were complainant witnesses?
Yes, CW 15 and 14, my lord.
Here they were
So
the witnesses.
now they are sought to be transposed as accused.
Yes, please. Now, my lord, so far as the evidence is concerned, 59 may kindly be seen, my lord, for a while. Lokesh, contractor. Girish,
ಬಾಲಗಂಗಾಧರ್, ಯೋಗೇಶ್ ಮತ್ತು
ಗಿರೀಶ್ ಇಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. 59 ಲಾಸ್ಟ್
ವಾರದ ಮುಂಚೆ ಬಾಂಬೆಗೆ ಹೋಗಿದ್ದರು.
ಘಟನೆ ಆಗೋ 1 ವಾರದ ಮುಂಚೆ ಬಾಂಬೆಗೆ ಹೋಗಿದ್ರು. ಬಾಂಬೆಯಿಂದ ಬಂದ 2 ಅಥವಾ 3 ದಿನಗಳ ನಂತರ ಈ ಘಟನೆ ನಡೆದಿದೆ. ಲೋಕೇಶ್ ಎನ್ನುವರು ನನ್ನ ತಮ್ಮನಿಂದ ಸಾಲ ಪಡೆದಿದ್ದು, ಆ ಬಗ್ಗೆ ಲೋಕೇಶ್ ರವರು ಒಂದು ಚೆಕ್ ಅನ್ನು ನನ್ನ ತಮ್ಮನಿಗೆ ನೀಡಿದ್ರು. ನನ್ನ ಪ್ರಕಾರ ಲೋಕೇಶ್ ಎನ್ನುವರು ಯೋಗೇಶ್ ಮತ್ತು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಎನ್ನುವರ ಮೂಲಕ ನನ್ನ ತಮ್ಮನನ್ನು ಕೊಲೆ ಮಾಡಿಸಿದ್ದಾರೆ. Further, he explains, he has gone to before the police station and explained. The next para may kindly be seen, my lord. ACP ಅವರು ಲೋಕೇಶ್, ಗಿರೀಶ್, ಬಾಲಗಂಗಾಧರ್ ಅವರನ್ನು ವಿಚಾರಣೆಗೆ ಕರೆಸಿಲ್ಲ. ಯೋಗೇಶ್ ಮತ್ತು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸಿಕ್ಕಿದ ಮೇಲೆ ಕರೆಸುತ್ತೇವೆ.
ಆಯ್ತು, ಇದಕ್ಕೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ 319?
319 ಗೆ an application was filed.
Prosecution files an application.
Yes, thereafter notice was issued.
Where is the notice? Where is the notice and their reply?
Yes, their reply.
I have filed my objection.
He has not.
ಇಲ್ಲ ಸರ್, ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದು ಎಲ್ಲಿದೆ?
ಇಲ್ಲ
ಪೇಜ್
81. 81.
They complete the other portion of the evidence, my lord, because we are stuck in the middle.
No problem.
Further portion of evidence is there.
Annexure K. Annexure K.
Why was he listed as witness?
My lord, earlier, my lord, during the course of the, because they were all friends, my lord. During there was a monetary disputes because the deceased had lent the money to all these persons. They have hatched a criminal conspiracy and they have committed the murder. But there is a serious criminal conspiracy in between all of these accused persons, and there was a telephone conversation is also there.
Where is the telephone?
The witness himself has produced.
Where is the telephone conversation?
Yes, please. The pen
You
drive.
show me telephone conversation with regard to conspiracy with these people, have dismissed the petition.
Yes, my lord. He himself has produced a pen drive that has been seized. May I just pass it on?
Where is the pen drive?
Pen drive, it is before the trial court, my lord. It is marked.
Where is the transcript of the pen drive?
A transcription of illegal, but a Caesar mark.
Get the transcript of the pen drive.
It does not belong to me, Your Honor.
He himself has produced. He himself.
And more, Your Honor.
1 minute. The petition, heard the learned counsel for the petitioner and counsel for the respondent and the state. The issue in the list is with regard to drawing two persons who were not the accused while filing the charge sheet, registering the crime, nor were drawn as accused at the time of filing the charge sheet. They were in fact shown as complainant witnesses. During the trial, the accused number 1 takes the name of these petitioners that they also could have. And the
PW1 number has not taken, my lord.
PW1.
PW1, that is in the chief examination, Your Honor.
While the conduct of the trial, the PW1 has taken the names of these petitioners, and on the lurking suspicion that these petitioners also could be involved, the prosecution files an application under section 319 of the CRPC. The application, despite the objections of the petitioner, stands allowed, and the petitioners are brought into the web of crime by their transposition from being complainant witnesses to accused. The learned counsel for the complainant submits that there is telephone conversation between the accused number 1 and the present petitioners who were witnesses at that point in time. The issue revolves around the murder of
Sadashiva.
Murder of one Sadashiva, and the complainant counsel submits that all of them were friends, and therefore there could be a conspiracy hatched for doing away the life of the said Sadashiva. Therefore, the learned HCGP shall place on record telephone conversation, if any, between accused number 1 and these petitioners to arrive at a prima facie view of the conspiracy angle, failing which the drawal of these petitioners into the web of proceedings would be illegal. Yes. List the matter on 25th. Yes.
My lord, little early, my lord, because the case is at the advanced stage. The investigating officers, evidence has to be
No
recorded.
problems.
Already
yes. List on 25th. Yes, no problem.
Like, could be taken little early.
No.
Union Bank of India registers a crime.
Union Bank of India
files a complaint with the CBI. I'm sorry, Punjab National Bank. Union Bank of India is the other case.
406, 420.
Against only private individuals.
Here madidna last time.
406. This I pointed out to your lordship some things.
That entire loan is cleared.
No, in this loan is, my lord, we've given a OTS proposal, and that is now, my lord, may I show this letter?
OTS is rejected.
No, there is another one.
New bank or CBI?
CBI.
We have got a communication from the bank.
Correct.
Okay. We've deposited another 4 crores.
The CBI is banking upon the bank.
It's banking upon
bank
the
is banking upon the CBI. Yes.
And Lord, I am banking on this.
On the court.
The registration, Lord, is only against private individuals and unknown public servants, as they normally say. Your lordship's Lord, in that Union Bank's matter, Lord, has taken the view that the state's general consent for CBI is only if there are public officials.
So, angle is
Lord?
Angle is
Now there are no public servants in the complaint, and then Lord, there's one
you
more.
mean Section 6 of the DSP.
Yes, yes. Your Lordship Judgment in Union Bank, my Lord, has then been followed by Justice Arun in another case where he has said that unless you have named the public servant, there is no general consent for the CBI to proceed, and therefore there is no question of the CBI registering an FIR.
They are not proceeding on that general consent. If the bank is involved, if the amount that is involved, a transaction beyond
That is
25
under the fraud
crores,
circular.
straight away it goes to CBI.
Yeah.
They have, the bank has no discretion and CBI has no discretion to say that, no, I will not take it.
True.
General consent is not here, but under 6 of DSP, that circular is drawn by the RBI.
Correct.
So it is automatic. I don't think we should get into that.
But that's the view, my Lord, taken by.
No, I have taken.
Your Lordship has taken a view, my Lord, earlier. Then, my Lord, on banking on the judgment in Union Bank of India, where your Lordships took the view that the transfer can't happen. Another learned single judge, my Lord, has taken a view. I don't know if your Lordship has seen this view.
This is Arun. All right.
In that, my Lord, the conclusion that is drawn is that taking note of the general consent of 2005, which is withdrawn in 2024, that
Are you talking of Union Bank of India's case where the Attorney General appeared?
Yes, that one.
No, that stands on a different footing.
True.
That is on 33 of the RBI.
35A.
35A
of the Banking Regulation
of
Act.
the Banking Regulation Act, where the RBI has supervisory control over every bank.
Yes.
That supervisory control cannot stretch transfer to CBI is what I have said.
Correct.
That also.
But anyway, it's my duty to place this judgment before your Lordship. Let me place it first. And then, Lord, also the fact that this settlement is in progress. OTS. And that may have
Just amount of
11 and odd crores, 11.9 crores. We've already deposited 4 crores.
ಇದು DRT matter.
ಇಲ್ಲ, DRT ಹೋಗಿಲ್ಲ. ಅಲ್ಲ, but under one-time settlements proposal which we've given, we've already deposited 4 crores and we've said we'll by 11.9 by April we'll pay. If that is accepted, Lord, then the entire issue will come to a close.
Where is the proposal?
I just gave you Lordships.
I want to let you around the togoli.
Lord, may kindly see at the bottom, in furtherance to what you
have given it on 16 January 26. What has become of this communication?
This, my Lord, please see the bottom, the signature and the statement
Received
of the
OTS
bank.
proposal as discussed in the meeting held on
20/12.
The same is under
process. And my Lord, I've deposited 4 crores. To show my bona fides, I deposited 4 crores.
Out of the 11.9.
Out of 11.9. And I said by April, I'll pay the rest. I have, my Lord, another 2.9 crores. If they accept, I'll pay another. I have a demand draft right now ready if the bank is willing.
PNB is not before the
PNB is not right. No, but they are also a party, my Lord. They are a party.
Party there, R2. Our principal allegation is not that of 420, which can be compounded. My principal allegation is 468 and 471. Lords, may I bring to my Lord's attention the FIR, Lords? Lords, one, that there is role of public servants where averments to the complaint is mentioned.
So you leave that.
Please.
Even otherwise RBI circular is there.
Please. Lords, insofar as the consideration of OTS, Lords, OTS proposals were given earlier. Lords, which came to be rejected. Lords, I have one copy.
There has been 1 minute. Idalla. OTS proposals had been rejected. The bank the amount had become sticky or whatever it is. Now there is a fresh OTS proposal given on why not on their own volition, but it is on deliberations with the bank.
Please.
See, that is why they received OTS proposal as discussed in the meeting held on 22/12/25. Now, if the crime, it may not vanish, but the rigor of the crime gets diluted. See, ultimately forgery ನೀವು ದುಡ್ಡು ಲಾಸ್ ಆಗಿದೆ ಪಬ್ಲಿಕ್ ಮನಿ ಅಂತ. ಈಗ ಅವ್ರು ಕೊಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಮಾಡ್ಲಿ ಬಿಡಿ.
That is one thing, my lords. The reason why I am emphasizing is this case is not the sole case where petitioner has employed this modus operandi. There is another case also where a similar, in fact, same modus operandi has been employed.
What is that modus operandi?
Lords, what they would do is they would submit sale deeds as collateral properties. Lords, then they would default in loan. Lords, the bank came to know in this case when they went to auction. When the auction was over, when deliberation was going on, ultimately it came to know that the title was itself not in the favor of petitioner.
Title was not?
Title was not in favor of petitioner.
What did the bank officials do while granting loan?
Please, my lords, bank has to overcome. Lords, what the petitioner would further do is, when the demolition was ordered, when demolition was about to be executed, the petitioner would go before the civil court, show the same documents, obtain a temporary order, TI.
ಅದು forged ಅಂತ ಯಾರು ಹೇಳಿದ್ರು?
Not, the bank gives a complaint that it is forged prior.
Where?
No, that's the complaint, no, kindly see the affair.
Bank has given the complaint.
Please, bank
What were the bank officials doing while granting the loan? What was the legal opinion? What was the evaluator's opinion?
We got two
Not,
legal opinions.
the legal opinion also, my lords, appears to be hand in glove with the petitioner. That is what the bank says.
Any proceedings you've initiated against those persons who have given legal opinion or valuation done?
My lords, in the complaint, they are also, my lords, they are not named. Allegations are leveled against them. My lords, there is interim order of stay before this honorable court.
No, parvailla. Interim order of stay in his favor. That's all right. What
Please.
did you do with the others?
Not stay as against all the proceedings is stalled before this honorable because it's on a legal issue. The interim order was obtained on a legal issue.
Complaint illa. Legal issue is DSP.
So other there is stay of all further proceedings. Therefore, we have
the legal issue qua DSP we will answer.
Please.
That's a different thing. What I am now telling you is, first thing is whatever he is saying. If all these documents were available with the bank and those documents only form the fulcrum of the crime now, what were the bank officials doing at the time of grant of loan? And why they are not named in the complaint?
No, my lords, they are named. Kindly see. Kindly see.
And why the others who are who have given that opinion or valuation of the property, all of them are not named? It is not that the manager would sign if it is 5 crores.
Let's understand
it goes to the board.
I understand
Are
what
the
is
members
falling
of the
from my
board,
lords.
are the members of the board lugged into the crime?
I understand what is
I-
falling from my lord.
No.
For a
I'll
moment,
tell
I am
you-
not trying to defend
I tell
them.
you why it is not
For a
done.
moment, I am not trying to
Why
defend
this complaint is registered is the bank to save its officials, to save the top brass in the board, register the crime in such cases.
Lords,
Why? Save their skin. ಕೊಟ್ಟಾಗೋಗ್ಬಿಟ್ಟಿದೆ ಈಗ.
ಇಲ್ಲ ಇದರಲ್ಲಿ
ಬೋರ್ಡ್ ಹೋಗ್ಲೇಬೇಕಾ? 11 ಕೋಟಿ ಲೋನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಬೋರ್ಡ್ ಹೋಗ್ಲೇಬೇಕಾ?
ಹೌದು.
ಬೋರ್ಡ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ಬೋರ್ಡ್ ಏನ್ ಮಾಡಿದ್ರು? ಏನ್ ಅಸೆಸ್ ಮಾಡಿದ್ರು?
I'll just point out one page. ಇದರಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ
ಅದಕ್ಕೆ it is prudent for the bank to keep quiet till it clears the amount.
ಅಲ್ಲ ಅದವ್ರು that they have to answer, my lords. But my lords, what they have stated in the complaint, in this case, in fact, there has been action taken. That is what I want to
Against
point
whom?
out. Bank, the internal inquiry has revealed and
ಅದರಿಂದ ಏನಾಗುತ್ತೆ ಸರ್? ಏನಾಗುತ್ತೆ?
Department.
I have to argue. I understand, my lords. I have to
Departmental
show the averments. I'm showing the averments.
No, in all these cases, banks, what they do is, yes, the board has cleared. Beyond 2 crores or 3 crores, it has to go to the board.
Please, my
The
lords
board,
are right.
the board has cleared everything. Once the board clears, everything goes on. All is well. But if somewhere it breaches, all this will crop up. How about to save their skin, you pull it off.
But this, my lords, is prima facie evident that is a fake document.
What did you do, sir? Where is the legal opinion on that? Fake document and property ilva alli?
The property is not standing in his name. Property, the you resident.
Standing in my name. Now they're saying the extent that is shown originally is less, more, all that is come out now.
Anyway, ಅವರು ದುಡ್ಡು ಬಂದ್ರೆ ಆಯ್ತು. ಎಷ್ಟು ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀರಿ?
As soon as it is accepted.
What is accepted?
So OTS. OTS under process in Brazil.
ಆಯ್ತು.
Therefore I
We'll
give
see.
4 crores straight away.
We'll grant you time till the 15th of April. If no deliberations come about, deliberations does not result in anything, we'll take this matter.
Yes.
Lords, may I request this thing? Insofar as the interim order is concerned, Lords, insofar as your lordship may clarify it is insofar as the petitioner, and insofar as the other persons we may
But
proceed.
I am the main borrower.
Other persons yaru?
No, it's in fact in the bank official.
Public servants ಇದ್ದಾರೆ.
ಇಲ್ಲ, name ಮಾಡಿಲ್ಲ.
Please proceed.
There's no,
That
not a single name.
let that be.
No, ಈಗ ನೀವು ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಮೇಲೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಬಿಟ್ರೆ ಇವ್ರ ಕೇಸಲ್ಲಿ it will frustrate the OTS. Bank will not accept it. ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ, ದುಡ್ಡು ಬರ್ಬೇಕು ವಾಪಸ್.
ಅಲ್ಲ ಅವ್ರ ಕೇಸ್ಗೆ ಬರ್ತಾ ಇಲ್ಲ, ಅವ್ರ ದುಡ್ಡು ಬರುತ್ತೆ ಅಂತ.
ಅಲ್ಲಿ ಇವ್ರು ಕೊಡ್ತಾರೆ ದುಡ್ಡು ಅವ್ರಿಗೆ.
ನಾನು ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Notice is issued, my lords, several occasions.
You don't
Some
worry
lawyer
about
is
them, sir.
appeared.
Yes. We'll record this statement.
Yes, yes.
The learned counsel, heard the learned senior counsel, Dhyan Chinnappa appearing for the petitioner, and Rahul Reddy representing the CBI. The learned senior counsel submits that apart from the merit of the matter upon which an interim order is subsisting today, he would seek to place reliance upon a communication dated 16th January 2026. The communication emerges from the hands of the petitioner to the bank, Punjab National Bank, from whom the petitioner had borrowed finance which has now become sticky. That pursuant to the discussion on 22/12/2025, the proposal, the one-time settlement proposal is being discussed and is under process. Therefore, the hearing of this matter or drawing up, vacating the interim order and drawing up other bank officials would frustrate the one-time settlement proposal that is under consideration before the bank. In that light, I deem it appropriate to grant 6 weeks' time to the petitioner to deliberate upon the settlement and report back to this court. In the event nothing would come about in the next 6 weeks, the matter would be heard upon on its merit. Subject to the aforesaid, the interim order stands continued till the next date of hearing. Adu vacate maadibidtare because DSP is not, cannot be the reason.
Not that your lordship may clarify because of which we are, in other cases also we are facing that issue.
ಈಗ ಬ್ಯಾಂಕ್ ಆಫೀಷಿಯಲ್ಸ್ ಅಲ್ವಾ ಇರೋದು ಅಲ್ಲ ಅದಕ್ಕೆ ಅದರ್ ಕೇಸಸ್ ಅವ್ರನ್ನ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ದಿಸ್ ವಿಲ್ ಗೆಟ್ ಫ್ರಸ್ಟ್ರೇಟೆಡ್.
ಪ್ಲೀಸ್
ವೇಟ್ ಟಿಲ್ 6 weeks.
ಪ್ಲೀಸ್
ಅದೇನು ಆಗಲ್ಲ, ಆಮೇಲೆ ಕ್ಲೋಸ್ ಮಾಡಿ. ಆಗುತ್ತಾ?
ಮಾಡ್ಲೇಬೇಕು.
ಮಾಡ್ಲೇಬೇಕು.
Lordship may fix a date.
Now it has come to the brim. You will have to do something.
He has to, no question. Money has to be repaid. There's no doubt about it.
Yes, list the matter on 15th April. Yes, 24th ಅಲ್ಲ ಇದು?
Yes.
15th April.
Lordship may take it as a last chance because multiple proposals were rejected
earlier. It is the learned counsel Rahul Reddy submits that these OTS proposals have time and again been submitted and rejected by the bank. Notwithstanding the said submission, I deem it appropriate to grant the aforenoted 6 weeks time, as the bank itself indicates that it is under process. But however, this would be the
last chance.
Last opportunity. CBI need not say last opportunity. Bank should say it. Why is CBI saying last opportunity?
We float together. Fortunately or unfortunately.
We'll make it.
Failing which it would be the LTS and Takpudi. Last time settlement.
Some appear for petitions.
OTS alla.
498A petition.
For the respondent in this matter, my lords, a week's time
No
been granted
time.
for filing.
Time ಮಾತ್ರ ಕೇಳ್ಬೇಡಿ.
Objections in a file ಮಾಡಿಲ್ಲ.
25 ಇದು 24 objections ಹಾಕಿದಾರ?
ಇನ್ನ ಇಲ್ಲ. Previous date ಅಲ್ಲಿ ಅವ್ರದ್ದು compliance ಗೋಸ್ಕರ ಬಂದಿತ್ತು ಸುಮ್ಮನೆ.
Interim order ಇದೆಯಲ್ಲ?
ಹೌದು.
ಮತ್ತೆ compliance ಗೋಸ್ಕರ ಅಂದ್ರೆ ಎಲ್ಲ ಲಾಸ್ಟ್ ಏನ್ ಹಸ್ಬೆಂಡ್?
ಇಲ್ಲ ಫಾದರ್ ಇನ್ ಲಾ, ಮದರ್ ಇನ್ ಲಾ, ಬ್ರದರ್
Father in law, mother in law and
Bill mill sell bill. Yes, gone.
There is one more complaint, my lords. ಅದನ್ನ I'll produce it before this honorable court.
ಏನಾರು ಇದ್ರೆ
One
ಹೇಳಿ
opportunity.
ಮೇಡಮ್. ಇಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲ ಅದ್ರೊಳಗಡೆ ಇವ್ರದ್ದು ಮದರ್ ಇನ್ ಲಾ ಅಂಡ್ ಫಾದರ್ ಇನ್ ಲಾದು ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ.
ಯಾವ ತರ?
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದಾರ?
ಇಲ್ಲ ಅಸಾಲ್ಟ್ ಆಗಿದೆ.
ಅಸಾಲ್ಟ್ ಆಗಿದೆ. ಓವರ್ ಟ್ಯಾಕ್ಟ್ ಒಂದಿದ್ರು ತೋರಿಸಿ.
In the year 2023, a complaint was filed. ಅದರಲ್ಲಿ mother-in-law and father-in-law ಅವರಿಬ್ರದ್ದು ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇದೆ. An opportunity may be given. I will file my objections along with the supporting documents.
Because there is no reason in the interim order.
Also, ಅದರಲ್ಲಿ ಅವರು entire charge sheet file ಮಾಡಿಲ್ಲ. I will file it before this honorable court.
ಮಾಡಿ. The learned counsel appearing for the respondent complainant submits that the entire charge sheet material is not placed before the court. If it would be placed, it would drive home certain overtax upon the petitioners, particularly of mother-in-law and father-in-law. In that light, as a last chance, objections or submissions be made by the next date. List the matter on 18th.
Great.
Yes, for admission. Next.
Even Millards, charges are framed Millards on 16/12/24.
Allah, after petition, before petition.
Lordship, I can see in this case, I am appearing for the petitioners in this case.
Yes, sir.
It's before Millards, before filing up.
Your Lordship may kindly see.
ಒಂದು ನಿಮಿಷ. petition ಹಾಕಿರೋದು ಯಾವತ್ತು?
3/7/24.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಯಾವತ್ತು?
Millards 16/12/24.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ
ಏನಾರು ಆಗಿರ್ಲಿ ಒಂದ್ ನಿಮಿಷ
ಸರ್.
ಯಾವತ್ತು? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋ ಡೇಟ್
16
12
ಮತ್ತೆ ಆಮೇಲೆ ಎಸ್ ಸರ್
ಏನಾಯ್ತು ಅಂತ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ಇದು a private
ಬನ್ನಿ
complaint,
ಏನಾಗಿದೆ ಅಲ್ಲ ವಾಟ್ ಇಸ್
a private complaint was logged by second respondent. After filing of the complaint by the petitioner, in this case, my lord, first petitioner, for the recovery of the amount due on a check given by the second respondent. As he has not paid, in view of the dishonor of the check, the first petitioner initiated the proceedings under section 138 of the Negotiable Instrument Act. After initiation of the proceedings under section 138 of the Negotiable Instrument Act, the second respondent herein filed a private complaint on the file of the 12th additional ACMM court in 12th additional ACMM court, alleging that the accused herein has committed the offences under section under section 364, 386, 406, 417, 465, 506, that is section 34 of IPC. My lord. Your lordship may kindly see, the said complaint was registered as PCR number 131416 of 16. In fact, the matter was referred to the Madiwala police station for investigation and report. The Madiwala police, after investigation, submitted the B report. The second respondent challenged the B report by filing a memo, protest memo. And after that, the inquiry was conducted by the 12th additional ACMM court. When the complaint filed by the second respondent was pending, that is first complaint, suppressing the fact of filing of the complaint before the 12th additional ACMM court, the second respondent filed a similar complaint on similar set of facts and documents before the third additional civil judge and MFC court at Anekal Manor. The matter was referred to the Attibale police station. Attibale police, after investigation, submitted the charge sheet. On that basis only, the CC has been registered against the accused, that is the petitioners in this case, my lord. This is nothing but abuse of process of law, my lord. In fact, your lordship may kindly see, during the pendency of the first complaint filed by the second respondent in this case, suppressing the fact is the second respondent.
ನೀವು ಅದು ಹೇಳಿದ್ಬಿಟ್ಟು ಪೇಜ್ ಹೇಳಿ. ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಯಾವುದು?
First complaint. Page number 8. Document.
Page.
ಹೇಳ್ತೀನಿ. The first complaint.
Just 130. File number 115.
PCR number, first complaint is page number 79, my lord. Page number 79. Ink page number 79. Document number 6. Your lordship may kindly take page number 79. That is the order passed by 93, my lord. 93. The order passed by the learned 12th additional ACMM court, my lord. I will read the relevant portion, my lord. It is to be noted that the complaint herein is the accused in CC number 1256 2016 in CC number so and so against him. A civil suit in OS number 712 of 2016 is also filed. Disputes are pending before the court for adjudication. The complainant or his wife are at liberty to defend themselves in the aforesaid cases under the above facts and circumstances. The court feels that the present complaint is premature. The complaint is at liberty to file a fresh complaint against the accused person subject to the result of the aforesaid cases. The complaint made out no prima facie case to proceed against the accused person. The said order was passed on 31/5/2023, my lord. During the pendency of this complaint, that is private complaint, the second respondent herein once again filed a similar complaint on 16/3/2019. The ink page number that's 98. Second before the third additional ACMM court and Anekal. Against that, yes, after investigation, the charge sheet was filed.
Yes, sir.
My lord, it is totally different. They went to the home of this respondent number 2 and make a galata and also threatened him and dragged him to their court. And the people were gathered.
ಈಗ ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ PCR 13141 of 2016 second complaint.
That is totally different facts, my lord. The complaint is not produced. Only the order has been produced along with the petition.
You file a synopsis
Yes, my lord.
of facts, dates and events.
Yes, my lord.
It is impossible to decipher from on the petition.
And I may also be permitted to
Please,
file
Yes, I will
objections.
file.
the parties to the list to file a short synopsis of the maze of facts in the case at hand.
Yes, my lord.
List on 25th. Yes. Offense, sir.
Offense 420, 506 and section 3, 1R and S of
Atrocities
SC.
Act.
ಇವ್ರು ಹೇಳ್ಬೇಕಾ? ಅವ್ರು ಮಾಡ್ತಾರೆ.
Much obliged.
Offense ಯಾರಿಲ್ವಾ?
My lord, I appear for the petition in this case, my lord.
7-0.
7-0, my lord. My lord, in this case, there were
Settlement
three-
ಎಲ್ಲಾಗಿದೆ?
Settlement ಆಗಿ
Mediation ಅಲ್ಲ?
mediation ಆಗಿದೆ ಸ್ವಾಮಿ. Mediation ಆಗಿ report ಆಗಿದೆ ಸ್ವಾಮಿ. And the same has been done the decree as well. Your lordship
ಎಲ್ಲಿ
can find it
ಕೊಡಿ?
at page number 42, my lordship. It's a part of the plaint, my lord.
ಕೊಡಿ.
Page number 42, my lord.
ಯಾವ್ದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಂತಿದೆ. ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ? 89 mediation.
My lord, that's the decree, my lord. That's the decree in MC
Where
number.
is the memorandum of settlement that you filed?
Memorandum settlement, I don't have the copy of the memorandum settlement. my
Mediation
lord.
ಇಲ್ವಾ?
Mediation
Mediation
though-
report ಅಲ್ಲಿ.
Mediation report, I don't have the certified copy, my lord. But
Which
this-
copy you have? ಕೊಡಿ sir.
that's been reflected in the decree as well, my lord. The same
Which
terms.
page, sir?
That's page number 42, my lord.
ಇದನ್ನ reproduce ಮಾಡ್ಲಾ?
My lord?
ಇದನ್ನ reproduce ಮಾಡ್ಲಾ?
Yes, my lord.
Page 42 ನೋಡಿ sir.
I'm sorry, the decree is at page number 38, my lord.
That's all right. MC 207 of 2021 ಅಲ್ಲಿ mutual consent ಗೆ ಹಾಕಿದಿರಲ್ಲ?
Yes, my lord.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ?
Other
The
than
above
page-
mental consent petition. ಅದನ್ನ ಇಲ್ಲೂ ಹಾಕ್ಬಿಡ್ತೀವಿ.
ಇಲ್ಲ, my lord, the
Mental
thing-
consent.
No.
ಮತ್ತೆ
Page number,
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ.
yes, ma'am. Page number 42 and paragraph number 11, my lord. In paragraph number 11,
ಇದೊಂದು ಮಾತ್ರ ಹಾಕಿ ಮೇಡಮ್. ಇದೊಂದು ಪ್ಯಾರ ಮಾತ್ರ ಹಾಕಿ. The petitioners are before this court calling in question so and so. During the subsistence of the subject petition, the parties to the list have settled the dispute amongst themselves by drawing up certain terms of settlement. In MC 207 of 2021, one of the term of settlement is closure of these proceedings. The term of settlement reads as follows. ಇದು ಕೊಟ್ ಮಾಡಿ in that light closed. Yes.
oblige, my lord.
Yes, next.
And for the petition, please. Respondent number 2 present with us.
Offense
498A.
yes, ಕೊಡಿ. ಎಲ್ಲಾಗಿದೆ ಸೆಟಲ್ಮೆಂಟ್? Mediation.
Mediation center.
ಸರಿ. ಆ mediation ಏನಿದೆ ಅದು ಹಾಕ್ಬಿಡಿ. Extract ಮಾಡಿ. Executed. Next.
Both parties present.
Signature ಮಾಡಿ.
Please, oblige.
498 AM.
498 AM, my lords.
ನೀವು ಸೆಟಲ್ಮೆಂಟಾ?
My lords, the second respondent is not appearing in the matter, my lord. She agreed for
ಅಲ್ಲ ಅಲ್ಲಿ ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
in the MC proceedings.
Huh?
In the MC proceedings, my lords,
Kodi.
I have produced. Lords, may kindly have page 15, my lord. One of the term of this agreement is to cooperate for quashing of these proceedings, but she is not appearing, my lord.
That's all right. Where is mediation ಆಗಿದೆಯಲ್ಲ?
Agide. Ink page 50.
ಇದರಲ್ಲಿ ಫುಲ್ ಹಾಕ್ಬಿಡಿ ಮೀಡಿಯೇಷನ್ ಆಗಿ ಇದು ಫಾರ್ಮೆಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಯಾರು ಇಲ್ಲ ನೋಬಡಿ ಇಸ್ ಪ್ರೆಸೆಂಟ್ ಹಿಯರ್
No, my lords.
ನೀವೇ ಸೈನ್ ಮಾಡಿ ಎಸ್
Your lordship, if I may mention, serial number 58 is for settlement.
Settlement,
Yes.
sorry.
58. List one.
You are there?
For respondent number 2.
Offense
498A and sections you done.
settled where?
Outside court, your lordship.
There's a
Compounding application ಹಾಕಿದ್ದೀರಾ?
Yes.
The petitioners are before this court calling in question the proceeding, crime or charge sheet?
crime, my lord.
Registration of a crime in crime number 25 of 2025, registered for offense punishable under so and so ನೋಡ್ಕೊಳ್ಳಿ. During the substance of the petition, the parties to the list have settled the dispute amongst themselves and by drawing certain terms of settlement, and have preferred an application seeking compounding of the offense under section 359 of the BNSS read with 528 of 359 read with 528 of BNSS. Will join me, Maile?
Page number 13, my lord.
And the joint memo, insofar as the present petition is concerned, reads as follows. Page 14. Page 14, mark portion. In the light of the offense being the one punishable under section 85 and 1152 of the BNS, I deem it appropriate to accept the application seeking compounding of the offense and close the proceeding against the petitioners. Disposed quashed. Next.
One submission. Serial number 67, they have not come up for compromise, my lordship.
27 merits ಮೇಲೆ ತಗೋಬೇಕಾ?
Yes, my lordship.
67 ಅಲ್ಲಿ parties to the list submit that the talks of settlement have failed. ಯಾವ ವರ್ಷದ
ಅವ್ರ
ಮೇಡಮ್?
ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡಿದ್ದು
ಯಾವ ವರ್ಷದ್ದು?
2023 ದು.
List the matter on 24th for admission.
Settlement, your lordship. Serial number, the list number 3, serial number 2. Settlement, your lordship. What is up?
List number 1.
3.
List number 3 ಕರ್ದಿಲ್ಲ.
Serial number 2, settlement.
Offense.
326, last time ಬಂದಿತ್ತು. 2002 incident.
ಕೊಡಿ.
Complaint.
The petitioners are before this court calling in question the pendency of the proceedings between the pendency of the proceedings against them in CC, in SCL.
ಅಲ್ಲ CC, yes,
In CC.
Umesh P.
CC ಏನೋ?
CC number is
CC ಆಗಿದೆಯೋ ಇಲ್ವೋ?
ಆಗಿದೆ.
In CC 917 of 2024,
2024,
registered for offense punishable under section 326 and 34 of the IPC. During the subsistence of the petition, the parties to the list have settled the dispute amongst themselves and have filed an application seeking compounding of the offense under section 359(8) of the BNSS. The settlement, joint memo ಅಲ್ಲಿ
next ಕೊಟ್ಟಿದ್ದೇನೆ ಅದರಲ್ಲಿ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೇನೆ.
Joint affidavit. The joint affidavit reads as follows. Affidavit. Though the offense is the one punishable under section 326 of the IPC, the normal circumstance would not be permitted to be compounded. The issue in the list is a complaint that was registered in the year 2002 is now sought to be tried before the concerned court in the year 2026, which is 24 years after the incident said to have happened. Therefore, the improbability that shrouds the incident that has happened 24 years ago, I deem it appropriate to accept the application seeking compounding and close the proceedings against these petitioners. Disposed quashed. Next. Yeah, madam. Withdrawal in terms of for a memo. For withdrawal. Memo, in terms of the memo, yes. ಆಯ್ತು.
I appear for the petitioner 498 AM, lords.
ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Outside
I appear
court.
for R2, please.
ಔಟ್ಸೈಡ್ mediation
ಅಲ್ಲ mediation ಏನಾಯ್ತು ಔಟ್ಸೈಡ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಯ್ತು. Thereafter we have approached court together for dissolution of marriage.
ಆಯ್ತು.
ಅದು ಡಿಕ್ರಿ ಹಾಕಿದ್ದೀನಿ.
ಡಿಕ್ರಿ ಆಗಿದೆಯಾ?
ಡಿಕ್ರಿ ಆಗಿದೆ, ಅದು ಹಾಕಿದ್ದೀನಿ.
The heard sounds.
R2 have filed vacant.
Petitioners are before this court calling in question the proceedings in so and so. During the subsistence of the petition, the parties to the list have settled the dispute, by drawing up certain terms of settlement. It transpires that the said terms of settlement was placed before the concerned court in the original suit pending between the parties. And the court, accepting the settlement, has drawn a decree of such divorce, such settlement also. In that light, I deem it appropriate to accept the compounding ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ? Accept the application seeking compounding of the offences and obliterate the crime against the present petitioners. For the aforesaid reasons, the disposed, quashed.
Lords, may I mention serial number 1, my lords, in the 230 mood matter.
Aral
1.1 only, that my lords we are withdrawing.
1.1 ಮಾತ್ರ
1.1.
ಮತ್ತು 1ಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ 1.1 ಮಿಕ್ಕಿದೆರಡು ಇದೆ ಮಿಕ್ಕಿದೆರಡು ಬೇಡವಾ
ಅದರಲ್ಲಿ ಡಿಫರೆಂಟ್ ಇಶ್ಯೂಸ್ ಇನ್ವಾಲ್ವ್.
ಆಯ್ತು ಸರಿ ಎಂಟ್ರಿ ಮಾಡೋಸ್ ಇದೆಯಾ ಅದರಲ್ಲಿ ಮಿಕ್ಕಿದೆರಡರಲ್ಲಿ
ಇಲ್ಲ, ದಟ್ಸ್ ಓನ್ಲಿ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ರಿಲೀಸ್ ಆಫ್
ಆಯ್ತು
ಪ್ರಾಪರ್ಟೀಸ್
ಅಷ್ಟೇ 230 ಇನ್ನೊಂದು ಅಷ್ಟು ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ ಮಧ್ಯಾಹ್ನ 1:30ಗೆ ಮೂವ್ ಮಾಡಿ ಬಂದಿಲ್ಲ ಬರತ್
My lords, on the serial number 69, my lords, it's
I'm
for
not
reporting
raising,
of
madam.
settlement. Apologies.
Settlement what happened?
My lords, I have not moved it for settlement, my lords, it's erroneously listed for settlement.
All right, no problem.
There's an interim order, my lords.
There is an interim order.
Please, my lords. Serial number 69, my lords, of list 1.
Matter is settled ಅಂತ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
No, my lords.
All right, sir. Yes.
Apologies.
List the matter after 2 weeks. Interim order subsisting will continue to the next date of hearing. Yes.
Grateful, my lords.
Next. ಮುಗಿತಾ ಇಲ್ಲ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಮುಗಿತಾ ತೇಜಸ್ ಇರಿ ಹೋಗ್ಬೇಡಿ ಎಸ್
For the respondent number 2, my lords.
Restaurant.
Respondent number 2, my lords.
May be permitted to address my arguments.
Oh, idu. Yes, sir.
Manager in petrol pump.
Correct.
He was working as manager in the petrol pump which was
Misappropriation.
Misappropriation.
Really, sir?
It is alleged that, they had started the petrol pump in the year 2019. Since 2019 till 2022, it is alleged that the petitioner has misappropriated a sum of rupees 1,70 lakhs and add 70 lakhs and add. In fact, the complaint, a private complaint came to be filed in the year 2022, which was referred for investigation under section 156 of class 3. Subsequently, after investigation, the respondent police now have filed the charge sheet. If complaint is perused, which is at page number 90, if my lords turns to page number 93, my lord, paragraph 13, last 10 lines from bottom, my lord. ಆರೋಪಿಯು ಪ್ರಾರಂಭದಿಂದಲೇ ಅಂದರೆ ಸುಮಾರು 2019 ಜನವರಿ ತಿಂಗಳಿಂದ ಆರೋಪಿಯು ಕೆಲಸ ಬಿಡುವವರೆಗೂ ಪ್ರತಿ ತಿಂಗಳು ಅಂದರೆ ಸುಮಾರು ಹಣವನ್ನು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡು ಪೆಟ್ರೋಲ್ ಬಂಕಿಗೆ ನಷ್ಟವನ್ನುಂಟು ಮಾಡಿರುತ್ತಾರೆ. ಈ ರೀತಿ ಫಿರ್ಯಾದುದಾರರು ಪೆಟ್ರೋಲ್ ಬಂಕ್ನಲ್ಲಿ ನಡೆಯುತ್ತಿರುವ ವ್ಯವಹಾರದಲ್ಲಿ ನಷ್ಟವಾಗುತ್ತಿರುವ ಬಗ್ಗೆ ಆರೋಪಿಯನ್ನು ವಿಚಾರಿಸಿದಾಗ ನಂತರ ಆರೋಪಿಯು 2019 ಜನವರಿ 2022 ಫೆಬ್ರವರಿವರೆಗೂ ಪುಸ್ತಕಗಳನ್ನು ಕಾಣೆಯಾಗದಂತೆ ಮಾಡಿರುತ್ತಾರೆ. Since 2019 till 2022, they had alleged that there was misappropriation. No complaint is lodged by the second respondent immediately thereafter. In a petrol pump, every day a reading will be taken. So the accounts have to be settled on the very same night when the readings are closed. But if at all, the petitioner had misappropriated the funds, the second respondent ought to have lodged the complaint immediately. So here is a case where there is delay of 3 years in lodging the complaint. That apart, there is nothing on record in order to show that the petitioner was working as a manager in the petrol pump which was run by the second respondent. There is not even a offer or acceptance letter which was issued by the second respondent or by the petitioner. So under that circumstance, they cannot claim that I was working as a manager in the petrol pump which was run by the second respondent. So my lord, the second respondent has filed a civil suit
For what?
seeking recovery of this very same money.
ಕೊಡಿ. ಯಾವಾಗ ಹಾಕಿದ್ರು ಅದು?
Now in the 2025, my lord.
ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆಯಾ?
Please.
ಅದಕ್ಕೆ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿರೋದು.
If prior column is perused, my lord, at page number 5. Directing defendant to pay a sum of rupees 1,71 lakhs
ಇಲ್ಲ ಅದು
34,000.
ಲಿಮಿಟೇಷನ್ ಆಗೋಗ್ಬಿಡುತ್ತಲ್ಲ ಅಂತ ಹಾಕಿದ್ದಾರೆ. 3 ವರ್ಷ ಆಗೋಗ್ಬಿಡುತ್ತೆ. ಇಲ್ಲಿ ಅಕಸ್ಮಾತ್ ಹೋದ್ರೆ ಅಲ್ಲಿರ್ಲಿ ಅಂತ. ಅಲ್ವಾ?
I was not aware of this, my lords.
Now you have become aware. I will close this. ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
No, my lords. May I?
Yes, sir.
Lords, I'd like to draw your lordship's attention to page number 31, my lords. The charge sheet running page.
Come to 37.
Kindly appreciate the
37th.
Column number 17.
Please, my lords.
ಈ ಪ್ರಕರಣದ ಆರೋಪಿಯು
2020ರ ಮಾರ್ಚ್ ತಿಂಗಳಿನಿಂದ 2028ರ ಏಪ್ರಿಲ್ 22ರ ಏಪ್ರಿಲ್ ವರೆಗೂ ಸರಗೂರು ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಬಿಡಗಲು ಗ್ರಾಮದ ಸಮೀಪ ಇರುವ ಸೋ ಅಂಡ್ ಸೋ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಅಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಆಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಬಂಕಿನಲ್ಲಿ ಮಾರಾಟ ಮಾಡುವ ಹಾಗೂ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಜವಾಬ್ದಾರಿಯನ್ನು ಹೊಂದಿದ್ದು, ಆ ಅವಧಿಯಲ್ಲಿ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ನಲ್ಲಿ ನಿರ್ವಹಣೆ ಕರ್ತವ್ಯದಲ್ಲಿದ್ದಾಗ ಆಯಾ ದಿನದ ಡೀಸೆಲ್ ಮತ್ತು ಪೆಟ್ರೋಲ್ ಮಾರಾಟದಿಂದ ಬಂದ ಹಣವನ್ನು ಬಂಕಿನ ನಿರ್ವಹಣಾ ರಿಜಿಸ್ಟರ್ಗಳಲ್ಲಿ ಕ್ರಮಬದ್ಧವಾಗಿ ನಿರ್ವಹಿಸಿದ ಆಯಾ ದಿನ ಸಂಗ್ರಹಣೆಯಾದ ಒಟ್ಟು ಹಣವನ್ನು ಬ್ಯಾಂಕಿಗೆ ಜಮಾ ಮಾಡದೆ ಪೊಲೀಸ್ ಬಂಕಿಗೆ ಪೆಟ್ರೋಲ್ ಬಂಕಿಗೆ ನಷ್ಟವನ್ನುಂಟು ಮಾಡುತ್ತಿದ್ದೇನೆಂದು ಗೊತ್ತಿದ್ದು ಸಹ ಸಂಗ್ರಹಣೆಯಾದ ಹಣದ ಪೈಕಿ ಭಾಗಾಂಶ ಹಣವನ್ನು ಬ್ಯಾಂಕಿಗೆ ಜಮಾ ಮಾಡಿ ಭಾಗಾಂಶ ಹಣವನ್ನು ಪ್ರತಿದಿನ ತನ್ನ ಸ್ವಂತಕ್ಕೆ ಬಳಸಿಕೊಂಡು 2020ರ ಮಾರ್ಚ್ ನಿಂದ 22ರ ಏಪ್ರಿಲ್ ವರೆಗೆ ಸುಮಾರು 1,11,74,000 ಸಮ್ ಅಮೌಂಟ್ ಹಣದ ನಂಬಿಕೆ ದ್ರೋಹ ಮಾಡಿ ತನ್ನ ಸ್ವಂತ ಉದ್ದೇಶಕ್ಕಾಗಿ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡು ಹಣಕಾಸಿನ ವಿಚಾರವನ್ನು ಮಾಲೀಕರಿಗೆ ತಿಳಿಸದೆ ವಂಚಿಸಿದ್ದಾನೆ ಅಂತ. Kindly appreciate the materials that is on record, my lords. That is on page number 31. That is the transaction from the husband of the complainant to the accused and that misappropriated funds that is in the document number 2, my lords.
What were you doing if he went on misappropriating?
Please, my lord.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
My lords, the accused is not an unknown person to the de facto complainant. He's very well, he's first cousin of the de facto complainant.
Family member.
Out of the trust and ಇವ್ರ ತಂದೆ ಏನಿದ್ರು ಇವನಿಗೆ ನಾನು ಬಂಕ್ ನಾನು ನೋಡ್ಕೊಳಕ್ ಬಿಡ್ತೀನಿ ಅನ್ನೋ ನಂಬಿಕೆ ಮೇಲೆನೆ.
ಈಗ ತಂದೆ ಎಲ್ಲಿದ್ದಾರೆ?
ತಂದೆ the father is dead.
ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಬಂದಿದೆ.
ಆಮೇಲೆ ಇವರಿಗೆ ಏನ್ ನಡೀತಾ ಇದೆ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಅಲ್ಲಿ ಅಂತ ವಿಚಾರಿಸಕ್ ಹೋದಾಗ ಅವಾಗ they came to know about all these transactions because I have submitted the audit report also. Auditor was keep on telling ನಿಮ್ ಬಂಕ್ ನಲ್ಲಿ ಏನೋ ಸರಿಗ್ ನಡೀತಾ ಇಲ್ಲ ಅಂತ. Then they come to know about this misappropriation of funds.
Did the father take any action during his lifetime?
No, he had informed.
ಯಾರಿಗೆ?
Complainant ಗೆ. It was all basis of trust, my lords.
ಅಲ್ಲ ಎಲ್ಲಿ?
No, my lords, that is on not on record. ಅದೇ ಹೌದು ಇವ್ರ father
on trust. For breach of trust there should be entrustment of some property.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಇದೇನೆ ಇವ್ರು ಏನೇನ್ ಮಾಡಿದ್ದಾರೆ ಪ್ರತಿಯೊಂದು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಕೂಡ ಅಮಾನತ್ ಮಹಜರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಪೊಲೀಸ್ ಅವರು.
ಅದ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್,
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿದಿರಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
ಮೈ ಲಾರ್ಡ್ಸ್, the civil suit and criminal suit are both are two different things.
No, ಇದರಲ್ಲಿ ಎಲ್ಲ
go hand in hand.
Recovery of money, sir.
Well, the recovery of money is already is there, my lords.
Iವಾಗ ಹಾಕಿರೋದು the only by
reason
registering this criminal case you want money to come back. ಹೌದಾ ಇಲ್ಲ?
No, my lords, he should be punished somehow, my lords. For the 1 crore is not a small
ಆಯ್ತು,
amount.
ಇವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದು ಎಲ್ಲಿದೆ ಮ್ಯಾನೇಜರ್ ಆಗಿ?
I have submitted through the memo, my lords. Audit report ಮತ್ತೆ
Audit report ಅಲ್ಲ sir, ಇವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದು ಎಲ್ಲಿದೆ?
ಎರಡನ್ನು ಒಟ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಕ್ ಬಂದೆ ಅಷ್ಟೇ. There is an appointment letter, my lords. If not, I have a copy.
ಕೊಡಿ ಒಂದ್ ನಿಮಿಷ, ಎಲ್ಲಿದೆ ತಾಳಿ? ಎಲ್ಲಿದೆ ಕ್ಲೈಂಟ್? ಎಲ್ಲಿದೆ ಕಾಪಿ ಕೊಡಿ ಒಂದು
ಪ್ಲೀಸ್ ಭಾರತ್.
ಕೊಡಿ ಅದು ಕಾಪಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. Yes, sir.
Lord, there is no acceptance by me.
ಮತ್ತೆ ಯಾಕೆ ಕೂತಿದ್ರಿ ಅಲ್ಲಿ?
It's only just a letter.
ಅಲ್ಲ ಜೀವನ್ ವಿಟ್ನೆಸ್ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ, ವಿಟ್ನೆಸ್ ಅಷ್ಟು ಜನ ಯಾರ್ಯಾರು ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದವ್ರು ಅಷ್ಟೇ ಜನ ಇವನೇ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದು. ದ ಸೇಮ್ ವೆರಿ ಸೇಮ್ ಅಕ್ಯೂಸ್ ಹೂ ಹ್ಯಾಸ್ ಅಪಾಯಿಂಟೆಡ್ ಆಲ್ ದಿ ರೆಸ್ಟ್ ಆಫ್ ದ ಟೀಮ್ ದಟ್ ಇಸ್ ವರ್ಕ್ಸ್ ವಿತ್ ಹಿಮ್ ಇನ್ ದ ಪೆಟ್ರೋಲ್ ಬಂಕ್. ಎವ್ರಿಬಡಿ ಇಸ್ ಅಪಾಯಿಂಟೆಡ್ ಬೈ ಹಿಮ್ ಓನ್ಲಿ. And even 97, page number 97, Amanat Majar Ali, every transaction is listed, my lords. ಪ್ರತಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಎಲ್ಲಿಂದ ದುಡ್ಡು ಬಂದಿದೆ, ಎಲ್ಲಿಗೆ ಹೋಗಿದೆ ಅನ್ನೋದನ್ನ ಪ್ರತಿಯೊಂದನ್ನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
Yes, sir.
Blood,
You want to file discharge, you file, otherwise I'll pass an order.
Every day, blood, there will be a readings taken in the petrol.
No, here's some semblance of explanation. Now the father was running the show. You have hoodwinked and eaten off.
No, blood, since I had left the job, blood, thereafter, blood, they had filed the complaint.
No, you said there is no order of appointment at all. There is.
There is no acceptance by me.
That's all.
There is no acceptance by me.
No. ನೀವು ಅಲ್ಲಿ ಕೂತ್ ಕೆಲಸ ಮಾಡಿದ್ರೆ acceptance. Yes. Anything else?
But in fact, blood, they allege that, blood, since 2019 till 2022, blood, I had misappropriated the funds.
Correct.
Daily,
ಅದು
on daily
ಗೊತ್ತಾಗಿರೋದೇ
basis.
ಅವಾಗ.
On daily basis. Blood,
FIR came to be registered on 28 2022 only.
Blood, daily, blood, I have to settle the accounts. Blood, I have to take the readings in the morning. While closing the reading,
No,
blood,
the whole problem is you appear to have taken advantage of being a family member. Very.
blood,
In all the
if
documents,
at
it is a
if at
matter
all,
of
blood,
trial,
the
my
complaint-
lords.
if at all, blood, the
Does not
complaint
come
is
under-
No,
perused.
this is matter of evidence.
Blood, if the complaint is perused, blood, which is at page number 93, paragraph
No,
12.
no,
blood,
sir.
they had availed loans in order to run the petrol pump. Blood, paragraph.
All that is a matter of evidence.
Paragraph 12, blood, for a moment, blood, paragraph 12 at page number 93.
Yes, sir.
Paragraph 12 at page number 93.
Hmm.
ಅಲ್ಲದೆ ಫಿರ್ಯಾದುದಾರರು ಅವರ ಯಜಮಾನರ ಅಕ್ಕನಾದ ಲಕ್ಷ್ಮಿ ಎಂಬುವರ ಹೆಸರಿನಲ್ಲಿ ತಮಿಳುನಾಡಿನ SBI ತಲೆವಾಸನ್ ಶಾಖೆಯಲ್ಲಿ ದಿನಾಂಕ 24/9/2019 ಕ್ರಮವಾಗಿ 2,27,000 ಹಾಗೂ 2,40,000 ರೂಗಳನ್ನು ಒಟ್ಟು 4,63,000 ರೂಗಳನ್ನು ಸಿಟಿ ಯೂನಿಯನ್ ಬ್ಯಾಂಕ್ ಚಿನ್ನಸೇಲಂ ಶಾಖೆಯಲ್ಲಿ ಸಾಲವಾಗಿ ಪಡೆದುಕೊಂಡಿದ್ದು, ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು. ಅದು
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ ಸರ್?
blood, he was in debts. Blood, the money which was received by way of cash, blood, it was being credited to the loan accounts. Blood, in fact, blood, if at all I had misappropriated the funds, blood,
No, we don't know.
complainant would have lodged the complaint immediately. Blood, there will be blood, auditing for every month. Blood, if at all, blood, there was misappropriation, the auditor would have brought to the notice of the complainant herein with regard to the misappropriation. In fact, blood, there was no such auditing since 2019 till 2024. Only after lodging of the private complaint, blood, a auditor's report came to be.
The FIR is only
filed in
registered
the
on
police
2022,
station.
please, my lords. Not on
You
24.
file discharge if you want, otherwise difficult.
Kindly vacate this.
Since there is abnormal delay of.
Dismiss, please.
ಸ್ವಲ್ಪ ಸುಮ್ನೆ ಇರ್ತೀರಾ? Yes.
Since, blood, there is abnormal delay of 3 years in lodging the complaint. Blood, if the
No,
second
this is-
respondent was a
see,
prudent
this
man.
is- This misappropriation does not stop at 2020. It is a calculated move, continued up to 2022. Till you were
Every
in
month,
charge.
every month, blood, there will be GST returns which
You-
have to be filed, blood.
You file discharge, we will see.
Blood, in
You
fact,
can,
blood,
you'll come
certain
back,
amount.
you'll come back anyway after discharge, yes.
Grateful.
Discharge ಹಾಕಿ. File discharge, yes.
Certain amounts were also deposited to the daughter of the
No,
second
it's a
respondent.
case of misappropriation, so you file discharge, yes. ಆಮೇಲೆ ಬನ್ನಿ ನೋಡೋಣ ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ. ಇಲ್ಲ ಏನಾದ್ರೂ ನಾನು ನೋಡಿ ನೀವೇನು ಗಾಬರಿ ಆಗ್ಬೇಡಿ.
ಡಾಕ್ಟರ್ ಕ್ರೆಡಿಟ್ ಮಾಡ್ಕೊಂಡಿರೋದಕ್ಕೆ
Certain-
ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡಿದೀವಿ ಈಗ ನಾವೆಲ್ಲ ಅವರ ಅಕೌಂಟ್ಗೆ ಅವ್ರ ಡಾಕ್ಟರ್
ಡಿಸ್ಚಾರ್ಜ್ ಅಲ್ಲಿ ಹೇಳಿ ಎಲ್ಲ ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿ ಬನ್ನಿ. ದಿ learned counsel appearing for the petitioner
ಸೂಟ್ ನಡೀತಾ ಇದೆ.
after they arguing the matter at length would seek leave of this court to avail the remedy of filing a discharge. The plethora of documents are sought to be placed before this court. I deem it appropriate to direct the petitioner to place it before the concerned court while filing an application seeking discharge. The concerned court shall consider those documents and pass necessary orders in accordance with law within the powers available under section 227 of the CRPC.
239 applies before.
239, sorry, 239 of the CRPC. Yes.
Dismiss.
Illa allowed. Yes.
No, my lord.
Yes.
Grateful. Please, my lord.
Oh,
The
disposition.
trap case, please, my lord, and
ಯಾವ್ದು ಇದು? Serial number?
33.
33, please.
Ah, failed trap.
No, no, my lord.
No, my lord. It's a successful trap, please, my lord.
Successful
The
page
officer-
numbers, everything
Pudi
is
sir, yes.
Officer who registered the FIR was not competent, please, my lord.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ sir.
That, my lord, and the charge sheet was also submitted by the same officer who was not vested
ಏನ್ ಪರವಾಗಿಲ್ಲ
for,
ಬಿಡಿ sir.
please, my lord.
ಪರವಾಗಿಲ್ಲ.
Lords.
That, my lord, this is covered by the.
Oh, not in a trap
filed
case.
appeal, there
That
is a
my lord.
stay. We have filed appeal, there is a stay, Supreme Court.
ಯಾವ್ದು matter
Our
ಅದು?
Hemant Chandan Gaud, his lordship Justice Hemant Chandan Gaud was pleased to take a view that it is police inspector himself who has to register the FIR. And a batch matter was allowed, as against which we have filed an appeal.
ಇಲ್ಲ
and
ಅದು
the-
ರಿವರ್ಸ್ ಆಗಿದೆ.
ಇಲ್ಲ, operating
ಬೆಳಿಗ್ಗೆ
portion.
ಕೊಟ್ರಲ್ಲ ಇನ್ನೊಂದು ಜಡ್ಮೆಂಟ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has reversed it and sent it back. ಯಾವ್ದು ಹಳೆ ಆರ್ಡರ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
No, we checked it as of yesterday, my lords, that is a stay operating.
ಬೆಳಿಗ್ಗೆ ಐ ಥಿಂಕ್ ಬೇರೆ ಯಾವ್ದೋ ಕೇಸ್ ಕೊಟ್ಟು ಕೇಸ್.
In an identical matter, please, my lord, my lord was pleased to adjourn the matter for 8 weeks, and noting that, my lord, an SLP has been filed and
He'll
pending.
vacate the interim order and adjourn it.
That, my lord, my submission to this honorable court is that,
Come on,
please, my
merits,
lord.
sir. Yes.
That, my lord, there are two points, please, my lord, which I wish to argue at
That
this
I-
juncture, please, my lord.
Aye, sir.
That, my lord,
Urge
firstly,
You urge those 2 points. Yes.
please, my lord, and firstly, please, my lord, on the legal issue, please, my lord.
ಎಲ್ಲ ಲೀಗಲ್ ಇಶ್ಯೂನೇ, ಇಲ್ಲಿಗಲ್ ಇಶ್ಯೂ ಯಾವ್ದಿದೆ? Yes.
That, my lord, the officer who registered the FIR was a police inspector, please, my lord. That, my lord, and subsequently, please, my lord, the charge sheet was also filed by the officer who was not empowered to file the charge sheet, please, my lord. So that's my first submission, please, my lord. That, my lord, during the pendency of the petition before this honorable court, please, my lord, a departmental inquiry was also initiated against the petitioner, please, my lord. That, my lord, a detailed inquiry was conducted, please, my lord, wherein 17 witnesses were examined. And that, my lord, the complainant and shadow witnesses, who are the key witnesses to this case, please, my lord, they were also examined. That, my lord, on the identical charges, please, my lord. So he has been exonerated, please, my lord. To that effect, I have submitted the report of the DE, please, my lord, and I request, my lord, to kindly see the report in the compilation which I have submitted with the amended petition, please, my lord. That, my lord, in view of the exoneration, please, my lord, that, my lord, the judgment of Ashu Surendranath and Kejriwal comes to the aid of this particular petitioner, please, my lord. That, my lord, the issues are identical and the charges which are charged, which are being framed in the trial court against this petitioner is also the same, please, my lord. That, my lord, on the strength of this same, please, my lord, when the petitioner was not held guilty and when he has been exonerated, my lord, on the same charges, please, my lord, to expect that, my lord, he would be convicted in the criminal trial, please, my lord, is also chances are very less, please, my lord. And therefore, my lord, I place reliance on couple of judgments, please, my lord. With the compilation, please, my lord, I am submitting the.
ಯಾವ್ದು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಜಡ್ಮೆಂಟ್ ಕೊಡ್ತಾ
Yes, yes, one is coordinate.
ಅದು ಇಲ್ಲ ಬಿಡಿ, ಅದು ಸ್ಟೇ ಆಗೋಗಿದೆ.
So the other judgment, please, my lord.
My lord.
Wait, sir.
The other judgment is that, my lord, in support of that particular
ಹೇಳಿ
submission,
ಏನೋ
please, my lord,
ಹೇಳ್ತಾರೆ.
I place reliance on the judgment of your lordship in Manjunath Hebbar's case, please, my lord, insofar as the power of the.
ಅದ್ಯಾಕೆ?
That, my lord, insofar as the power is concerned, please, my lord, the officer who is investigating, who is registering the FIR should be competent to file the charge sheet, please, my lord. In that regard, my lord, issue number 2.
ಅದು ಇಶ್ಯೂ ನಂಬರ್ 2 ಸ್ಟೇ ಆಗಿದೆ.
That is identical, please, my lord.
ಇಶ್ಯೂ ನಂಬರ್ 2 is stayed.
That, my lord, insofar as Manjunath Hebbar's case is concerned, please, my
Issue
lord.
number 2 is stayed. Now the matter is heard and reserved.
And therefore, please, my lord, if these two contentions are taken into consideration, please, my lord, on the strength of these two submissions, please, my lord, I seek the kind intervention of this honorable court.
To what? Dismiss the petition.
No, not, my lord, to allow the petition, please, my lord. And that, my lord, and regarding the merits is concerned, please, my lord, that, my lord, the allegation is that, my lord, he has demanded for 20,000 rupees, please, my lord. Insofar as merits are concerned, my lord, I am not going to make any submission.
ಯಾಕೆ?
That, my lord, insofar as these two contentions are concerned on the legal issues, please, my lord, this is my submission, please, my lord.
ಅಷ್ಟೇನಾ?
That's all.
Yes, sir.
My lords, I've given the page number which connotes the demand and acceptance. He himself has demanded and
ಅಲ್ಲ
accepted.
ಇವರೇ ಕೈಯಲ್ಲಿ ತಗೊಂಡ್ರಲ್ವಾ?
He has not received.
Beside,
ಮತ್ತೆ who has received?
Driver, please, my lord. That's the allegation.
ನಿಮ್ ಡ್ರೈವರ್? ಮತ್ತೆ ನೀವೇ ಇವರೇ ತಗೊಂಡ್ರು ಅಂತ ಇದ್ದೀರಾ?
Driver ಇಂದ ತಗೊಂಡ್ ನಂತರ.
ಅಲ್ಲ
ತಮ್ಮ
That's
ಹೆಸರು
their
ಕೆ.
allegation.
ಶಂಕರ್ ಮೂರ್ತಿ, AEE ಭಾಸ್ಕರ್. My lords, page number 36 and 37, Trap Mahazar.
36, 37.
35 bottom page I'll read, my lords. ತಕ್ಷಣ ಫಿರ್ಯಾದಿಗೆ ಕೊಟ್ಟಿದ್ದ ಡಿಜಿಟಲ್ ವಾಯ್ಸ್ ರೆಕಾರ್ಡರ್ ಫಿರ್ಯಾದಿಯಿಂದ ಪಡೆದು PI ರವರು ಬಂದ್ ಮಾಡಿದರು. ನಂತರ PI ರವರು ಆರೋಪಿ ಹೆಸರು ವಿಳಾಸವನ್ನು ಕೇಳಿದಾಗ ತಮ್ಮ ಹೆಸರು ಕೆ. ಶಂಕರ್ ಮೂರ್ತಿ, AEE ಬೆಸ್ಕಾಂ ಜಾಗೃತ ದಳ ಚಿತ್ರದುರ್ಗ ಎಂದು ತಿಳಿಸಿದರು.
7A. Has he received the amount?
Please, my lords, he has received it.
ಎಲ್ಲಿದೆ?
ಟ್ರಾಪ್ ಮಹಜರ್ ಅಲ್ಲಿ ಬಾಟಮ್ ಪೇಜ್ ಓದ್ತಾ ಇದೆ.
ಯಾವ್ದು ಪೇಜ್?
35. ಟ್ರಾಪ್ ಮಹಜರ್
I am at 35, sir. Which page and which line?
35 bottom page, my lords.
Bottom line.
Bottom 4th line ಇಂದ. ಆಗ ನೆರಳು
ನಮ್ಮ
ಸಾಕ್ಷಿ
ಕುತ್ತಿಗೆ
ಮತ್ತು
ಸುತ್ತ ಹಾಕಿದ ಟವಲ್ ಅನ್ನು ತೆಗೆದು ಬಲಗೈಯಲ್ಲಿ ಕೆಳಗೆ ಹಿಡಿದುಕೊಳ್ಳುವ ಮೂಲಕ ಆರೋಪಿ ಹಣ ಪಡೆದು ಬಗ್ಗೆ ಸೂಚನೆ ನೀಡಿದರು. ಆಗ ನೆರಳು ಸಾಕ್ಷ್ಯದ ಡಿಕಾಯ್ ಕಾರಿನ ಹತ್ತಿರ ಬಂದು ಆರೋಪಿಯನ್ನು ಹಿಡಿದು ತಮ್ಮ ಗುರುತಿನ ಪತ್ರವನ್ನು ತೋರಿಸಿ ತಮ್ಮ ಪರಿಚಯ ಮಾಡಿಕೊಂಡು ತಕ್ಷಣ ಇನ್ನೊಬ್ಬ ಸೋಡಿಸು ಬೆಳಕ್ಕೆ ಬಂದು ತಕ್ಷಣ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿದ್ದ ಡಿಜಿಟಲ್ ವಾಯ್ಸ್ ರೆಕಾರ್ಡರ್ ಆಯ್ತು. ತಗೊಂಡಿದ್ದೆಲ್ಲಿದೆ?
ನಂತರ ತನಿಖೆದಾರರು ಆಪಾದಿತ ಶಂಕರ್ ಮೂರ್ತಿ ಅವರನ್ನು ಹಣ ತೆಗೆದುಕೊಡಲು ಕೇಳಿದಾಗ ಅವರು ತಮ್ಮ ಬಲಗೈಯಲ್ಲಿಟ್ಟುಕೊಂಡಿದ್ದ ಹಣವನ್ನು ಕೊಟ್ಟಿದ್ದು ಅದನ್ನು ನೆರಳು ಸಾಕ್ಷಿಯವರು ಎಣಿಸಿ ವಹಿಸುವಿಕೆ ಪಂಚನಾಮೆ ಕಾಲದಲ್ಲಿ ತಾನು ಬರೆದುಕೊಂಡಿದ್ದ ನೋಟುಗಳ ನಂಬರ್ ಮತ್ತು ಮೌಲ್ಯಕ್ಕೆ ತಾಳೆಯಾಗಿದ್ದು ಮೌಲ್ಯ ಮತ್ತು ಕ್ರಮ ಸಂಖ್ಯೆ ಈ ಕೆಳಗಿನಂತಿರುತ್ತದೆ.
ನೀವೇ ತಗೊಂಡಿದ್ದೀರಾ?
And it has become pink. My lords, besides that, he has not argued on merits. I would still say, my lords, the only 2 points that are being now petitioned before this honorable court is officer in charge of the station. Both the provisions which provide for registration of FIR and submission of the charge sheet emphasize on officer in charge of the station. Correct. Which is defined, my lords, in terms of section 2O of CRPC. Correct. And the definition in itself is very clear when it says whoever is present above the rank of constable. Now there is a negative reading. My lords, these provisions were construed in such a manner that a police station is a dynamic situation. It is not that an officer is sitting there only to do this.
ಬಿಟ್ಬಿಡೋಣ ಬಿಡಿ ಮಾಡಕ್ಕೆ.
No, ಕಾನ್ಸ್ಟೇಬಲ್ ಮೇಲೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಇದರಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮಾಡಿದ್ದಾರೆ.
ಕಾನ್ಸ್ಟೇಬಲ್ ಬಿಟ್ಟು
ಅಲ್ಲ, ಇವರು ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ನಾಟ್ ದಟ್ ಇಟ್ ಇಸ್ someone of a low rank.
No, that can't be accepted. What does the act say?
Act is what I'm saying, my lords.
Not CRP, that is the code. Lokayukta Act.
My lords, Lokayukta doesn't speak about registration.
No. There is ಇದರಲ್ಲಿ
17
PC Act ಅಲ್ಲಿ, sorry. PC Act ಅಲ್ಲಿ ಏನಿದೆ?
Section 17 ಅಲ್ಲಿ inspector and above rank if authorized by the government to investigate.
So basis inspector?
Investigate, not register an FIR. My lords, there is a subtle variation.
ಯಾವ ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ರೆ FIR ನ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾರಾ?
ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಮಾಡಿಲ್ಲ, ಇಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರಿಜಿಸ್ಟರ್
ಇಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ.
The illustration, anybody can register the FIR ಅಂದ್ರೆ ಇದರಲ್ಲಿ 17 order should be passed first. DA case ಇಲ್ಲ ಅದು ಬೇರೆ. But it can't be like that. In inspector registering the crime and then head constable registering the crime, this inspector going and investigating ಎಲ್ಲ ಆಗಲ್ಲ. Stay ಆಗಿದೆ, ಅದು ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
Stay ಆಗಿದೆ. My submission will only for the sake of contention before this honorable court.
But ಇಲ್ಲಿ I will not interfere, not on merits. This man has taken money by himself. We will not show any indulgence.
And also, my lords, the departmental inquiry, my lords have taken a view.
2026.
26. Bharati case.
ನಾನು ಬಂದ್ಬಿಡ್ತಾಗಲೇ. Already reported. ಮೊನ್ನೆ ತಾನೇ ಬರ್ತೀನಿ. I have distinguished.
Certainly, please, my lord.
Ashu followed Chandrasekhar.
Yes, my lord. Chandrasekhar's case, please, my lord.
And I even now fail to understand, in a case of trap where the accused ಬೇರೆ ಯಾರೋ ತಗೊಂಡಿದ್ರು ಆಯ್ತು, accused himself is caught receiving bribe and all procedures of receiving bribe is completed how a departmental inquiry is maintainable?
It is done not.
Demand and acceptance ಎಲ್ಲಿ through a criminal case ಅಲ್ಲಿ ಮಾಡಬೇಕು. Departmental inquiry ಇದಕ್ಕೆ ಬೇರೆಯವರು ತಗೊಂಡಿದ್ರೆ there is a chance of evidence to be seen and other things. Because ನೀವು ಲೋಕಾಯುಕ್ತದಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಕಿಟಕಿಯಲ್ಲಿ ಇದ್ದಿದ್ದು ಇವ್ರದೇ ಅಂತೀರಾ. ಅದಕ್ಕೆ ಅಂತದಿದ್ರೆ
I beg to differ.
ಅದೆಲ್ಲ ಕಿಟಕಿಯಲ್ಲಿ ಇತ್ತು, ಆ ಅಂಗಡಿಲಿ ಇತ್ತು, ಇಲ್ಲಿತ್ತು ಎಲ್ಲ ನಿಮ್ಗೆ ಅಂತ ಅಲ್ಲಿ ಮಾಡಿರ್ಬೋದು ಅವರು ಬೇರೆ. But direct ಆಗಿ ಎಲ್ಲಿ I have dismissed all those cases where they have received money by themselves or kept in the house table, kept in the car seat hindgade. All those I have dismissed. But if somebody has received on his behalf, then I am a little cautious. Because a 7A explanation be interpretation also. You can't bring in ಯಾರೋ ಎಲ್ಲೋ ಇಸ್ಕೊಂತಾರೆ ಹಂಗಂತ ಇವ್ರಿಗೆ ಇಸ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ.
That is corroborated by the fact that he has demanded. We could say in the absence of he himself demanding.
If he has demanded by telephone, by conversations recorded that ಇವ್ರಿಗೆ ಕೊಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ, it's all right. ಕೆಲವು ಸರಿ ಡಿಮಾಂಡೇ ಇರಲ್ಲ, ಕೆಲವು ಸರಿ ಕಾನ್ವರ್ಸೇಷನ್ ಇರಲ್ಲ, ಟ್ರ್ಯಾಪ್ ಫೇಲ್ ಆಗಿರುತ್ತೆ.
That I'll agree. Here is a case where he himself has
They
demanded.
will not spare any person who is caught accepting money. No shelter in this court at all.
Please.
But if somebody else has accepted, then it becomes a matter of at least listening the petitioner.
Please.
Yes, that's all. Idral ನೀವೇ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ sir?
Page 38, please, my lord. Page 38 of my petition, please.
You have taken the money yourself.
But man, insofar as receiving is
Notes
concerned.
are counted.
No, just 2 lines, please, my lord. Just 2 lines. ಅದಕ್ಕೆ ನನ್ನ ಅಣ್ಣ ಹೌದು ಸರ್ ತಂದಿದ್ದೇವೆ, ಕಷ್ಟ ಇದೆ, ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿಕೊಳ್ಳಿ ಎಂದು ಹೇಳಿದರು. ಹಾಗಾದರೆ ಆಗುವುದಿಲ್ಲ, ವಾಪಸ್ ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಅಂತ ಹೇಳಿದರು. ಮತ್ತೆಯವರನ್ನು ಕೇಳಿಕೊಂಡಾಗ ಆಯ್ತು ಎಂದು ಹೇಳಿ ನನ್ನ ಅಣ್ಣ ಹಣವನ್ನು ಸೋನ್ಸೋರವರಿಗೆ ಕೊಡಲು ಹೋದಾಗ ಅವರು ಕಾರ್ ಚಾಲಕನಿಗೆ ಕೊಡುವಂತೆ ತಿಳಿಸಿದರು. ಆಗ ಕಾರಿನ ಚಾಲಕನಿಗೆ ಸೋನ್ಸೋ ರೂಗಳನ್ನು ನನ್ನ ಅಣ್ಣ ಕೊಟ್ಟರು.
ಕಾರ್ ಚಾಲಕ ತಗೊಂಡು ನಿಮ್ಮ ಹತ್ರ ತಂದಿಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಬಂದವ್ರನ್ನ ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದೀರಾ.
ಅಲ್ಲ, that's what see this petitioner accused has not received the money.
No,
please,
that's all right.
and this is immediately, please, my lord, after the trap, please, my
ಬಂದಾಗ ನೀವು ಡ್ರೈವರ್ ಕೊಡಿ.
lord. My lord, there is no corroboration to this particular allegation.
Indian corroboration ಬೇಕು sir.
That, my lord, this is immediately after the trap, please, my lord, such a statement was made by the complainant's brother. Please, my lord.
ರಿಕವರಿ ಯಾರಿಂದ ಆಗಿದ್ದು?
Lords,
Driver
according to us, my lords, we have read out the.
ಅಲ್ಲ, ರಿಕವರಿನು ನಿಮ್ ಇವರಿಂದಾನೇ ಆಗಿದ್ದು.
ಅವರಿಂದ ಜೇಬಿಂದ ತಗೊಂಡು ಅವ್ರ ಕೈನೇ ಪಿಂಕ್ ಆಗಿದೆ, ಅವ್ರು ಆಮೇಲೆ ಅವ್ರ ಕಡೆಯಿಂದ ಇಸ್ಕೊಂಡು ಜೇಬಲ್ಲಿ. Ultimately, it has turned up in his hand.
No,
It
that,
may
my
have
lord,
turned through 3 or 4
that's, my lord,
hands
and
in change.
insofar as hand wash is
Oh,
concerned,
Swami.
my lord, it's a practice, my lord. Once they come, immediately they ask the accused to take the currency notes and to hand over. Then, my lord, they do the hand wash, please, my lord.
Correct.
And that is all. Ultimately, please, my lord,
ನೀವು ದುಡ್ಡು ತಗೊಂಡಿದ್ರೆ
if the matter goes for trial, please, my lord, all those, I mean, grounds are available for the
ಮಾಡ್ಕೊಳ್ಳಿ.
accused, please, my
ಅಲ್ಲಿ
lord.
ಮಾಡ್ಕೊಳ್ಳಿ.
But now,
No problem.
Let him
at this juncture, please, my lord, it is evident from the records, please, my lord, in the trap measure itself, please, my lord. It indicates that, my lord, the currency notes were, tainted notes were given to the driver, please, my lord, not to the accused, please, my lord. And this itself is sufficient, please, my lord, at this
No,
juncture,
no,
please,
no.
my lord. And therefore, please, my lord, there is no.
If the driver on your name had taken money, then yes, you have guided the person to go and give it to the driver. Basta. Discharge ಹಾಕಿ. ಅಷ್ಟೇ.
Oblige.
And this departmental inquiry in 7A, I want to write in something.
That, my lord,
Where they
insofar
have
as
received money on their own and the tests have been turned, no departmental inquiry will absolve them.
Please.
It's a question of crime. Departmental inquiry ಯಾರನ್ನು examine ಮಾಡಲ್ಲ, exonerated. ಇಲ್ಲಿ ಬಂದು
No,
ನಾವು
in
ಬರೀತೀವಿ.
our case, 17 witnesses have been examined, please, my lord. Complainant and the shadow witness also examined, please, my lord. That, my lord, having considered all the material, please, my lord, the inquiry officer has given the reports, my lord.
ಯಾರು enquiry officer?
Our
My lord,
department- our
a
department
retired
ಅಲ್ಲಿ.
district judge, please, my lord. Retired district judge.
Disciplinary authority ಯಾರು?
My lord, the BESCOM, please, my lord.
BESCOM ಅಲ್ವಾ?
BESCOM,
It was
please.
not referred under 14A?
No, no. No, lords. It is
Eleven-
their own parent department which has given that report.
Under rule
That
1123,
is what
please, my lord.
Chandrasekhar.
Rule 11 ಅಂದ್ರೆ it is our department.
Internally.
14A ಆದ್ರೆ ಮಾತ್ರ
Internally, please, my lord.
ಅದು ಹೆಂಗಾಗುತ್ತೆ ಗೊತ್ತು.
Obliged.
Internal.
Chandrasekhar defines, my lords.
Yes. The learned counsel appearing for the petitioner. The petitioner is before this court seeking the following prayer. The petitioner would project various contentions and would submit that all those contentions be permitted to be urged before the concerned court in an application seeking discharge. The
Charge has been framed, please, my lord.
ಏಮಾಯ್ತಾ?
Oh,
ಮತ್ತೆ
charge of
ಯಾವಾಗ
framed.
ಆಗಿದೆ?
Subsequent to the filing of the petition before this honorable court, on the very next day it
The
was
learned
framed.
counsel submits that he be permitted to urge all these contentions before the concerned court at the appropriate time. At the appropriate time. The apprehension of the counsel for the petitioner is that the concerned court would not look into the law laid down by the apex court in plethora of judgments with regard to exoneration and departmental inquiry or otherwise. It is needless to observe that all the contentions urged by the petitioner before the concerned court at the appropriate stage would merit an answer while taking the issue to its logical conclusion. Ordered accordingly.
Please, deeply obliged.
Yes. Sorry.
Complainant's petition, my lords, offense is 138. Accused
ನಾಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದಾರ?
13ಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಟಿಕೆಟ್ ಇದ್ದಾರೆ ಶುಕ್ರವಾರ.
ಏನ್ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ?
ಅಲ್ಲಿ ಏನಾಯ್ತು, ಅವರು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ. ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ they took one contention saying that, my lords, we have not produced a resolution to authorize, my lords, the manager. Accused was working as manager in our temple while discharging his
temple problem.
ಅಲ್ಲ, ಟೆಂಪಲ್ ಅಲ್ಲಿ ಇದ್ದಾಗ he mismanaged the funds, he admitted the liability and he issued the check.
ಸರಿ, ಎಂತ ಪ್ರಾಬ್ಲಮ್?
ಈಗ ನಮಗೆ ರಿಕಾಲ್ ಅಂಡ್ ರಿಓಪನಿಂಗ್ ಕೇಳಿದ್ದು ಒಂದು
ಅಪ್ಲಿಕೇಶನ್
311 ಅಪ್ಲಿಕೇಶನ್
ಯಾವಾಗ ಹಾಕಿದ್? ಕಂಪ್ಲೇನೆಂಟ್ಸ್
9ನೇ ತಾರೀಕಿಗೆ ಹಾಕಿದ್ದು, ಅವತ್ತೇ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
The petitioner shall serve on the counsel representing the accused before the concerned court and file an acknowledgement of such service by the 16th, list the matter on 20th in the fresh matters list. Further proceedings before the concerned court shall remain stayed till the next date.
And
ನಾಡಿದ್ದಲ್ವಾ ಇರೋದು? ಸಿಗ್ತದೆ, ನಾಳೆ ಬೆಳಗ್ಗೆ ಸಿಗ್ತದೆ.
Great.
Senior motor vehicle inspector, but without initiating any action under the Motor Vehicles Act, Lord, files a complaint of cheating and forgery, and Lord, he takes the car himself. It's a luxury car, Lord. Annexure A is the FIR.
IMV na?
ಹೌದು. Senior motor vehicle inspector.
Yes,
Annexure B
IMV.
page 16. ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ. Kindly, my lord, annexure C.
Complainant ಯಾರು? ಅವರೇ.
Annexure C is the invoice under which I have purchased the vehicle. My lord, up to 1 crore, my lord, I have paid CGST. My lord, the cost of the vehicle is.
ಯಾವ ಕಾರ್ ಸರ್ ಇದು?
Lamborghini.
ಇವೆಲ್ಲ Lamborghini ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆಯಲ್ಲ, ಏನಿದು? ಗ್ರೀನ್ ಅಲ್ವಾ?
ಇಲ್ಲ, ಬ್ಲಾಕ್ ಇದು. ಬೆನ್ ಹತ್ ಬಿಡಿದಾರೆ ನಮ್ಮನ್ನ. Annexure D, my lord, is the registration certificate at page 19. Then, my lord, annexure E is the road tax that I have paid in the state of Karnataka.
What's the allegation?
Cheating and forgery.
ಯಾವ್ದು cheating and forgery?
Issue, my lord, this vehicle was purchased in the year 2022. Registered under temporary registration on the ground that vehicle will be registered in Andhra. Andhra. The vehicle was not registered.
Where did you purchase the vehicle?
Not 2025, I purchased it from the dealer. He has issued invoice, I have paid CGS.
ಆಯ್ತು, ಎಲ್ಲಿ ಬೆಂಗಳೂರು?
ಇಲ್ಲ, ಬೆಂಗಳೂರಲ್ಲಿ. And blood, section 55, if there is fraud and forgery, he has to issue notice and blood, he not come, blood, he has come.
ಸರಿ, ನೀವು ಬಂದು ಕಾರ್ Lamborghini ಡ್ರೈವ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತಾ?
ಅಲ್ಲ, ನೋಡಿ ಸ್ವಾಮಿ.
ತಗೊಂಡೋಗಿ
ಅಲ್ಲ, he comes, complainant comes and takes the car.
No, it is.
Kindly see the photograph. ಟೋ ಮಾಡ್ಕೊಂಡು ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನನ್ಗದ್ ಮತ್ತೆ ಅದು ನಮ್ಮ ಮನೆಗೆ ವಾಪಸ್ ಬಂದ್ರೆ ಫಾರ್ ಮೀ ಟು ಸೆಟ್ ಇಟ್ ರೈಟ್.
ಏನಿತ್ತು?
ಅಲ್ಲ, ಏನಿದೆ ಕಾರಲ್ಲಿ ಏನಿರ್ಲಿಲ್ಲ. ಕಾರ್ ಟೋ ಮಾಡೋದಕ್ಕೆ ಕೈಂಡ್ಲಿ ಸಿ ಮಲಡ್, ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಫೋಟೋಗ್ರಾಫ್ ಪೇಜ್ 37 onwards, and he gives ಮಲಡ್ press statements also, right, left and center. Not in all the newspapers my name is there saying that I am a tax defaulter. Not 60 lakh, they say mlad 37 lakhs tax default. I have paid 60 lakhs mlad tax, road tax here. Page 40.
The vehicle was not registered between 2022 to 2025. So vehicle is not registered, and there
ಅಂದ್ರೆ ಟೆಂಪರರಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಲ್ಲಿ ಓಡಿಸಿದಾರಾ?
That is the issue. And not only that,
not me, Lord. I have purchased it from the dealer. I have paid.
When did you buy it?
25 September 25.
22 ಇಂದ ಮತ್ತೆ ಹೆಂಗ್ ಬಂತಿದೆ?
That is exactly the issue, Mel.
Where did you purchase it?
Lord, I have produced the invoice at page 20, Annexure C, page 18. Lavelle Road, Lord, dealer.
ಒಂದು ನಿಮಿಷ.
Hoysala Automotives Private Limited,
One moment. Page.
page 18, annexure C. My lord, Hoysala Automotives Private Limited, my lord, Lavender Road is the dealer. I have purchased it from him. Kindly see, my lord, the
2
amount.
crore 3 lakhs.
Yes, my lord.
3 crore 68 lakhs.
Yes, my lord. 1 crore is the GST, my lord.
ಇದಕ್ಕ
Because, my lord,
ಬೆಂಗಳೂರಲ್ಲಿ ಎಲ್ಲಿ ಓಡಿಸ್ತೀರಾ?
ಅದೇ ಅಲ್ಲ, ಮನೆಯಲ್ಲಿ ಇದ್ದಾಗ, ಗ್ಯಾರೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗ, ನಾನ್ ಇಲ್ದೇ ಇದ್ದಾಗ
ಗ್ಯಾರೇಜ್ ಅಲ್ಲಿ ಓಡಿಸ್ತೀರಾ?
ಅಲ್ಲಲ್ಲ, ಗ್ಯಾರೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ನಿಲ್ಸಿದಾಗ, ನಾನ್ ಇಲ್ದೇ ಇದ್ದಾಗ, ನಾನ್ ಇದೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೋಆಪರೇಟ್ ಮಾಡಿಲ್ಲ.
ಅದೆಲ್ಲ ಆಯ್ತು. ನೀವು ಎಲ್ಲರೂ ಓಡಿಸ್ಕೊಳ್ಳಿ ಬಿಡಿ, ನಮ್ಗೆ.
Your lordship may see the registration, the vehicle manufactured 2021.
No, one moment, sir. Lamborghini Hurricane Evo Coupe. This is purchase date alliде. 19/20/25.
Yes, my lords. And registration date, my lord, is next page, page 19. The RC card itself. It will show manufacturing date of February 2021.
Registration date so and so, manufacturing date?
ಅಲ್ಲೇ ಕೆಳಗಿದೆ ಸರ್. February 2021. But the RTO has given this RC card. I have, next page is the road tax that I have paid. 11/9/2025, 60 lakhs.
Amala.
Lord, these are the other documents, Lord, other expenditure that I have incurred.
On the car.
To service the car prior to taking the annexure F avalla. That is also.
So, it was not registered from 2021 to 25 alva. Catch hold of the dealer.
No, it's not, no, vehicle was registered, temporary registration.
Where?
In Bangalore.
It was with whom?
It's supposed to be transport.
With whom?
No, that
It
one.
was with whom for 4 years?
No, that's exactly, my lord, that now the issue is that they have to, they could not, what they have done at the time of registration in 2025, I've anyway sought for records, is that they deleted the temporary registration itself. They could not have registered the vehicle, RTO. Yes, RTO. So they could not have registered because if the temporary registration was existing since 2022 to 2025, they would have levied penalty. To evade penalty.
To whom?
To the person who is buying now or person who is selling. One of these people has to pay the penalty. To evade that, they have deleted the temporary registration. So may I request my lordship have it tomorrow top of the list.
No,
I'll the only issue, my lord, according to me, my lord.
And what was this hero officer
No,
doing?
that I'll bring him tomorrow, my lord. Your lordship have it tomorrow.
Lord, he comes and takes away the car, not the police, my lord.
No, there is something else he explained, my lord, and I.
No, not something else. How did he, now tax is paid, it is registered by the RTO, GST is paid, all nuances of a purchase of a car is done. Who is this hero who goes and gets it from the garage?
No.
And drives it, where does he drive it?
Tow ಮಾಡ್ಕೊಂಡು ತಗೊಂಡೋಗಿದ್ದಾರೆ, but he takes it to Yelahanka police station initially. From there, my lord, now they say Ramurthy Nagar police station. Both of them, my lord, I have filed a 451 application.
ಎಲ್ಲಿದೆ ಗಾಡಿ ಎಲ್ಲಿದೆ ಈಗ?
ಗೊತ್ತಿಲ್ಲ.
Not 10:30 minute tomorrow.
Tomorrow 10:30, where is the vehicle? It should be there.
Yes.
And ask that hero to come to the court.
I'll ask.
What is this heroism is displaying contrary to law? Notice ಕೊಟ್ಟಿದ್ದೀರಾ 55 ಅಲ್ಲಿ, if there is any fraud?
No, I have asked him.
What these policemen are thinking they can do anything?
ಅವರು ಅಲ್ಲ.
RTO.
ಇವ್ರು ಇನ್ನೊಂದು wing.
ಅವರು complainant.
ಅವರೇ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟು ಅವರೇ ಪ್ರಾಬ್ಲಮ್.
I asked him, where is the, have you issued a notice? He said notice has to be issued by RTO. Then I said, why are you even asked RTO? So your lordship,
Who is this man? Let him come to the
I'll ask
court.
him to come tomorrow morning.
Who is this man?
R2.
Ranjit.
The second respondent shall be present before the court at, second respondent complainant shall be present before the court at 10:30 AM. Yes. ನಾಳೆ ಕೊಡು order. Yes. And the learned additional SPP to secure instructions as to where the car of the petitioner is now parked. ಏನೋ ಡ್ಯಾಮೇಜ್ ಆಗಿದ್ರೆ ಕೈಯಿಂದ ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಿ. I will definitely pull it out from his pocket.
Correct.
If he is acting contrary to law.
No,
These people cannot think they are above the law.
In fact, we're reading 65 together, my lord. 65 says that notice has to be served by register post.
Yes.
Even
ಸೀದಾ garage ಅಲ್ಲಿ ಗಾಡಿ ಟೋ ಮಾಡ್ಕೊಂಡ್ ಬರೋದು, garage ಅಲ್ಲಿ ಗಾಡಿ ಟೋ ಮಾಡ್ಕೊಂಡು. So what power does he have? What power the RTO has to enter into someone's house in the garage and pull the vehicle out? Crime register ಮಾಡಿ ಅವ್ರ ಮೇಲೆ. Trespass.
I've instructed, my lord, already instructed.
You register house trespass crime. ಅದು ಇಲ್ಲೇ ಬರುತ್ತೆ, ಅವಾಗ will take care. Yes. What does he think of himself? Today, tomorrow, they will go anywhere.
You're probably smiling, my lord, because we are at the hands of this court. But generally, my lord, if it's scary, my lord, if this kinds of.
No, that's what, it is not, they can't behave that like it's their personal fiefdom, sir. They are above, they are to contours of law, they are supposed to find RTO. He's entering somebody's house and taking away the car. Where is the power? It bitre ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ enter ಆಗ್ತಾರೆ.
Lighter note. No, the High Court has passed an order.
ಯಾವ್ದು ಹೈಕೋರ್ಟ್?
In judge name. They are on pen.
ಮತ್ತೆ ಬೆಳಿಗ್ಗೆ ಬರಕ್ಕೆ ಹೇಳಿ. We'll see, we'll ask. Tomorrow we'll grant. And I want, where is the car today? Yes. And any damage will be from that man's pocket. 5 ವರ್ಷದ ಸಂಬಳ ಕೊಡಬೇಕಾಗುತ್ತೆ. ನಿಮ್ ಲ್ಯಾಂಬೋರ್ಗಿನಿ ರಿಪೇರಿ ಮಾಡ್ಬೇಕು. Yes.
RTO ಅಲ್ವಾ ಪರವಾಗಿಲ್ಲ.
RTO ಪರ ಕೊಡ್ತಾರೆ.
I only want to safeguard my own car if I get it. Great.
ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. Yes.
I appear for petitioner in this matter, Your Lordship. The charge sheet is registered for the crime 506 and 504, Your Lordship.
504, 506.
Actually, ಇದರಲ್ಲಿ ಫಸ್ಟ್ 403, 406, 420 ಎಲ್ಲ
ಬಿಟ್ಬಿಟ್ರ ಆಮೇಲೆ?
ಎಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು ಇವಾಗ 504, 506 ಮಾಡಿದ್ದಾರೆ.
ಅಯ್ಯೋ. ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
ಕಂಪ್ಲೇನೆಂಟ್ ಅವ್ರಿಗೆ ಈ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್.
ಅದ್ರಲ್ಲಿ ಗೊತ್ತಾಯ್ತು, ಇಲ್ಲಿ ಎಲ್ಲಿ ಅಂತ ಕೇಳಿದೆ ಅಷ್ಟೇ.
We have instituted
On 7/1/2026, this court passed the following order. There was no representation on behalf of the respondent complainant. The matter was directed to be listed on 28/1/2026. The matter is listed today. Even today, there is no representation on behalf of the complainant. Therefore, as a last chance, list this matter on 18th. In the event there would be no representation, appropriate orders would be passed on hearing the counsel appearing for the petitioner. Interim order stand section. Not Saruda. Saruda?
Saruda.
Counsel ilva? Oh, sorry. Yes, ಹೇಳಿ madam. The petitioners are before this court calling in question proceedings in CC
327 of 24.
CC 327 of 2024 registered for offences punishable under section 504 and 506 of the IPC. The petitioners are accused 1 to 8. The second respondent, the complainant, a trustee and secretary of Anjuman Al Arfat Education Trust. The petitioners are said to be office bearers are said to be the erstwhile the office bearers of the said trust. A complaint comes to be registered against these petitioners a private complaint comes to be registered against these petitioners invoking section 200 of the CRPC on 11/4/2023 for the offences punishable under page 20 I'll mark madideni. So and so. The learned magistrate refers the matter for investigation, and which becomes a crime in crime number 201 of 2023. The police conduct investigation and file a charge sheet not for the aforesaid glorified offences, but for offences punishable under section 504 and 506 of the IPC. The filing of the charge sheet is what has driven these petitioners to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that none of the allegations that are alleged against these petitioners, even in the crime stage, had no ingredients of those allegations. The learned counsel would seek to project that the accused number 1 had preferred, has instituted a civil suit in OS 576 of 2023 against the complainant seeking permanent injunction. And once the notice was served in the said suit, the complaint registers the subject complaint. Therefore, it was an act of wreaking vengeance against these petitioners for having registered the civil suit in which notice was issued. The respondent complainant, though served long ago, remains unrepresented even as on date. The learned HCGP would, however, submit that the allegations of 504 or 506 is also found in the case at hand. Therefore, it is for the petitioners to come out clean in a full-blown trial. I have given my anxious, Madam, I have given my anxious consideration the submissions made by the respective, by the learned counsel for the petitioner and the counsel for the state, the HCGP for the state. The petitioners and the respondent complainant belong to the same trust. A suit is instituted by the first petitioner, accused number 1, against the complainant seeking his restraint from entry into this trust in OS 576 of 2023, where a permanent injunction was sought. Notice was issued on notice was issued in the said suit, and objection were directed to be filed. Interim order kotra. Objections were directed to be filed to the application under Order 39, Rule 1 and 2, filed before the civil court. Immediately thereafter springs the subject complaint on 11/4/2023. The complaint was before the learned magistrate, who refers the matter for investigation under 156(3) of the CRPC. The reference becomes the aforesaid crime. The crime leads to investigation. The investigation leads the police to file a charge sheet as observed, not for all the glorified offences, but for the offences under section 504 and 506 of the IPC. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 36. A perusal at the complaint or the summary of the charge sheet would clearly indicate that it was an abuse of the process of the law by the complainant for having instituted the complaint for several offences, including cheating, forgery, or the case would, as the case would be, while the charge sheet rests the crimes to offence under 504 and 506. Even the said offences cannot be laid against these petitioners for the simple reason that they do not hold the ingredients as necessary under section 503 of the IPC. The apex court in the case of Muhammad Wajid versus State of Bihar, 2023 SEC online SC page 951, has held as follows. Paragraphs ಇದೆ 503, 506 yes, so and so. In the light of the facts obtaining in the case at hand and the law as laid down by the apex court in Muhammad Wajid, permitting further proceedings would become an abuse of the process of the law and result in miscarriage of justice. Allowed quash. Next.
Obliged.
The observations made in the course of the order would not come in the way of the proceedings in the aforesaid civil suit. Yes, next.
In this matter, morning I made a mention.
ಏನಿದು ಇದರಲ್ಲಿ registry to delete the name of BB Patil as appearing for the first respondent and print the name of Prasanna Shetty.
Please.
List them will 24th ಅಲ್ವಾ?
Objection ಹಾಕ್ಲಿಲ್ಲ. Objection ಹಾಕ್ಲಿಲ್ಲ. I'll file.
ಆಯ್ತು ಹಾಕಿ. List the matter on 25th.
Please.
Objections if any by then.
Submission, my lord.
Entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ. The petitioner has not demanded any bribe in the
7A. 7A na?
So he has not demanded any bribe in the alleged situation, and kindly, my lord, in support of that.
2 ವರ್ಷದಿಂದ ಇಲ್ಲದೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕೊಡಲ್ಲ ಸರ್. List the matter on 25th.
My lord, single line ಇದೆ. Kindly go through 28.
Entry order I am not granting. Let him file objections. 2 years in the pending ಇದೆ. ಇವತ್ತೇನು entry order? Yes.
Yes.
Would it be on 24th or?
No sir, 25th. 2024 ತಾನೇ ಇದು.
I have some personal information.
Then 18th.
Please.
Astral objection ಹಾಕೊಂಡ್ರೆ 18th.
Next month 8. Next week 18th.
Please. Month 18th. Yes.
Have it on 18th.
18th.
Please.
For the petitioner,
For
senior is held up in another matter.
Held up. Entry ಮಾಡಿದ್ಯಾ? Entry order continue ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿ. 7A.
Yes, please, your lordship.
ಏನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ? What's the interim order?
State them, he's accused.
Shall not file, my lord.
Yeah.
Charge sheet shall not file, my lord, without leave of the court.
25th, yes. Objections hakidira?
Yes, please, your lordship.
Interim.
Continue, sir. Hmm.
Lord, I want to file the
50 ವರ್ಗು ಇದೆಯಾ? One moment.
Lord, I want to file the FIR registered in Bombay. I've placed a 0 FIR with the petition. This is what is registered in Bombay. Okay. And
Yes.
in this, my lord, the charge sheet is filed about 4 days back, and they have
4
informed.
days back.
3-4 days back, they filed the final charge, the final report, my lord, in this. And they've informed me that the CC number will be issued in about 3-4 days, in which case I may be permitted to place that charge sheet because it is directly connected with the list in this matter.
So interim order ಇದೆಯಾ ಇಲ್ಲಿ?
Yes, in this there's an interim order, my lord. Ninja cart matter.
Ninja cart, your
Ninja
lordship
cart, yes.
specifically said, my lord, interim order, they should get ready, make submissions on
No, I'm
29,
ready
1
for
to
submissions, but
26.
because of the
Ready?
charge sheet, I'm ready. my
No, no, my
All
lord,
right, you forget the charge sheet.
yes.
Ninja cart.
Yes.
ಏನ್ ಹೋಗಿಲ್ಲ?
Now what my lords, we believe that certain goods have been delivered and we make the payments. Now we come to everything is fake. They accuse joint hands together. Fake. They create fake invoices. There is actually, my lord, Ninja cart is a platform for supply or buying or purchase so and so. Now what they do is these accused persons, 1, 2, 3 join hands together. They create a document that one person has sold the articles to another person. They received it.
Madam, ಹೇಳಿ madam.
No, my lord. So on 13 April 24, my lord, we have tried to get this 0 FIR registered because we came to know that a fake board resolution, which I have produced at
Fake
page
board resolution of
of mine, my lord. Page 29, I've placed that fake board.
Of Ninja cart.
Not Ninja cart, my lord. I am for Romofi Agro. I am accused 2 and 3. I am only connected indirectly to this whole transaction, my lord. The entire transactions are between respondent 2 and accused number 1, against whom there is no stay. The investigation has continued against accused number 1. And if your lordship will see the complaint also, as well as their objections, the entirety of the allegation is against accused number 1. In this, on 4th April itself, I came to know that this bank account opened in HDFC, my lord, was opened through a fake board resolution by one Sanjay Umasare. That I have placed at page 29, my lord. And this entire transaction of however many crores that they are alleging has gone through this bank account, which we had no idea about. We knew that a bank account was opened. However, the email address and the phone number is not ours. And they have opened it using this fake board resolution, this one Sanjay Umasare, who is an accused in this FIR in Bombay, which I have registered subsequently, due to my account being in Bombay, my lord. They have done this in Bombay. So the entire transaction, all this cheating that they have alleged, has taken place through this account. On 13th April itself, I tried to get this FIR registered. That is recorded, my lord, in my 0 FIR at Falodi in Rajasthan, where I am resident, as well as in the FIR that I have filed in Bombay, which I have now placed via memo, that I have tried to get this FIR registered. However, the FIR got registered only in June, the 0 FIR, and then subsequently the FIR in Bombay was in September of 2024, my lord. Thereafter, investigation has taken place. So my submission is that I myself am a victim of fraud at the earliest stage that I came to know that my signature was forged.
It is done by the other accused.
No, my lord, there are 4-5 people involved in this. They seem to have been in cahoots with accused number 1 and others and done this transaction against me and against respondent number 2, my lord. So last date I had submitted, my lord, that at the very least, most I can be made a witness in this case. I am not involved in
No,
these.
the other accused are drawn into the crime.
in the Bombay FIR, there are 4 members, my lord.
Illi,
Illy, I'm not sure what is the stage of investigation that the R1 has
this,
to.
government investigation paper cell is.
First, my lords, I have to get it, my lords.
Get it.
Or day after tomorrow, my lords.
My
Not
lords,
day after
please.
tomorrow.
That appears to be
25 either 24.
interest dispute between their directors, my lord. They are alleging certain things, my
ಈಗ
lord.
ನಿಮ್ದು
No, there's no
ಏನ್-
interest
ಒಂದ್
dispute
ನಿಮಿಷ.
in my
ಈಗ
director.
ನಿಮ್ಗೆ ಏನಾಗಿದೆ?
No, my lord, as far as we are the
ಬಾಂಬೆ
complainants.
ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಿರಲ್ಲ?
No, my lord, no. FIR is, we are not registered in FIR, my lords.
ಸರಿ.
They say, as far as we are registered only this FIR. And my lord, they say that one of the directors has lodged a complaint against them, their own people. And they say the resolutions, etc. are fake. Here the question is not of resolutions, the entire subject matter is different. We say fake invoices are created and all these accused persons, they show as if some goods are supplied and they received and make the invoices to us. We have made payment of rupees 5 crores. So which of,
5 crores is involved in this.
yes, yes, and based on the fake documents. Now, my lord, as against this 2 and 3 are before the honorable, accused number 2 and 3 are before this honorable court. Accused number 1, my lord, who is also involved, he is facing another prosecution of a similar nature of setting up fake invoices and is arrested
ಎಲ್ಲಿ?
in Delhi. The separate criminal case is registered, my lords. Now the role of 2 and 3, they want to say we are not involved, we are maybe witness, we have no objection. Let the investigation go on is only our submission, my lords. They say that the
entry
witnesses.
ಮಾಡಿದ್ಯಾ ಇಲ್ಲಿ?
Howdu.
Yes, my lord.
And
Investigation is complete?
no, there is no progress in the investigation because.
So let the investigation go on. They will not file charge sheet without the leave of the court.
Please.
That's all.
Anyway, they have supposed to have investigated against A1. Let them place the papers, my
That's
lord.
all right. Let them investigate against you also. Let the charge sheet not be filed.
At least let me place that charge sheet, my lord.
That's all
And
right.
after
No-
that, it
no
may
problem.
be decided.
The petitioners are accused 2 and 3
2 and 3.
are said to be the office bearers of a company which had a transaction with the respondent. You are Ninja Carta.
Not a direct, not direct transaction, my lord.
With a transaction
number
with
1.
the complainant. The issue is that the complainant has supplied certain goods on the invoices generated by the present accused. The goods are transferred.
I have supplied goods, my lord. It's quite a
with-
complicated
supplied-
that I have supplied the goods, my lord.
My lords, with the accused 1, 2, 3.
Accused 1, my lord, and they are in
Yes.
an agreement with accused 1. I am not in direct
You're
agreement with
Your
them.
lords,
That is the
kindly
point,
see.
my lord.
What they do is accused number 2 and 3 say that we have supplied the goods to A1. A1 say received and we make the payment. Now, my lord, this nothing is supplied.
Directly to me.
Yes.
No, no. Now, who is?
There
who
are.
1 minute. Transaction is, contract is between you and accused number 1.
No, intimacy between all the 3 persons for this reason, my
Tripartite
lords.
agreement. I
No,
know.
my lord, there is no tripartite.
My lords, like this, please, may I ask, my lords? It's a platform. They say we have supplied the goods. A1 says I received the goods and they place the order with us. We say give a green signal.
Who places the order?
No, my lord, the person who wants to purchase, he would place the order with us. We would give it to the person, my lords, who is actually supplying. He would say, I have supplied. So buyer and both of them are with us. And we make the payment to the person who has supplied it.
All right.
And now, my lords, these people say we have supplied the goods. And other persons have received the goods.
Sir, you have supplied it to someone, he has
No, no.
received it.
We are-
2 and 3 gu nimgu ಏನ್
I'm only the platform. I'm on the platform. I make the payment.
2 and 3 gu nimgu ಏನ್ ಸಂಬಂಧ?
2 and 3 say, my lord, they have supplied the goods to A1. A1 in fact has not received, it's bogus. A1 says he has received. And that we make the payment, my lords, based on this.
To whom?
To the person who has supplied, to them. To them, they have received 5 crores.
That is the
Yes,
allegation, my
the
lord.
payments
which
have gone
has
through the bank
Gone
accounts.
through that bank account.
Now, all these are fake.
Yeah.
Which
this-
is not, I have
wait,
no knowledge of,
this
my lord.
Definitely requires investigation. So this court had entered, everybody, this court had interdicted investigation by an interim order. The issue in the list revolves around payment of 5 crores based upon fake invoices. Who has generated the fake invoices and payment has gone to whom is a matter that requires investigation. Against accused number 1, investigation is on, and it is said that the accused number 1 is involved in similar crimes and is in custody in a crime registered within jurisdiction of the courts of Delhi. The learned HCGP, the investigation papers are not placed before the court as against accused number 2 and 3. There is no investigation conducted. Therefore, the investigation against accused number 2 and 3 shall continue, and the learned and the investigating officer shall conclude the investigation and place the final report before this court, qua the the accused 2 and 3 and not file it before the concerned court without the leave of the court. In the garb of investigation, no coercive steps shall be taken against these petitioners unless they cooperate with the investigation. In the teeth of the interim order, the aforesaid order is passed. Aforesaid order of no coercive steps is passed in the light of the interim order subsisting in the case at hand till today. It is only to know the truth of the transaction, investigation is permitted and the final report is called for.
One submission, my lord. Let them seek the report from the Bombay police as well.
They will do
because
it. They will do everything.
Let that specific
My lord,
direction
sir.
be given, my
My
lord,
lord,
because
as far as,
there is an investigation conducted there.
We'll see. They
though,
will
my
do
lord,
it.
Stick to the same
You-
transactions.
even though your lordships have not stayed the case against accused number 1, only against 2 and 3 there was an interim order. They have not conducted any investigation for A1. That also, because your lordships have permitted now
Whatever,
investigation.
accused number 1 and 3.
1 to
Therefore,
3.
the investigation shall now continue against all the accused.
Please.
Lord,
I'm
that
grateful.
specific direction may be given regarding the Bombay papers,
Bombay
my
is
lord.
totally unconnected.
Because
my lord.
otherwise,
The
it is
intricacies
completely
between
connected,
them.
my lord.
We'll
That's
see.
why I placed the memo with that FIR.
Let them come up with
It's
the
the same bank account that the
I have
transaction flew
protected
through.
you with no coercive steps. They will not harass you. Cooperate with the investigation.
We will cooperate,
Yes.
my lord.
Please, humbly play for any date after a month or so.
The learned HCGP to place the papers of investigation by the 16th of April 2026. Rest the matter on 16th April, 17th April. ಬೇಡವಾ? ರಜಾ
ಇಲ್ಲ ಇಲ್ಲ ಅದು ರಜೆ ಹತ್ತಿರ ಬರುತ್ತೆ ಅಂತ
ರಜೆ ಹತ್ರ ಇರ್ಲಿ ಬಿಡಿ.
ನಮ್ಗೆ ಯೂಶುವಲಿ ವಿ ಗೆಟ್ ಇನ್ ಟು ದಟ್ ಮೂಡ್.
They will not get into that. Don't worry. Yes.
They are already in that mood, investigating agency, because the stay order, my lord, permanent holiday.
ಅಲ್ಲ ಅವ್ರಿಗೆ enough and more in their kitty to do. Yes.
We are good.
To
38.
38. The alleged offense 324, 420, 504 and 506 of IPC. The allegation against this petitioner,
ಏನ್ offense ಏನಂದ್ರೆ 420,
420, 324, 504 and 506 of
ಆಯ್ತು.
IPC. The allegation.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet is filed, my lord.
Yes.
The allegation is against this petitioner. This petitioner was misused the company amount for her own use, firstly. Secondly, threatened to kill respondent number 2. Thirdly, assault on his stomach, chest and testicle with
Matter for trial. Last
but,
word ಹೇಳಲ್ಲ.
but my lord, but coming to other things, with stones, my lord, on 13/7/2023.
Very brutal.
No, my lord, very not no, kindly see the document of the wound certificate, my lord. There is no whisper about
About what?
the last.
Last. Oh.
That one, my
That one.
my lord, kindly see the complaint version, the page number. It is lengthy complaint filed by the respondent number 2. Page number 24. I come to on what happened on 13th July 2023. After repeated request by me and Chiri Natraj, she came to Double Road in BEML layout near service station, sat inside my car.
ಎಲ್ಲ wound certificate ಎಲ್ಲಿದೆ ಹೇಳಿ ಸರ್?
No, my lord, what happened?
Wound certificate ಎಲ್ಲಿದೆ ಹೇಳಿ ಸರ್?
Grievous in nature. Grievous in nature.
My lord, one thing, and throw stones on me. They written, they throw stones on me. That is the, and kindly see, wound certificate.
324 or 26?
24, my lord. 24.
26 ಆಗ್ಬೇಕು. Dangerous.
No, my lord. Why kindly see, my lord, the incident occurred on, as per respondent number 2, 13/7/2023.
Yes, sir.
He was taken treatment on 27/2023.
13/7.
2023. He was taken treatment on 27/2023. The complaint lodged on 1/8/2023.
5 ತಿಂಗಳು ಆದ್ಮೇಲೆ
1/8, madam.
18.
1/8, madam. After registration of the FIR, 4/8/2023, Caesar Mazar was drawn.
ಏನ್ ಸೀಸ್ ಮಾಡಿದ್ರು?
Kallu, Swami.
ಕಲ್ಲು.
Kallu. There, seize one.
ಯಾವ ಜಲ್ಲಿ ಕಲ್ಲ?
Kallu, one kallu ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. Kindly see, that is the page number 49, my lord. ಒಂದು ಕಲ್ಲಿನಿಂದ ಹೊಡೆದು ಅಲ್ಲೇ ಮಾಡಿ 50, my lord. ಒಂದು ಇಡೀ ಗಾತ್ರದ ಕಲ್ಲನ್ನು they seize one ಇಡೀ ಗಾತ್ರದ ಕಲ್ಲು, my lord.
ಇಡೀ ಗಾತ್ರ ಅಂದ್ರೆ ಎಷ್ಟು?
They stated
ಇನ್ನು ದೊಡ್ಡದು.
ಇನ್ನು
ಇಡೀ ಗಾತ್ರ.
My lord, kindly see, kindly appreciate the document number own certificate. They stated in the own certificate. The history of assault, my lord. Assaulted by one petitioner, Parimala, on 13/7/2023 at about 8:30 p.m, my lord.
Lady,
my lord. At about 8:30 p.m.
ಸೋಲೋ ಅಕ್ಯೂಸ್ಡ್ ಅಂದ್ರೆ ಏನು? ಸೋಲ್ ಅಕ್ಯೂಸ್ಡ್. ನಿಮ್ ಆಕ್ಟ್ ಸೋಲೋ.
8:30 p.m. My lord, it is document reflected in own certificate. The incident occurred on 8:30 p.m.
ಯಾರು ಸರ್ ನಿಮ್ಗೆ ಲೇಡಿ ಹೊಡೆದಿದ್ದು?
Happened to be a friend of mine for the last 27 years.
27 years friend.
They come.
28th year ಅಲ್ಲಿ ಕಲ್ ತಗೊಂಡು ಹೊಡೆದ್ರು.
They hail from same district, my lord. And continuously, my lord, after
ನಿಮ್ಮಿಬ್ಬರ ಮಧ್ಯೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಸರ್?
There is a issue
at page 25, my lord. I don't want to read that part. Page 25.
That part.
Please, my lord.
20?
Because subsequent to filing of this
20
in page 25, last 5 lines, my lord. These are only few things mentioned in these complaints. Sir, request you to kindly look into the matter along with all the attached documents and all. Also take necessary action.
In spite of so much being done,
please, my lord.
Only for friendship's sake, she always takes me for granted.
Yes, my lord.
And manipulates things on me.
Please, my lord.
It's stone on me ಅಂತ ಎಲ್ಲಿದೆ?
No, my lord. Harassment and mental tortures towards me. She is troubling me a lot with. It is proved. She herself filed an application, a suit before the trial court after filing of this complaint.
She is troubling me a lot.
She admits that yes, I
One
sent.
ನಿಮಿಷ ಸರ್, troubling me a lot with unwanted videos.
Yes.
ಏನು? ಅಲ್ಲಿ ನಿಮ್ಮಿಬ್ರದ್ದು ಏನು ಅಂತ ಗೊತ್ತಾಗ್ಲಿವಲ್ಲ?
But
You are in love,
Not in love, not in love. There were some
47, 48.
There were some transactions, my lord. Transactions to state that previously the complaint, the respondent number 2 was running a company by a fashion design company, my lord. Now, without bringing that to my notice, she took me as a partner without even changing the name of that company initially, and induced me to invest 10 lakhs rupees. Subsequent, and also the H series that is produced by the petitioner, my lord.
X series.
H series.
H series.
That is the bank statement, my lord, where the amount which is collected on behalf of the company, they were transferred to many other accounts to individual
ಈಗ
persons.
ನಿಮ್ದೇನ್ ಲಾಸ್ ಆಗಿದೆ ಹೇಳಿ ಸರ್?
Lost to the tune of 10 lakhs.
10 ಲಕ್ಷನಾ? ಅಷ್ಟೇ. ನೀವು ಎಷ್ಟು ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರಿ?
10 lakhs.
ಅದು ಕೊಟ್ಬಿಡಿ ಸರ್.
my lord, kindly look into their
ಹಂಗಾರೆ ಕಲ್ಲೆಲ್ಲ ಸುಮ್ನೆ ಸುಳ್ಳು.
It is, my lord, it's a matter of fact. It is, my lord.
Where is the own certificate?
Own certificate at page 88 and 89, my lord.
1 ನಿಮಿಷ.
46.
46.
88, my lord. Page number is 88.
ಎಷ್ಟು own certificate ಇದೆ?
Only one own certificate. The above injuries are many serious in nature.
One
Grievous in
ನಿಮಿಷ.
nature.
One ನಿಮಿಷ. Let me see sir. Page 88.
88, my lord.
ನೀವು 13ಕ್ಕೆ ಇವ್ರು ಹೊಡೆದ್ರ
Please, my lord.
ಒಂದ್ ವಾರ ಸುಧಾರಿಸ್ಕೊಂತ ಇದ್ರ.
My lord, I was searching for even sensitive parts of my lord. Any person being
7 ದಿನ ಬೇಕಾಗುತ್ತೆ.
it's a humiliating situation to take a treatment immediately, my lord. Saying that I am beaten by a lady, even on my.
ಏನಾಗುತ್ತೆ?
It's a humiliating situation for any.
Humiliating.
Please, my lord.
Why sir? Why women cannot beat?
They can, my lord, but in order to save, my lord, they happen to be family friends. The father also happened to be a family friend to the respond number 2. In order to mitigate the situation, he tried his best. My lord, after filing of this complaint, my lord, the petitioner files a suit for injunction, saying that on a particular day he trespassed my house.
ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಏನೇನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ? wound injuries 7 ದಿನ ಆದ್ಮೇಲೆ ಚೆಕ್ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ wounds.
No, wounds were detected, but I took the treatment after 7
You appeared before the doctor only on 20th.
Please, my lord.
13th ಆಗಿರೋದು ಇದು.
Please, my lord.
7 ದಿನ ಅಂದ್ರೆ ಹ್ಯೂಮಿಲೇಟ್ ಆಗ್ತೀರಾ ಅಂತ ಹೋಗ್ಲಿ.
I bear the pain.
Law does not recognize humiliations. ಡಿಲೇ ಅಂದ್ಮೇಲೆ ಡಿಲೇ.
That delay is
7 ದಿನ ಯಾಕೆ ಹೋಗ್ಲಿಲ್ಲ?
That delay is explained, and also the wound certificate category states that
wound certificate grievous ಅಂತ ಎಲ್ಲಿದೆ? ಸೀರಿಯಸ್ ಅಂತ ಇದ್ಯಾವುದು? ಸೀರಿಯಸ್ ಅಂತ ಇರೋದು ಗ್ರೀವಿಯಸ್ ಅನ್ಬೇಕು, ಸಿಂಪಲ್ ಅನ್ಬೇಕು. ಸೀರಿಯಸ್ ಯಾವುದು? ಕ್ರಿಟಿಕಲ್. ಓ a scar near right so and so
lower abdomen.
ಅಷ್ಟೇ ಇರೋದು. Contrusion over right lower abdomen.
Please, my lord.
Contrusion over right chest.
Even according to the petition, my lord, there are many disputed facts, my lord. Disputed facts can't be adjudicated under section 482, my lord. There are disputed facts.
That will
disputed facts with regard to the transaction. Disputed
recovery of money criminal law will not permit unless this wound certificate is correct.
The wound certificate is.
ಇದಕ್ಕೆ witness ಯಾರು ಇದಾರಾ?
Yes,
please, my lord.
Kindly see the page number 69. They stated incident occurred on, they projected as an eyewitness. They stated at about 6 p.m. Now wound certificate stated alleged incident 8:30 p.m. The page number 69.
13 ಯಾರ್ದಿದೆ ಸ್ಟೇಟ್ಮೆಂಟ್?
This is one of the Karthik, my lord. He is the passing of the road.
Passing of?
By that time seeing the occurrence.
Passer by.
The projecting as an eyewitness to the incident. Nowhere whisper.
ಅವರು ಪರಿಚಯ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಪಾಸರ್ ಬೈ ಹೆಂಗ್ ಆಗ್ತಾರೆ?
ಅವರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊತಾರೆ ಸ್ವಾಮಿ. The incident as
6 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಸೋಮಯ್ಯ ಅವರ ಬಳಿ ಬಂದು ಜೋರಾಗಿ ಗಲಾಟೆ ಮಾಡಿ ಪ್ರಾರಂಭಿಸಿ ಸೋಮಯ್ಯ ಅವರಿಗೆ ಸೋ ಹೊಟ್ಟೆ ಮತ್ತು ಎದೆ ಭಾಗಕ್ಕೆ ಬಿದ್ದು ಪೆಟ್ಟಾಗಿರುತ್ತೆ. ಜಗದೀಶ್ ಸರ್, ಇದು ಯಾರು ಸ್ವಲ್ಪ ಡಾಕ್ಟರ್ ಕೇಳಿ. ಮತ್ತೆ ಎಲ್ಲಿದೆ ಮತ್ತೆ ಎಲ್ಲ ಇದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡಿಸ್ಪ್ಯೂಟ್ಗೆ ಏನೇನೋ ಪ್ರೊಜೆಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ ಸರ್? ರಿಕವರಿ ಆಫ್ ಮನಿಗೆ ವಿಲ್ ನಾಟ್ ಪರ್ಮಿಟ್.
Initially I am 8 to.
It's not just a matter of recovery, my lord.
ಯಾರು ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿರೋದು? ನಿಮ್ ಕೇಸ್ ನೀವೇ ಹಾಳು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಇಲ್ಲಿ ನಾನ್ ಗ್ರೀವಿಯಸ್ ಅಂದ್ರೆ ಇಲ್ಲಿ ಗ್ರೀವಿಯಸ್ ಅಂತ ಬರ್ದು ಟೈಪ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ನೋಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೆ ನಾನು. wound is grievous in nature ಅಂತ. ಇಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ ಬರ್ದಿರೋದು ನಾನ್ ಗ್ರೀವಿಯಸ್ ಇನ್ ನೇಚರ್ ಅಂತ. ನಾನ್ ಬಿಟ್ಬಿಟ್ರಿ.
ಟೈಪಿಕಲ್ ಎರರ್.
ಮತ್ತೆ ಅದನ್ನೇ ನೋಡಿದ್ನ, ಅದನ್ನೇ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ ನಂಗೆ. ನಾನ್ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್. ಸೊ
420, my lord.
ಅದೇ ಎಲ್ಲ ಸುಳ್ಳೆ. 420.
Their own documents produced at series H. They speaks.
You have invested 10 lakhs. The partnership has gone wrong. For recovery of 10 lakhs in a partnership that has gone wrong, you have projected all these wounds. ಇದು ಯಾರ್ wound certificate? ಅದು simple in nature. Nothing. ಇದೆಲ್ಲ ಪ್ರಾಜೆಕ್ಟ್. 1 ವಾರ ಆದ್ಮೇಲೆ ಯಾಕೆ ತೋರಿಸಿದ್ರಿ? ನಿಮ್ಗೆ ಅಷ್ಟೊಂದು ನೋವು ಆಗಿದ್ರೆ ನಡೆಯಕ್ಕಾಗ್ಲಿಲ್ವಾ?
I was not accompanied by anyone, my lord.
Accompanied ನೀವೇ ನಡ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ ತಾನೆ?
On that particular day, yes. After a span of 7 days. I was grievously hurt, my lord.
ಎಲ್ಲಿದೆ? ಕಾಂಟ್ರೂಷನ್ ಮೇಲೆ ಕಾಂಟ್ರೂಷನ್ ಅಬ್ಡಮನ್.
Abdomen. Also 420, my lord, there is a clear case.
ಸೂಟ್ ಹಾಕಿದಾರ?
One
Suit
wire
not
shoot is
filed.
pending.
Suit is filed seeking temporary injunction not to interfere with the peaceful possession of the property of the petitioner.
Who is the plaintiff?
Plaintiff is the petitioner.
Against you?
Against me. And on that particular day, I was not at all in the country.
That's all right, no problem. ಯಾವಾಗ ಸೂಟ್ ಹಾಕಿದ್ದು?
Subsequent to filing of this complaint.
My lord, firstly, I issued a legal notice to the respondent number 2.
When?
On 8/2/2023.
Crime registered?
1/8/2023.
On 8/2. Reply ಮಾಡಿದ್ರ ಅದಕ್ಕೆ?
They not replied anything, my lord. After subsequent, they lodged a complaint against me. 1/8, all of the sudden. Then,
ನೀವು ಯಾಕೆ ರಾತ್ರಿ 8:30 ಅವ್ರ ಹತ್ರ ಹೋಗಿದ್ರಿ?
no, my lord, I am not go there anything, my lord.
Then how did you hit him?
But there is a misunderstanding between the petitioner and respondent number 2. For the moment, they filed the complaint against me. And I specifically stated in that legal notice, dissolution of the partnership firm and not to interfere the.
My lord, in that civil suit, she categorically admits that such a notice was never sent to me.
No, it is.
I can place before this court, my lord. It is an admitted fact.
It is marked
in all
the
these
OS
cases
case.
ಏನಾಗುತ್ತೆ? We can straight away dismiss it, saying wound ಇದೆ, ಇದಿದೆ ಅಂತ. But if you just go behind the smoke screen and see, the real intent of the complainant would come out. Why the complaint is registered? It is then exercise of jurisdiction under 408. ನಾವು ಏನೋ ನೋಡಲ್ಲ ಹಿಂಗ್ ಹಾಕ್ಬಿಡ್ತೀವಿ ಅಂದ್ರೆ ಎಲ್ಲ ಬರೀ ಕ್ರೈಮ್ ಟ್ರಯಲೇ ಆಗತ್ತೆ. A well doctored complaint. ನೀವು ಅಷ್ಟೊಂದು ನೋವಾಗಿದ್ರೆ ಅದು ಅಲ್ಲಿಗೆ ಹೊಡೆದ್ರು ಅಂತ ನೀವು ತಕ್ಷಣ ಓಡ್ಬೇಕಾಗಿತ್ತು ಡಾಕ್ಟರ್.
That was reasonably explained, my lord, stating that I was actually.
No, sir.
Even there is a
ಈಗ
case.
10 ಲಕ್ಷ ಬೇಕಷ್ಟೇನಾ?
My lord, not about 10 lakhs. I was actually attacked by this lady. It is not just about the investment that is made by me, my lord, or the investment that the petitioner has done.
Why did you hit him?
No, my lord, that is nothing happened that day, my lord.
When did it happen?
No, my lord. Anything happened, my lord.
Also in the petition, it is categorically stated, my lord, that the petitioner made an attempt to make a complaint against me, but also categorically makes an allegation against the police saying that the police didn't register the complaint. That being the thing, my lord, if something has happened, then definitely the petitioner had every remedy under 156 subsection 3.
We'll see. To hear them further next Tuesday,
Please.
next Wednesday. ಅಷ್ಟೇ, ನೀವು ಟೈಮ್ ಇಲ್ಲ ಬರೆಯಕ್ಕೆ, ಇಲ್ದಾರೆ ಅಷ್ಟೇ. ಅದೇ ಅವ್ರಿಗೂ ಗೊತ್ತು. 10 ಲಕ್ಷ ವಾಪಸ್ ಕೊಟ್ರಿ, ಇವೆಲ್ಲ ಏನು ನೋವು ಆಗಿಲ್ಲ, ಉಂಡು ಆಗಿಲ್ಲ.
There are eyewitnesses for that thing, my lord.
ನೋಡ್ ಇದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ.
And it is a continuous, there is not just a one crime that is registered. There was also subsequently another crime has been registered.
ಅದು ಮತ್ತೆ ಹೊಡೆದ್ರ?
ಇಲ್ಲ, no, my lord.
Not
They
on that
same
thing.
cause of action, they filed another one
Cause of
complaint
action,
before
my
the
lord.
jurisdiction.
On the thing that
Bangla court,
saying,
my lord.
taking the name of the
That
respondent
is
number.
B report filed by the.
ಒಂದ್ಸರಿ ಹೊಡೆದಿದ್ದು ದೇವ್ರ ತರ್ಕೊಳಕ್ ಆಗ್ತದೆ.
Same cause of action, they filed another complaint
Taking
before the Bangla
taking the name of respondent number 2, CH siphoned to an amount to the tune of 16 lakhs by taking money from so many persons.
ಅದಕ್ಕೆ 324 ತೆಗೆದು ಬಿಡ್ತೀನಿ.
Please, ma'am.
324 will quash.
I will explain 420 also, madam. Firstly,
I will explain 420.
He is not a partnership firm. He is not a partner of the.
That is proved by the forensic lab report, my lord.
That also.
324 and definitely I will quash.
That also.
There is nothing for 324.
Page number 59 is not.
Glorified complaint. ಎಲ್ಲ ಹೊಡೆದ್ಬಿಟ್ರು ಅಂತ. Yes. ಕಲ್ ತಗೊಂಡು ಇದು ಉಳಿತಾನೆ ಇರಲಿಲ್ಲ. ಅದು ಹೊಡೆದಿರಕ್ಕೆ ಸಾಧ್ಯವೇ ಇಲ್ಲ. ಅದು ಇವ್ರು ಎಷ್ಟಾರೋ ಹೊಡೆದಿದ್ರೆ ಅಷ್ಟೇ.
Entry model may be extended.
Subject to no touching stones. Yes. List the matter on next Wednesday. We'll post it next Wednesday.
39 Mallard side.
230 ದಿನ ಮೂಡ್ ಮಾಡಿದ್ಯಾ? Yes.
Lord, matter pertains to a PCPNDT Act, my lords.
ಏನದು? ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನೇ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ರದ?
Yes, my lord.
ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ವಾ ಇದು?
No, my lord. It's covered by the judgment, my lord.
Correct, but
Not even a single allegation of the sex selection, sex determination, female feticide.
I
my lord.
myself rendered a
Yes, my lord.
detailed
It's a
order.
reported
ಎಲ್ಲಿದೆ?
judgment.
ಎಲ್ಲಿದೆ?
I have produced.
Page. ಇಲ್ಲ ಇದು ನಾನೇ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಐ ಥಿಂಕ್ ಇಸ್ ಕ್ವೈಟ್ ಲೆಂದಿ. 1 minute. ಆಮೇಲೆ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕವರ್ಡ್ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದೆ. ಐ ಥಾಟ್ ಇಟ್ ವುಡ್ ಡಿಸ್ಪೋಸ್ಡ್.
Subbalakshmi N, my lord.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಬರೆದಿದ್ದೀನಿ ನೋಡ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಮಿಕ್ಕಿದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕ್ತೀನಿ. ಆರ್ಡರ್ಸ್ ಒಂದು ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. Two weeks time. Finally, 2 weeks time is granted to do the needful, failing which the petition would be dismissed for its non-prosecution. Vacating stay. ಅಲ್ಲ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ, ಅದ್ರಲ್ಲೇನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. ಸರ್ವ್ ಮಾಡಿಲ್ವಾ? Yes. The respondent is granted 2 weeks time to comply with the office objections qua the application seeking vacation of the interim order. List after 2 weeks. Date list on 25th. Interim order 25th. Interim order subsisting will continue till the next date of hearing. Yes. Same order, madam.
They have filed the objection, my lord.
Office objection ಏನೋ ಇದೆ ಅದರ ಮೇಲೆ.
ನಮ್ಮ objection ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Same 25th.
Dereliction of duty.
ಅಲ್ಲ ಇದು ಪರವಾಗಿಲ್ಲ, ಇದು 2 weeks ಬಿಟ್ಟು ಹಾಕಿ ಮೇಡಮ್, ಡೇಟ್ ಬೇಡ.
Dereliction of duty.
ಪರವಾಗಿಲ್ಲ ಸರ್. ಎಸ್, ಸುಮ್ಮನೆ ಇರೋ ಎಂಟ್ರಿ ಮಾಡಿ ಇಲ್ಲದೆ ಇರೋರನ್ನ ಫಸ್ಟ್ ತಗೊಂಡು ಕೊಡೋಣ ಅವ್ರಿಗೆ. ಇರೋರು ಸ್ವಲ್ಪ ಕೋಆಪರೇಟ್ ಮಾಡಿ ಒಂದು 3 ವಾರ ಬಿಟ್ಟು ತಗೊಂತೇನೆ, ಇಲ್ಲದೆ ಇರೋರು ಕವರ್ ಮಾಡ್ಬೋಣ ಎಲ್ಲ. ಪ್ರಮೋಷನ್ ಹಂಗಾರೆ 6 weeks ಬಿಟ್ಟು ಹಾಕಿ. ಎಸ್. 50 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮೇಂಟೈನಬಿಲಿಟಿ 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಆಯ್ತು. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ರಿ. The office of the Monday ಹಾಕಿ ಮೇಡಮ್, ಮಂಡೇ ಹಾಕಿ. ಎಸ್ 55.
54.
The objections 54 ಅಡ್ಜನ್ ಆದ್ಮೇಲೆ ಹೇಳ್ತಿರಲ್ಲ.
Hello, sorry.
ಏನ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಏನು?
Your Lordship, may kindly recall, I produced an order of His Lordship Justice Sheshananda, where he has held that the revision is not maintainable at the instance of the original complainant.
Oh, ಅದಕ್ಕೆ 482. Yes, Monday ಹಾಕಿರಿ ಮೇಡಮ್. Yes.
To the petitioner in this matter.
Non-compliance office objections.
So,
Look into the objection.
the copy is already served to us. May be listed in preliminary hearing, my lords.
Why, sir? No interim order?
The interim order may be
Yes,
extended.
the list after the office learned counsel submits office objections have been complied with, office to verify. List after 2 weeks. Yes, I will. Next.
Appear for respondent in this case, madam. I filed 2 applications. One is for the release the deposited amount by the petitioner. That is 19,500 rupees. Another application is for vacating stay. Is not complied with the orders of this honorable court.
I list this matter on 18th in admission. Yes. Next.
Appear for petition, my lord. The copy served on the trial court advocate on 8th January 2026.
Submits needful has been done, office to verify. IO. Next. Prasad sir, ಏನಿದು?
Split up charge sheet, my lord. He is in custody since 1 year, my lord.
List. List on Tuesday for admission.
15th
for Wednesday for admission.
15th daughter engagement ಇದೆ.
ಆಯ್ತು, ನಾಳೆ ಆಗುತ್ತೆ ಮೇಡಮ್. ನಾಳೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಕ್ಸ್ತೀನಿ.
Please.
ಸ್ಪ್ಲಿಟ್ ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ ತಾನೆ ಬೇರೆಯವರು?
Acquit.
ಎಸ್. ನಾಳೆ ಕ್ಲೋಸ್ ಮಾಡೋಣ.
Please.
60 withdrawal in terms of memo.
For the petitioners, my lords, we have filed an IA form asking the name of the petitioner in this.
Why?
My lords, he is an 18-year-old boy and he has been harassed in this name.
Offense.
My lords, it's under 35, my lords. 75-75-3, my lords. It was disposed by of my lords in the year 2024, my lords. So we want to mask them.
Allowed or dismissed?
Allowed, my lords.
Yes, I'm asking, madam. B group ಎಲ್ಲ will give date ಕರಿಬೇಡಿ ಮೇಡಮ್.
Serial number 70.
Models ಇದ್ರೆ continue ಆಗುತ್ತೆ. ಇದ್ರೆ continue ಆಗುತ್ತೆ. 2 weeks, yes.
May I make on submission, your lordship?
List 2 ಇದೆಯಾ? ಕರೀರಿ. Entry ಎಲ್ಲ entry ಮಾಡಿದ್ಯಾ?
Serial number 50. This is third time coming. It is not.
Maybe.
Stay out is not granted.
Entry ಮಾಡಿದ್ರೆ not there. ಒಂದು ನಿಮಿಷ. Which one?
50, serial number 50. EC Act.
ಒಂದು ನಿಮಿಷ.
50.
Entry matter is not granted.
No.
Monday fresh matter. Monday fresh matter. Entry matter ಯಾವ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ. ಯಾರು ಪ್ಲೀಸ್ VC.
ಆಫ್ ಮಾಡ್ಕೊಳ್ರಿ.
Listed to serial number 25, my lord.
ಇದಾನೆ.
List 2 ತೆಗಿ ಕರೀರಿ.
List 1, serial number 40.
I'll come back to the list 1. Wait. List after 2 weeks. Yes. Huh? Entry matter ಇದೆಯಾ? Notice ಆಗಿದೆಯಲ್ಲ? Yes. List after date ಕೊಡೋಣ. 25th. Yes. 26th. Yes. 3. 2 weeks. 2 weeks. ಇದೆಯಾ? 2 weeks. IO will continue. Yes. 2 weeks. In terms of the memo.
Appearing for respondent, my lord.
Memo for withdrawal. 8. Yes. Notice ಆಗಿದೆಯಲ್ಲ already. ಬರುತ್ತೆ. Yes. No. 25th. Yes. 26th. Entry matter ಇರೋದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Don't make a mention. Yes.
Serial number 9, there's no entry matter. I am for the petition.
Notice is already issued. So 26th. Yes.
Please.
Petition, Lord.
Entry matter ಇದೆಯಾ? Monday fresh matters. Yes.
Serial 11, entry matter ಇಲ್ಲ ಸುಮ್ಮನೆ. Fresh matter.
Monday Monday ಜಾಸ್ತಿ. Monday fresh matters. Yes.
Please. 12 minute notice ಆಗಿದೆ. Entry matter ಇಲ್ಲ. 22nd charge ಇದೆ ಸುಮ್ಮನೆ. Date ಕೊಡ್ತಾ ಇಲ್ಲ.
ಹಾಗಾದ್ರೆ list on 20th.
Please.
Monday fresh matters. Monday fresh matters. Yes. 14 notice ಆಗಿರೋದು. List on 26th. Yes. 26th. Yes. Stay application ಇಲ್ವಾ? List after 2 weeks. Next. 15. 23rd fresh matters. Yes. Monday fresh matters. Yes. 23rd.
Appearing for my lord, in serial number 17, I'm appearing for the petitioner, my lord. IA is pending notice not.
Yes. Next.
18.
Oblige.
Monday fresh
Husband
matters.
is not before the court.
Monday fresh matters. Yes. Monday fresh matters. Yes. 20.
Notice is issued, your lordship. This is, we are challenging the acceptance of the B report. There's no interim order in this.
Acceptance of the B report.
Yes.
That's all right. Yes, let it come. 26th. Yes. 26th. Yes. Next. 2 weeks to come. A week's time is granted to comply with the office objections. Interim order continues. Next. List of 2 weeks to do the needful. Next. Post immediately after service of notice upon the respondent.
Serve the notice. 23.
23.
23 have served the notice.
Post immediately after service of notice upon the respondent. Yes. Furnishing of 2 weeks time is granted to do the needful. Next.
My lord, the honorable court had granted called for a final report, my lord. The second time it is coming before your lordship.
Entry matter ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ವೆಕೇಶನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಫೈಲ್ ಆಗಿತ್ತು. 5ನೇ ತಾರೀಕು ಹಾಕೊಂಡು January 5th ಹಾಕೊಂಡಿದ್ರು. ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಸ್ಪೆಸಿಫಿಕ್ ಡೈರೆಕ್ಷನ್ ಇತ್ತು, ಓರಲ್ ಡೈರೆಕ್ಷನ್ ಇತ್ತು.
Monday fresh matters. ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ, ವೆಕೇಶನ್ ಬೆಂಚ್ ಫೈಲಿಂಗ್ ಆಗಿತ್ತು.
ವೆಕೇಶನ್ ಬೆಂಚ್ ಫೈಲಿಂಗ್.
January 5th ಗೆ ಒಂದು ಡೇಟ್ ಇತ್ತು ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ IO ರಿಪೋರ್ಟ್ ತಗೋಬೇಕಾಗಿತ್ತು. ಇದು ಇಟ್ ಡಿಡ್ಂಟ್ ಗೆಟ್ ಲಿಸ್ಟೆಡ್, my lord.
List on 26th. Yes.
My lord, entry matter, my lord, the second time it is coming before your lordship.
26th will grant. Yes. Post immediately after service of notice upon the
Date
respondent.
may be given, my lord. Date may be 26.
26. Post immediately of service of notice upon the respondent. Yes.
My lord, a date may be
2
given,
weeks
my lord.
IO. Next.
My lord, a date may be given for 20.
ಯಾವ್ದ್ರಲ್ಲಿ sir?
Sorry, my lord.
Which serial number?
27.
You are for whom?
Petitioner, my lord.
Entry matter is there.
Entry matter is there.
List after 6 weeks.
No,
Yes. Next.
Your Lordship, the difficulty in this matter is
Yes.
that
Don't be greedy. Entry model ಇಲ್ದೇ ಇರೋರಿಗೆ ಫಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಡೋಣ ಆಮೇಲೆ ಡಿಸ್ಪೋಸಲ್ ಕೇಳಿ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 6 weeks ಮಾಡಿ ಅದು
Milord, since you apply this, Milord.
Yes. Hmm.
Milord, 2 weeks.
28 recalling the order. ಯಾರು recalling ಹಾಕಿದ್ರು? List after 2 weeks, yes. Entry model continues. Big group ಎಲ್ಲ 2 weeks.
May request a date to be fixed in 29.
In which, sir? 29. Oh, sir. Yes, list after 2 weeks. ಏನು? List one.
My lords, cause list 2, serial number 5, my lords, we have filed IA for vacating of stay. A date may be given, my lords.
It will come, sir, yes.
28,
My lords, the court asked for.
List one. 39 ಆಗಿದೆಯಲ್ಲ 40 ಸತ್ಯಾನಂದ್ ಏನು
Petitioner.
ಹ್ಮ್
40 I am for the petitioner. This is the doctor's matter, my lord, where advocates
So
are
we'll have
involved and they
to
are
hear
roped
it
in.
on merits.
Aye.
Then we'll take it on 25th.
Interim order may continue.
That will continues, yes.
I'm for the petitioner in this case, my lord.
Petitioner was died.
Entry order ಇದೆಯಾ
Entry ಮಾಡಿದೆ petitioner ಇಲ್ಲ ಅದು
Petitioner was
ತೀರ್ಕೊಂಡಿದ್ದಾರೆ
died on
March
March 5th, my lord.
Agar abated.
Please, my lord. My lord, with respect to other accused,
ಅದು ಗೊತ್ತಿಲ್ಲ
investigation ಮಾಡೇ ಇಲ್ಲ.
ಅದು ಗೊತ್ತಿಲ್ಲ. The petitioner is set is no more. The learned counsel for the petitioner submits that respondent ನೀವು
Please, my lord.
respondent submits the petitioner is no more. Therefore, the proceedings stand abated qua the present petitioner accused number.
Accused number 1, please, my lord.
Accused number 1. The petition is thus disposed. The learned counsel submits that the respondents have not conducted investigation qua the other accused. The dismissal of with the dismissal of the petition as being abated, it is for the state to take the issue of investigation to its logical conclusion. Is qua the other accused. Yes, Swami.
May please, my lord, respondent.
Both the
Interim order ಇದೆಯಾ?
ಇದೆ.
2 weeks.
Like one request, my lord. Objections are ready. I think I've served a
ಮಾಡಿ
draft
ಮಾಡಿ
copy.
ತೊಂದರೆ ಇಲ್ಲ
Take
ಕೊಡಿ.
it back. Draft copy ಕೊಟ್ಟು.
Vacating stay ಇದೆ
Date ಹಾಕಿದ್ದಾರೆ.
ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ ಮಗ vacating stay ಇದ್ರೆ 25th ಅಲ್ಲ 25th yes.
My lords, cause list 2, serial number 5, my
Wait,
lords.
sir,
The court
VC,
has directed
please wait.
list after 2 weeks.
VC,
My lords,
please
there's an
wait.
Application for IA.
Lord's petitioner, my lords, the date may be fixed, my lord. Mod is granted.
Interim order is there.
Lord, my objections may be taken on record. I've served a copy to the other side.
I file it in the registry, sir.
Lord, the last order, you give last chance to file it today.
Oh, you file it in the registry, don't worry, yes.
That's a date may be fixed, my lords.
24, we'll take it, madam, yes.
Achha, achha.
Interim order extends next.
It's a abetment of suicide, my lordship.
Interim order ಇಲ್ವಾ?
ಇದೆ. Deceased itself, she has mentioned in the
ಮಾಡ್ರಿ
death
ಇದೆಯಲ್ಲ
note.
ಸರ್ ಒಂದು 2 ವಾರ ವೇಟ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಎಸ್ ಅದನ್ನ ಮೇಡಮ್ ಈಗೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿರೋ ಕೇಸ್ಗಳು 24th ಮಾತ್ರ ಪೋಸ್ಟ್ ದೆಮ್ ಆನ್ 4th March. We'll dispose it from that date. Yes, next. 45.
45 entry matter ಇಲ್ಲ ಇದು connected matter ಅಲ್ಲಿ entry matter ಇದೆ. Connected next week ಮಾಡೋಣ 18th 19th.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ 25 ಅದರಲ್ಲಿ ಇದೆಯಾ 24 ಅಲ್ಲಿ ಇದೆಯಾ?
ಅಲ್ಲ 45 ನಲ್ಲಿ.
ಆಯ್ತು 18th yes.
Macho.
In terms of the memo withdrawn. Next.
For the petitioner, my lords, date may be fixed, my lords.
47.
Please, my lords, respondent is not.
Entry order ಇದೆಯಾ?
Please, my lords.
ಅದೇ 4th March.
Please, my lords. Great.
Preliminary ಎಲ್ಲ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ 48 SC/ST atrocities act.
48 ಇದನ್ನ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ 4th March.
Please, entry model.
That will continue, sir. 4th March, yes.
My lords, 49 interim order subsist.
Continues, sir. Yes, sir. 50? Yes. ಮಿಕ್ಕಿದೆಲ್ಲ all 24 matters will be on 4th March.
My lords, one humble submission, my lords.
My lords, serial number 60
My lords,
withdrawal.
cause list 2, serial number 5, my lords. My lords, cause list 2, serial number 5.
On 21st, the date was given, but in the memo, it's listed as per seniority, my lords.
Pending matter.
No, my lords.
Fresh matter.
Split up case.
21st ಬರೋದು split up. ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಅವತ್ತೇ ಬರೋದು.
But it's listed as seniority, my lords.
No, 21st it will come definitely. Don't worry about it. 21st it will be listed.
But it's in the pending.
Hey, don't worry.
One humble request, my lords.
Split ಅಲ್ಲಿ 21st ಹಾಕಿ fresh matters.
My lords, one humble request, my lords.
60 ಏನು ಮೇಡಮ್?